Okay, all right. That'd be great. You can line them up in the seat order they were in originally. That would be great. Thank you. Sit down. Oh, you got to re-swear. Sorry. Thought you were standing for the jury. All right, folks, if you raise your right hands, we need to re-swear you. All right, have a seat. You're still missing seat 14. So this is seat 1 at this end. All right, folks, they're in the order of seats, starting to my right, going this way. The original, this is panel 1. All right, good morning, ladies and gentlemen. Welcome back to day 2 of jury selection. Let me explain to you what we're going to do this morning, and then I have some instructions and fact I need to talk to you all about. As a group, send you back into the jury room and bring you out one at a time to ask you questions, all right? So the first thing I have is an actual question, which is, have any of you received any information over the weekend, whether it be by the internet, media, coworkers, family, friends, anything concerning this case? You have? All right. You are the juror in seat number 22. Is that correct? Or juror 205? All right. Without telling me anything that you received, how did you get the information? Hold on. We're going to give you guys microphones because we can't hear you otherwise.
Some coworkers were talking about it in the break room.
Did you tell them that you couldn't talk about it?
Yes.
Did they stop?
They did.
Okay. Is there anything that they said that influenced you in any way?
Possibly, but I tried not to let it.
All right. We'll talk to you about that a little bit later in private. Okay. She's juror 205. She was in seat 22. She was in seat 22, panel 1. Her juror number is 205. Okay. I can't hear a word you are saying. You're going to have to use your original charts.
Is the court going to identify each juror?
Yes, when
record?
I'm talking to them, I am.
Okay.
Okay. All right. Anyone else who got any information at all? No? All right, thank you. Deputy, I'm sorry, but you're right in my line of sight of the jury. Thank you. All right. This is phase 2. As I explained to you, we're going to do this in 2 phases. I'm going to give you some preliminary instructions, and then I'm going to send you into the jury room. We're going to bring you out for individual instruction, all right? Some of what we're going to be talking to you about is anything you know about the case, your feelings about the death penalty, and your feelings about a defense that is being raised in this case, all right? There's a couple of things you need to remember throughout these proceedings. And this is the first one and the most important one you need to remember. Jurors must be able to presume that Mr. Loyd is not guilty. He's innocent of the charges until and if the state of Florida, these 2 gentlemen, can prove beyond a reasonable doubt that he is guilty of the charges. Mr. Loyd is charged by indictment. And let me tell you that an indictment is just a piece of paper, this is it right here, that tells someone what they're being charged with. You have to tell people what you're charging them with. This is how the state of Florida does it. You cannot use the fact that someone was indicted or charged with something as evidence that they're guilty of it. That's not how our system works. But he's been charged by indictment with first-degree murder with a firearm of a law enforcement officer attempted first-degree murder with a firearm of a law enforcement officer, aggravated assault with a deadly weapon, carjacking with a firearm, and possession of a firearm by a convicted felon. The first charge, the first-degree murder, if convicted, carries with it the potential for a death penalty sentence. All right? And I'll explain to you how that works. There are two phases to this trial if you're a juror. Phase one is what we call the guilt phase. And during that phase, your job is to determine, based solely on the evidence you hear in this courtroom, whether or not the state has proven beyond a reasonable doubt that Mr. Loyd is guilty of one or all of these charges or not guilty of one or all of them. That's your job in the first phase. What might happen if he's convicted is nothing for you to worry about. You have to focus solely on guilt in the first phase, all right? The guilt phase is pretty much conducted the same way we do all criminal cases. You'll be asked to return a verdict of guilty or not guilty on all counts. Your verdict must be unanimous on all counts, meaning that each juror must agree on each count either to acquit or convict. But as I previously said, only murder in the first degree qualifies for the death penalty. The burden of proof for the government is the same in the guilt phase of a capital case, which is a death penalty case, as it is for every other type of criminal case. It is proof beyond a reasonable doubt, and the instructions you will receive on reasonable doubt will be identical to the one given in all other criminal cases. The burden on the state is not higher because of the possible penalty. When you are deciding guilt in phase one of the case, you will be instructed to ignore the possible sentence during this phase. In other words, we ask jurors to decide whether a defendant is guilty or not on the charges, including murder one, on its own merit, and you will be told to disregard the possible consequences of your verdict. The only question you are to answer during the guilt phase is whether the defendant is guilty of murder in the first degree, as well as any other offenses charged, or guilty of a lesser included offense, or not guilty. And we expect you, of course, as a juror, to carefully consider the facts before you reach a decision. The fact that a defendant might face a death penalty is to play no part at that stage in the proceedings. If and only if the jury returns a verdict of murder in the first degree, the jury will reconvene for the purpose of rendering a verdict as to which sentence, death, or life imprisonment without the possibility of parole should be returned. If that happens, a special set of rules and instructions come into play. I'm going to give you an overview of it now. The actual instructions in both guilt and penalty phase are typewritten and given to you. They're very specific. I'm just giving you an overview right now, folks, all right? Because the death penalty in Florida is reserved for one class of crimes only, and that is murder in the first degree, the legislature has created special rules for juries to consider in reaching a verdict in the penalty phase. The legislature recognizes that not all first-degree murder cases deserve the death penalty, so they've created a list of circumstances which jurors are to consider in reaching a verdict in a death penalty case. Some of these the prosecution finds helpful, some of these the defendant finds helpful. The ones the prosecutor may rely upon are called aggravating factors. The state is required to prove these factors beyond and to the exclusion of a reasonable doubt, and they are limited by statute. The ones the defendant relies upon are called mitigating circumstances. Mitigating circumstances do not need to be proved beyond a reasonable doubt. A mitigating circumstance need only be proven by the greater weight of the evidence. Mitigating circumstances are not limited by statute and may include matters relevant to the defendant's background or character or circumstances surrounding the offense, and they will be offered as a basis for a verdict of a sentence of life in prison without the possibility of parole. Before you may vote, the court impose a sentence of death, the state must prove beyond a reasonable doubt one or more of the aggravating factors that they have alleged. The process of considering the aggravating factors and mitigating circumstances to determine the proper punishment is not a mechanical or mathematical process. The law contemplates that different factors may be given different weight or values by different jurors. In your decision-making process, you and you alone are to decide what weight is to be given to a particular factor. Regardless of your findings in this respect, however, you are never compelled nor required to vote for a sentence of death. The final step in this phase of the trial is for each of you to determine whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. The court may not impose a sentence of death unless each juror individually finds the defendant should be sentenced to death. It has to be a unanimous verdict from the jury. Even when death is a possible sentence, each juror must independently decide whether life imprisonment without the possibility of parole or death should be imposed. Regardless of your prior findings, the law never compels nor requires any juror to determine the defendant should be sentenced to death. Any single juror has the right to vote for a sentence of life imprisonment without the possibility of parole. If, after deliberating, the jury unanimously agrees that the appropriate sentence is death, then your verdict may be for a sentence of death. If the jury does not unanimously agree that the appropriate sentence is death, then your verdict must be for a sentence of life imprisonment without the possibility for parole. Again, this is just a broad outline of how this works. Detailed instructions are given at every step of the case. Let me say this too. Right? Let me caution you that the fact that I'm talking about the death penalty is not to be taken by you as any indication one way or another as to whether or not this is a case which justifies the death penalty. I don't know that, and you don't know that. I'm only discussing it because it's a possibility. It doesn't presuppose anything. We just have to be ready in case it happens for you to understand how you have to proceed here. We're going to be asking you some questions about this procedure. We're going to be asking you some questions about all the things we talked about, and the lawyers are going to do that in some detail. Some questions are going to be on the death penalty. I want to prepare you so you can be thinking about it. In general, they're typical questions. They may or may not come your way, but I expect they probably will. You're going to be asked whether you have any moral, religious, or personal feelings about sitting in judgment of a defendant's conduct in this case. We will ask about your feelings about the death penalty, and if you're in favor of the death penalty, whether or not you agree with the premise that a sentence of death is not appropriate for all first-degree murder cases. You may be asked whether you would agree to weigh the aggravating factors and mitigating circumstances with an open mind and determine whether death or life imprisonment without the possibility of parole would be an appropriate sentence. You may be asked whether you are opposed to the death penalty such that you would not consider it a penalty under any circumstances. Many people have strong feelings about the death penalty, both for and against it. The fact that you may have such feelings does not disqualify you to serve as a juror, as long as you can put those feelings aside and apply the law as I instruct you. In other words, you must be willing to be bound by your oath as a juror to obey the laws of this state in delivering your verdict. Questions may be asked about whether your opinion concerning the death penalty would substantially impair your ability to follow the court's instructions. You're also going to be asked questions about a defense known as the insanity defense. Mr. Loyd has raised a defense of not guilty by reason of insanity. I'll talk to you about that in a little bit more detail individually, but that's something that you have to be able to keep an open mind as to everything that's being presented to you in a courtroom, including any defense that a defendant may raise, such as not guilty by reason of insanity. I'm going to read to you a short statement about this case. Folks, this is just a short statement. It is not evidence, all right? On the morning of January 9th, 2017, defendant Markeith Loyd is alleged to have entered the Walmart store at 3101 West Princeton Street. Mr. Loyd had an active warrant for his arrest. Orlando Police Lieutenant Debra Clayton attempted to take Mr. Loyd into custody on the information she received regarding Mr. Loyd's involvement in the Dixon homicide when it is alleged Mr. Loyd shot and killed Lieutenant Clayton following an exchange of gunfire before fleeing the Walmart and eventually being apprehended about a week later. Mr. Loyd's trial for the killing of Sade Dixon and her unborn child began on September 27, 2019, and concluded on October 23, 2019. Mr. Loyd was convicted and sentenced to life without the possibility of parole. Based solely, number one, on the facts that I just read to you, or the statement I just read to you, and anything that you may personally know without telling me anything other than, without just raising your hand, how many of you have heard about this case? All right, so I have the juror in seat number 2. You're juror 339, is that correct? All right. Who else? Raise your hand. So juror in seat number 3, you're juror 204? Okay. 3, 4, 5. So you're going to be juror seat, you're 32? You're number what? 20? Okay. Who else heard about it? Okay, the last two. Ma'am, what's your juror number? 283? 293. And your juror 205. Okay. Of the ones that just raised your hand, have any of you formed an opinion? Again, all I want to know is just raise your hand. Have any of you formed an opinion based on what you've heard already as to Mr. Loyd's guilt or innocence? Juror in seat 2, juror number 205. Anybody else? All right. Okay, I'm going to send you back into the jury room except for you, juror in seat 205. Why don't you stay here with us, and or juror number 205. We're going to talk to you about what's going on today. Yes. The rest of you go into the jury room. Do not talk about this case among yourselves. We need to give her a microphone, please. Okay, thank you. Guys, they sent the signature, I thought, but never mind, we'll work on it. We'll figure it out, yeah. All right, ma'am. For the record, your juror number is 205. You were in seat 1. I'm sorry, you were in the first panel in seat 22.
Correct.
Okay. Tell me what you think you know about this case.
Well, I just know kind of the general overview of the alleged shooting of a police officer, but that's about it. I don't know like a lot of the details, but I do what my coworkers were talking about, and I asked them to stop.
All right, tell me what they were talking about.
Well, they were just talking about how, this trial was about to happen, and their beliefs on the case, like how if like a police officer is involved, that it's, it's really serious. And I mean, any murder is serious, but like specifically with a police officer. And they were also saying what they thought, that he like was allegedly
Right,
like
so
guilty.
based on all of that, you said you formed an opinion about guilt or innocence?
About what? Sorry.
Whether he's guilty or innocent?
Yes, I would say it is hard for me to keep an open mind. So I would say that I would lean more towards guilty.
So at this point, you're leaning towards guilty?
Yes, ma'am.
During the trial, if you were placed on the jury and the witnesses were being called, would you be sitting there thinking that Mr. Loyd has to convince you that he's not guilty?
Has convinced me that he's not guilty?
Yeah.
I mean, possibly. I'm not really sure.
You're not sure? Okay.
Yes, ma'am.
Thank you, ma'am. State, any questions on that issue?
No, Your Honor.
Defense, any questions on that issue? May I excuse this juror?
You may. No
All right.
objection.
Ma'am, thank you very much. The court appreciates your service. You are free to go. You're excused as a juror. You're going out that door. Go down to the jury room. They're going to give you the letters that you need for your employers or school or whatever. All right, thank you. Let's bring in the juror who was in juror number 207. He was in seat number 1, panel 1. No, I'm sorry, not him. Sorry. Bring in juror 339. You know what? Yeah, he was in seat number 3. Bring me 339 in seat number 3. I need to wake up. All right, sir, have a seat. Just in the middle there so everybody can see you. I know that's not anyone's fondest wish, but just, you can have a seat. All right, you're juror number 339, and your original seat number was 3, is that correct?
Yes.
All right. All right, sir, you indicated you'd heard something about this case. Can you tell me what it is you heard?
I just remember seeing it on the news when it was happening.
When you say on the news, on television,
Yeah.
internet, where do you?
On the television, yeah.
All right. How much of it did you see on the news?
Not very much.
You see 1 or 2 stories, 15
Just-
stories? What did you see?
Like one story maybe. When we were here last time, I didn't really know who he was until I remembered what I saw on the news. That was pretty much it.
Okay. So prior to hearing it on the news, had you ever heard of the case?
No.
No. All right. Did you form an opinion? Well, tell me what you heard. Let's start with that.
Basically everything that you had recited. I'd heard that part on the news, but I didn't know about the first trial or anything.
Okay. Since that time, have you heard any? And that was the morning that you were coming to jury
Yes.
selection? All right. And since that time, have you heard anything else about the case?
No.
Or read anything?
No.
Anybody tried to talk to you?
No.
Did you form an opinion about whether Mr. Loyd is guilty or not? Remember, this case is solely about Lieutenant Clayton. Have you formed any kind of an opinion about that case?
No.
As I told you, jurors have to approach this with an open mind. You have to presume he's innocent. That's the law. You have to start the trial saying, this guy's innocent until and if the state can prove to me he's guilty. Do you believe you can do that?
Yes.
Can you set aside anything you may have heard on the news?
Yes.
All right. Tell me about your thoughts on the death penalty, please.
I think it's circumstantial, depending on the crime.
Okay. Are you opposed to the death penalty, in favor of the death penalty, anything like that?
Neutral. Yeah.
Neutral? All right. If Mr. Loyd was found guilty of first-degree murder and the jury was asked to determine life or death, or vote life or death, life in Florida is without the possibility of parole, meaning you die in prison. Right? The death penalty, the state has to prove 1 or more aggravators beyond a reasonable doubt. Defense gets to put on mitigation. Mitigation is reasons they believe life is the appropriate sentence. The aggravators are reasons the state believes death is the appropriate sentence. You then go back in the jury room with your fellow jurors, and although you all discuss this as a group, and you go through the aggravators, the mitigators, you go through your process of determining whether or not you believe life or death is the appropriate sentence, it's an individual decision. To impose death, it has to be, for the court to be able to impose death, it has to be 12-0. It has to be unanimous. But even one juror can say life without the possibility of parole, and then it's a life sentence. You understand that? Do you think you could go through that process with an open mind? Do you think you could listen to, even though you had convicted Mr. Loyd, do you think you could listen to both the state and the defense and treat the sentencing separate from your verdict and the guilt and just determine what sentence you believe would be the appropriate one? Is there anything that's causing you any hesitation about that? All right. In this case, Mr. Loyd has raised the defense of insanity. There's a specific jury instruction on this, but in essence, it has to be, the defense has to raise it, prove it by clear and convincing evidence that either Mr. Loyd did not know the consequences of what he was doing at that time, or that he knew what he was doing, but he didn't know it was wrong. That's a very short version of the rule for insanity. There's a specific jury instruction. Like everything else, you have to be able, as a juror, to sit there and listen. You can't start the trial out going, yeah, I'm not buying that. You have to listen to everything that's presented and then make a decision one way or another about that. Do you think you could do that?
Yes.
Is there anything about the defense of insanity that makes you uncomfortable, that makes you think, I'm not going to be able to do this?
No.
All right. Thank you very much, sir. State, you may inquire.
Good morning.
Good morning.
So tell me, if you wouldn't mind, what it is that you're thinking as the judge is explaining to you that this is a case where the death penalty might be an option. So in other words, I heard you say that you're neutral on the idea of the death penalty, but I'm asking about your thoughts on participating in a very real way in that process. Could you tell me what you're thinking?
It is a little bit.
A little what? I'm sorry?
It's a little bit daunting.
Right.
But if it's something that I have to do, I'll do it.
Okay. Have you ever served on a jury before?
No.
So from nothing all the way to the very top end at the
Yes.
beginning. Okay. Have you ever had an opportunity to think about the death penalty or have a conversation with anybody close to you? It's kind of one of those you have. Okay.
Yeah.
Can you tell me about that conversation or what your thoughts were on it?
Like I told the judge, I think it's circumstantial based on the crime.
So I take that to mean that you can imagine some scenarios where the death penalty, in your view, might be appropriate.
Yes.
Could you tell me one of those scenarios? In other words, were you talking about a case with somebody, a specific case with somebody, or have you thought, you know, if this crime were committed, that person deserves to die? Has there been a thought like that?
Yeah.
Can you tell me about that, please?
I think discussing like serial killers and things like that.
Right, serial killers, okay. Any other ones that you can think of?
No.
So I'll give you another example that has nothing to do with this case. You heard the judge talk about aggravating factors, right? And we have to prove at least one aggravating factor beyond a reasonable doubt. You heard that?
Yes.
So one of the aggravating factors, the victim was a child under the age of 12. Some people say that if a child is involved and it's the murder of a child, then the death penalty should be automatic. Are there any situations factually that for you think the death penalty should be an automatic punishment, or in your mind, that's just always going to be the appropriate punishment?
No, I think I would need to learn everything first.
Okay. So no matter what, you'd want to make a specific determination.
Yeah.
Is that fair? Now, you've obviously heard on multiple occasions already this morning that it is alleged that a law enforcement officer was killed. Does the involvement of a law enforcement officer specifically make you lean towards the death penalty or away from it in any way?
No.
Okay. Fair enough. The judge gave you an overview of the process, and that overview took 6 minutes to describe. It's a lengthy process if we get to that point, because remember, the death penalty is only appropriate if the defendant is convicted of first degree. Anything about what was described to you that you think would make it difficult for you to participate in this process?
No.
Obviously, you said that you recognize the weight of it, right? So my last question on this topic, because we've had sort of a hypothetical conversation now. But let's say you're selected as a member of the jury, and that you go through the process and that you find with your other 11 jurors that at least one aggravator has been proven beyond a reasonable doubt. And that after listening to any mitigation that is presented, that you believe the aggravating factors outweigh the mitigating circumstances, and that you personally believe that under the law, death is the appropriate sentence. You with me?
Yes.
Could you, not in a hypothetical sense, but if that were the circumstance for you, raise your hand in the jury room and say, yes, I vote to impose a sentence, or that a sentence of death should be imposed upon a defendant, another human being?
Come on up here. All right. You may answer the question, sir. If you don't remember it, the state will repeat it for you.
Could you just briefly say it again?
Sure. What I was asking is, if you find under the law, as the judge describes it to you, and the facts that are presented, that you believe that the death penalty is appropriate, could you raise your hand and vote to impose a sentence of death on another human being if that's what you found to be the appropriate sentence?
If that's what I believe was presented as evidence and everything, yes, I
Right.
could
Okay.
leave my feelings out.
Conversely,
I would leave my feelings out.
Conversely, if you believed that an aggravator wasn't proven beyond a reasonable doubt, or that based upon what you heard, that death was not appropriate, could you also stand up and say, death is not appropriate, I do not agree, and vote for life in prison without the possibility of parole?
Yes.
Okay, thank you, sir. So I have a couple of questions about the concept of insanity, all right, and then I'm going to be finished. And because of the nature of that defense, I'm going to ask what may be perceived as some more personal questions, so forgive me. Have you personally or anyone close to you dealt with what I'm going to call significant mental illness in any way? Something that impacted a person's daily life?
Yes.
Okay, can you tell me who that person, not like their names, but who they are to you, and sort of describe the nature of what you heard or what you've dealt with?
Myself personally,
Okay.
I had a diagnosed panic disorder where I would have like anxiety attacks for hours on end, and it impacted my daily life until I had therapy and everything.
Okay, so you've gone to get medical.
what? Is it showing up on your, sir, can you try and, I know those masks are really hard. Can you try and, it may
Better?
be better if you hold the mic lower.
No, that's not better.
That's not going to work either. Just try and speak up. Thanks.
So you were explaining to me, I think, that you've actually sought treatment successfully for your illness. Okay. So I would think that you recognize that mental illness is a real thing. You can appreciate why I'm asking that, because there are some people who don't see it that way. You agree? Okay. Any friends or loved ones deal with that issue? Did I hear you say, have you been prescribed medication for that, or? Okay. Anything about that medication make you groggy or tired or forgetful in any way? Okay. And how long have you been dealing with this issue, sir? Okay. And obviously you work and have managed to go about your day, right? Okay. Do you think anything about your personal experience with that topic would make it difficult for you to be fair and impartial, and more specifically, fair and impartially weigh the allegation or claim that a person has a mental illness?
No.
Do you think it would give you any special insight on that topic?
In this circumstance,
Probably not. Obviously, it's very different than what you dealt with. Do you believe that even assuming that a person has a mental illness, that it automatically absolves them of any conduct that they engage in?
No.
It sounds like to me, and if I'm wrong, correct me, that it's sort of for you is like the death penalty issue, it depends on the circumstances?
Yes.
Okay, fair enough. So, one general question before I sit down. Is there anything, as one of the lawyers trying this case, that you think, life, background, or experience, that we should know about you, given that we're trying to find the most fair and impartial jury we can in this situation? So let me give you an example, okay? You had a loved one convicted of murder, or you had a loved one who was the victim of a serious crime and that impacted you. Anything like that that comes to your mind, and if there is something, it will come to your mind, that you think we should know about in your past or background?
No.
Okay. If selected, I'm assuming you're willing to serve, even though that this is in a difficult and unique circumstance?
Yes, I am.
Okay. All right. Thank you, Your Honor.
Thank you, Mr. Rowley.
Thank you, sir.
Mr. Lemon, you may start.
How are you doing today, sir? So, do you think the fact that you had mental health treatment in your life is going to make you more of a skeptic than someone who has an open mind?
No.
Yeah. How long have you been receiving treatment?
Probably 3 years total.
Okay. And during that time, you talked openly with your close friends and family about it?
Yes.
So you don't try to keep it to yourself? Okay. Now, the issue involving insanity involves a number of different things that have to be proven. There has to be a mental illness or defect, and there's another standard, the second standard. But one of the things the judge is going to read you is that it is the judge who decides if a person is found not guilty by reason of insanity, where to send that person. Okay? In this particular case, Mr. Loyd has been sentenced to life in prison already. He's never getting out of prison. Would that make it easier for you to find him not guilty by reason of insanity? Okay. All the things that Mr. Williams talked to you, now that you know that my client is a convicted felon who's serving life, how does that play into your thought process and internal prejudice, things like that?
Like the judge said, it has nothing to do with this case, so I wouldn't think about it.
Okay. So you're able to put it aside?
Yes.
Now, you had said you only watched one news story. Is that right?
Yes.
Do you watch the news?
Not really, no.
So you're not a news person? Don't read the paper? Don't follow it? Do you remember where you were when you actually remember hearing about this? How long ago it was? Okay, so you haven't heard anything since? Okay. Now, you had said that in a situation where a person is convicted of first-degree murder, it's premeditated, there's no question, there's no defense, that you would never vote automatically for death. Why?
Can you speak up a little bit, sir?
Sorry. I just think it would be a bias if I formed an opinion without hearing any evidence.
Okay. Now, there's going to be a set of rules that we're going to talk about in a little bit. But before I get to those rules, in regards to death penalty, on a scale, one being not against the death penalty on any situation, and 7, always voting for the death penalty, where would you find yourself?
So like I had said before, probably
Now, when you say 3 or 4, would you lean more towards 3 or more towards 4? Okay. But the impartiality issue is really, the question is not about impartiality, it's about how you feel about the death penalty. So I think you told a little bit to the prosecutor about how you feel about the death penalty, but I'm not really following what your internal feelings are about the death penalty.
okay. I honestly believe that, like I said, it depends on the case. I am for it if I find that the evidence and everything supports it. I am against it if I find the thing is.
So you're really talking kind of in general terms.
Okay.
And what I'm really interested in,
I don't know, honestly.
is there something that drives you to that decision?
No, I
Okay.
give a feeling on something that I don't know yet, if that makes sense.
Sure. So I'm going to ask you some questions about that and get to know you a little better. Do you think that life without the possibility of parole is a sentence that you would be able to consider? Is there anything about that bothers you? Like the taxpayers are going to pay more money versus the death penalty, anything like that? Okay. Now, in this case, like all death penalty cases, the ultimate decision you make is an individual decision. You understand that?
Yes.
This is completely up to you. And although you can talk about it with other jurors, if we get to that part of the case, it's your decision. Now, sometimes in that situation, there's someone who ends up being kind of bullyish in the jury room because they have one opinion or another. Strong death, strong life. Would you be able to put those opinions aside and not be influenced by them?
Yes.
Why do you think you
Because my opinion is my own.
do that? Would you verbally be able to tell that person in front of the other jurors, listen, this is an individual decision. We all heard it in the court. You're going to leave me alone.
Yes.
What about if they're going after another juror, whatever their position is? Would you be able to stand up for them?
Yes.
Yeah. Now, some people feel that the killing of a police officer all the time.
And
Okay? And when we're talking about kind of the rules that play out in the case, if we get there, you heard the prosecutor talk about aggravating circumstances. There are a limited number of those. They have to be out. Once one is out, and you move to consider the mitigation and weighing that mitigation, as the judge talked about. It's a different standard, lower standard than what the aggravators are. And then you have to weigh the mitigators against the aggravators. Now, some people don't like and can't accept some types of mitigation. Now, I think it'd be a little foolish to ask you about mental health, because you clearly would consider mental health. That wouldn't be a problem, right? What about someone who has dealt with racism their entire life? Would that be something you're able to consider?
Objection.
Let me see the attorneys at the bench. And I have one right here. You may proceed. Mr. Lenneman, I can't hear you. Do you have your mic on?
I think we were talking about generally your ability to consider things as a mitigating factor. And generally, would you be able to consider racism as a mitigating factor?
yes, I would.
Okay. What about something like brain damage?
Yes.
Okay. Would you be able to consider generally trauma the person suffers?
Yes.
Now, we were talking about this individual decision-making of yours in this part of the case. And the judge had talked about, if we're coming down the line, where there's a checklist where you go from, the aggravator being proved beyond a reasonable doubt, mitigation being proven, you weighing the aggravating factors versus the mitigating factors. The legislator has clearly empowered our community that even if you feel that the aggravators outweigh the mitigators, you never have to vote for death. Do you understand that?
Yes.
No matter what anybody tells you. It's your decision. Some people call that mercy, some people call that whatever. It's whatever you believe it is, but you have the entitlement. You understand that?
Yes.
Now, the legislator also wanted to, when they created the statute, they wanted to offer to the jury and to the community the importance of an individual. And it's called victim impact. That's exactly what it's called, victim impact testimony. So people will come into a trial and they will testify about the relationships and that person and what that person brought back to the community. Now, a lot of times it's very powerful evidence, very emotional evidence. But the legislator understood and knew that you could not use that as an aggravating factor. You can't use it in any way to consider death. But you can consider it as a human being. Would you be able to do that?
Yes.
If I can have one moment, Judge? Now, you were talking throughout both your communication with Williams that you wanted to hear the evidence. I think the judge went through, but I just want to make sure we're on the same page. You understand technically a defendant never has to put on any evidence. It's the burden of the state to prove the case beyond a reasonable doubt.
Yes.
Okay? Insanity is different. Insanity means that the defense would have a burden they have to prove in order to prevail on that. Okay?
Yes.
You understand that?
Yes.
All right. Sir, do you understand that the death penalty will only come in play, as the judge said, if there's a conviction for first-degree murder?
Yes.
Okay. Thank you.
All right, thanks, sir. I don't believe we have any other questions for you. Hold on one second. Anything from state?
No, Your Honor.
Defense?
No.
All right, sir, first of all, let me tell you, you're free to go to the Blue Ridge vacation that you have planned for the 14th to the 18th.
Okay.
Trial's not going to start before that.
Okay.
We're going to give you the coveted purple dot, Teresa. we're going to be giving you the coveted purple dot, which means you're going into the final stage of jury selection.
Okay.
I don't know what day that's going to occur because we have to get a certain number of people through to that stage. So, do you have the slip that tells him what number to call? I'm so ticked off. All right. I've got a jury sequestration package for you. There's some differences when you come back.
Okay.
right? This packet explains to you what it's like being a sequestered juror. But you're going to need to pack tonight before you come here and bring your suitcases to the courthouse. Leave them in your car. If you're picked for the jury, the deputies will escort you to the car and get your belongings and all that. But
Okay.
you have to arrive at the courthouse already packed in case you're picked, because we sequester the jury as soon as they're sworn in.
Okay.
All right? That packet provides quite a bit of information for you about that. We are trying to get for you, and I apologize, there's a delay from the jury room. There's still a slip of paper we're going to give you that has a phone number on it that you call. You're going to need to, don't call it before Friday.
Okay.
Or actually, don't call it before Thursday, all right? And it's going to tell you when to report back for general jury selection. You may hear purple dots, we have no information for you, meaning we still don't have a date.
Okay.
Just keep calling until we give you a date to report back. You would report back to the jury room that morning, and then they'll, pull everybody and bring them upstairs. If you can just have a seat outside the courtroom and wait for a few minutes till we get the rest of this paperwork. They tell me it's on the way up. My apologies.
Okay.
All right? Do you have any questions about what you're doing?
No.
All right. Thank you very much, sir.
Thank you.
And once again, you can keep the mask. If you get enough of them, they can be stocking stuffers. All right, let's bring in juror number 204, who was in panel 1, seat 4. Good morning, sir.
Good morning.
All right. You're juror 204, is that correct?
Correct.
And you were in seat 4 originally in the
Correct.
first panel? Okay. All right. Got a few questions for you. Let me start with, you said you'd heard something about this case. How much have you heard?
I mean, pretty much what you explained earlier, I already knew.
Okay. When you say pretty much I already knew, what did you know? Tell me before you walked into this courtroom, if I said to you, describe this case to me, what would you say?
I would say that it's about a person who who killed a police officer. I knew that. I knew that they apprehended him and there was some scuffle and he lost his eye. I knew that. I knew that there was that I had some feelings about this case because.
What are your feelings about this case?
Well, I mean, I just feel that being that I feel as law enforcement might have roughed them up more than they could have, and being that a police officer was slain, I could understand where that would come from, but that doesn't mean that it's right.
Okay. The fact that Mr. Loyd got roughed up and lost his eye is not relevant and isn't anything that you can consider in this case. Do you think you could follow that instruction?
Yes, ma'am.
You sound reluctant.
I mean,
Look, I'm not looking for one answer or another. We really need you to tell us how you feel and what you can and can't do. Sometimes people can't sit on a certain case. That's fine.
Yeah, I mean, personally, my feelings, for me, I think, I don't know if, how I would feel, knowing that I would indirectly be responsible or could be responsible for this man's demise or him sitting in prison for the rest of his life.
Okay. Let me back up a little bit more, which is, I'm going to get to that in just a second. Based on everything you've heard about the case, do you have any, are you leaning one way or the other, guilty, not guilty, starting the case?
No. My feelings towards the death penalty have nothing to do with him being guilty of his crime.
Okay. Jurors are required to presume he's innocent of the crime until and if the state can prove he's guilty.
Correct.
If we sat you in the jury box, would you start with that, saying, okay, state, prove he's guilty?
Yeah.
Okay. Is there any part of you that thinks that Mr. Loyd is guilty of anything?
No. No. I can't be influenced by what I've heard. Every case has to go to trial, or everybody got their day. So
Okay.
you have to go over the evidence and all that. I understand that, so I don't.
All right, so let's talk to you about your feelings about the death penalty. In order to sit as a juror in these types of cases, as I said repeatedly, no juror is required to vote for death. But if Mr. Loyd was convicted of first-degree murder, you're required to have an open mind, and if the law and your deliberations and you're listening to the mitigators and the aggravators, you listen to all of that, and at the end you say to yourself, the appropriate sentence here is death, you have to be able to vote for death. Can you do that?
I don't think so.
You don't think so?
I'm not gonna.
Okay,
I don't
that's
think
fine.
So.
That's fine. Again, I'm not looking for one answer or another. I'm looking for the truth. And whether or not, this may not be the case for you, whether or not you can do your job. So you have doubts that you could vote for death even if you thought
Even
that
yeah.
that's what should be the sentence.
Yes, due to my personal feelings, yes.
Okay. And how long have you had those personal beliefs?
I guess ever since I was a teenager and I knew about the death penalty, I started getting in trouble. I had a trouble pass.
Okay.
So ever since then, I pay attention to a lot of things in the news, not just the news, but in life and how things and how people are treated, how certain, I don't know, I kind of look at everything, so.
All right. Thank you, sir. State, you have any?
No questions from the stage, Judge.
Defense?
How you doing, sir?
I'm doing all right. How you doing?
So do you think that we should live in a society where a person is excluded from the complete group of peers that he deserves in the criminal justice case?
Objection, relevance.
Sustain.
I don't.
No, sir, you can't answer the question. Sorry. Go ahead.
So here's the situation. I understand what your feelings are. I understand where they come from. But do you think that you can set those feelings aside and consider, you don't have to do anything else but consider the possibility of the death penalty in any given case.
Yes.
The possibility of
You
death.
have to be able to consider it. The law says if you can't consider it, you can't be a part of this group. So you'd have to be able to consider it. And you set aside your own personal feelings and consider it as a possible sentence in this case.
No.
Okay, thank you, sir.
Mr. Lyman, any objections?
No.
All right, thank you. So the court thanks you for your candor and for your service. You're excused as a juror in this case, and you're free to go. You can keep the mask. All right, thanks. It's the juror in original seat number 4, panel 1. Give me the juror number 20, panel 1, seat 8. I'm sorry? Number 4 just got excused for cause. Oh, number 5, yeah, I haven't gotten to that one yet. I'm not going in order. All right. Good morning. You're juror number 20, correct?
Yes.
And you were in seat number 8 in the original
Yeah.
jury panel? Okay. All right, sir. You heard all the instructions I gave you. But
Okay.
you also indicated that you have heard something about this case?
Yeah, not much information. I like you mentioned in your statement, it was the year that it happened, that it involved a police officer, and the name of the person committing the crime. But
Right.
that's it. That's all the information I know about.
When did you hear that?
Probably like last week sometime when I
Last
was
week?
Yeah, I was on Facebook. I was just scrolling through, and since I follow Fox 35, that was like one of the articles that popped up, but I didn't read it. It just kind of, that's what popped up as like the title. And
Okay. Were you here in 2017, here in Orlando?
yes.
Okay. Did you hear anything then?
No.
So between
Not that I recall.
then and last week, right before you got called in for this case, the first time you heard or read anything was on Facebook.
Yeah.
Did you ever hear anybody talking about the case?
No.
So aside from what you just told me, do you believe you know anything else about this case? Other than what I told you,
I mean, you told me more information than I knew.
what I told you this morning.
Yeah,
right?
and I don't watch the news. So that kind of limits my,
No need to apologize? All right.
yeah.
I do want to emphasize to you that we're not looking for particular answers this morning. We just need you to tell us the truth.
Okay.
How you actually feel about things. All right. Well, so based on what you've heard, have you formed any opinion about whether or not Mr. Loyd is guilty?
It would all be based upon the evidence. You know, I mean, it's a jury, so you have to, in terms of having an unbiased opinion, you know, but obviously if I was researching and reading articles and so forth, I would form an opinion, but due to the lack of information I have and evidence, I wouldn't. I'm pretty neutral on the subject.
And you know you're under court order not to research or form an opinion.
yeah.
All right. Okay.
Yeah, you made
I just
that
wanted to clear that, clarify that.
Yeah,
All
yeah.
right.
I'm just saying on normal circumstances.
Right.
Yeah.
So, as you sit here today, can you presume Mr. Loyd to be innocent?
I would say that I'm neutral on the subject, and innocent until proven guilty,
Okay.
based on the evidence.
You
yeah.
realize that he's innocent until and if the
Yes.
state can prove he's guilty?
Mhm.
Okay, is that a yes?
Yes, yes.
All right. So tell me about your feelings or beliefs about the death penalty, please.
I don't have a problem one way or another. I guess based upon the evidence that's provided, I would say some people might deserve it more than others based upon the crime that is committed,
Okay.
or the severity of it. But it's kind of catch-22 either way of what you decide, because one could argue it's an easy way out versus rotting away in a jail cell if you want to put it in that terms. So I'm pretty neutral either way on I'm not opposed to it. No religious problems or anything. So I guess it would be based upon evidence.
All right. Are there any cases that you think automatically deserve a death penalty?
I don't know. I would have to, not that off the top of my head. I would have to kind of, get a situation.
Specifically, do you believe that the death of a law enforcement officer automatically warrants a death penalty?
Well, I would say some people might be upset, but I would say the law enforcement officer, in my opinion, warrants it more than, say, a normal citizen's life.
Okay.
In that case.
All right. The law says that if, let's say Mr. Loyd was convicted of first-degree murder, and it is a law enforcement officer, you have to be able, during penalty phase, you have to have an open mind about this. You can't start with a, predisposition for life or predisposition for, you can't, you got to start in the middle, neutral. All right? You start with life, you work to death, all right? I'm correcting it. You start with life, and then you weigh the aggravators, or you hear the aggravators. They have to be proven beyond a reasonable doubt. Then you go back into the jury room with your fellow jurors, all right, and talk about the aggravators and the mitigators. Aggravators are statutory reasons the state believes death is an appropriate sentence. Mitigators are reasons the defense believes that life is the appropriate sentence.
Okay.
You have to have an open mind as to both, all right? And you talk about this with your fellow jurors. Sure. All right, sir. Penalty phase.
Yes.
State's going to present aggravators, defense going to present mitigators. You have to be open to both of them, all right? You're going to go back in the jury room. You're going to talk about it as a group. You're going to discuss it all, weigh it out. And at the end, each one of you has to vote individually, life or death. But you have to have an open mind as to both. Do you believe you could do that?
I believe I could do that. It's not, I wouldn't say that I'm, hardcore yes on this specific subject.
Okay.
Yeah.
And your decision is an individual decision. Each juror, even if 11 people voted one way and you wanted to vote the other way, you can do that. You understand that? Is that a yes?
Yes.
You understand that the vote for death has to be unanimous. All 12 jurors have to agree
Okay.
before a court could impose a death sentence.
I understand.
And you understand that even if one juror votes life without the possibility of parole, meaning Mr. Loyd dies in prison, it's a life sentence.
Okay.
And are you comfortable with that?
Yeah.
Do you believe you could follow the law as to this?
I could follow that. Yes.
Mr. Loyd has raised the defense of insanity in this case, not guilty by reason of insanity. The specific instruction will be given to you at the end if you're on the jury, but generally the burden's on the defense. This is the one time, the burden's on the defense by clear and convincing to raise the defense. And the two things they have to prove by clear and convincing, there's a mental infirmity, disease, or defect. Mr. Loyd suffers from that. And because of that, he did not know what he was doing or the consequences, or although he knew what he was doing and its consequences, he did not know it was wrong.
Okay.
All right. Like everything else, you have to have an open mind. You have to be willing to listen to the evidence and consider this and weigh it. And listen to the evidence, consider this, and decide whether you can decide yes or no, but you have to be open to it. Do you have an issue with the defense of insanity?
I don't have an issue if that was something to be presented.
All right. Do you think you could listen to the evidence with an open mind and reach a verdict on that issue?
I would believe so.
All right.
If, depending on, the evidence that was provided.
Is there anything about this case that's causing you concern that you could be a fair and impartial juror
I don't believe
to
so.
both sides?
I don't believe so.
All right. State, you may inquire.
Good morning, sir. Sorry, we're all over the
No,
court.
you're all right.
Just popping up wherever. On a scale of 1 to 10, 1 being you'd like to run out of the room screaming, and 10, it's really important to you that you be a member of the jury. Would you like to be a member of the jury?
Sorry, I slipped my brain. What was 10 and what was 1?
10 is you really want to be on the jury, and number 1
Okay.
is you want to run out screaming because this is the worst thing you could possibly imagine.
No, I mean, everyone has, different priorities in life going on, so I wouldn't say it's an absolute 10, but I would say it's probably like around an 8 or something. It's important. This is actually my first time, so I'm actually interested in the process of it
Okay.
and to help out as much as possible.
And that's what I was going to ask, but I think maybe you answered it. Why are you interested in being on the jury? Why do you want to be on the jury?
Well, I guess that kind of answers
Right.
it in a little
Okay.
bit, yeah.
You want to help out, you're interested in the process. Is that a yes?
Yes, because it's my first time as well. I like to be educated in, I guess, different areas.
Your first time as a juror, is that what you were referring to?
Yes.
Like even coming up to the initial part, you've never had that happen?
Yeah, I haven't done that before.
Okay. So just to reiterate, don't presume that because we're talking about the death penalty that will even ever be a conversation. The only time that even becomes an issue is if the defendant is convicted of first-degree murder. You understand that?
I understand.
So the way the process would play out is if there's a conviction of first-degree murder, the state would have the opportunity to present evidence of what are called aggravating factors. And those are things that are just like they sound. They are facts or circumstances that make a first-degree murder above and beyond worse than your normal first-degree murder, if there is such a thing, right? And one of them that does not apply in this case, but is an example, is the victim was a child under the age of 12, right? So you can imagine why killing a child in the eyes of the legislature or the law might be worse, correct? Does that make sense?
Correct, yeah.
All right. So in order for a death sentence to be lawful, the jury has to find unanimously that at least one aggravating factor was proven beyond a reasonable doubt. At that point, the defense would have the opportunity, if they wish, to present evidence of mitigating circumstances. And those are things just like reasons why they believe that a sentence of death is not appropriate. And that can be anything about the life, character, or background of the defendant that is proven. Does that make sense?
Yes.
So at the end of, or in the middle of this process, you all will be asked to weigh, the jurors, the aggravating factors against the mitigating circumstances. And there is no specific weight. You don't tally up the numbers on one side and put them against the other. You decide as a juror, your fellow jurors decide as individuals what weight to give the aggravators and the mitigators. Make sense?
Yes.
Right? I'm explaining this because I don't want you to think that we just throw this decision, this very important decision at you and ask you to make it without some context. At the end of all that, if you unanimously find at least one aggravating factor beyond a reasonable doubt, and if there's a unanimous finding that the death penalty is warranted, only then is it authorized for that sentence to be imposed. Make sense?
Yes.
All right. No matter what you find as a juror regarding the aggravating factors, the mitigators must be considered. Now, you can know that intellectually, but my question for you is, even if you find that the aggravating factors are really severe, let's just say they personally offend you and you're angry about the crime. You with me?
Yes.
Overruled. Go ahead.
Could you still consider the mitigating circumstances before making a determination as to whether the death penalty is the appropriate sentence?
I feel like bringing emotion into it is kind of an immature aspect if you're trying to be professional and make a decision.
Right.
And I feel like you would need to consider both options and keep a level head. And as a juror, that's your responsibility.
So could you do that, though?
I believe so.
So even if the aggravators were proven, you would wait and listen to the mitigating circumstances before rendering a decision?
Yes.
Okay. Let me ask a separate question. Let's say that we go through the process and that you listen to the mitigating circumstances, and you believe the mitigating circumstances outweigh the aggravating factors, or that the aggravating factors do not outweigh the mitigating circumstances, right? Either way. In that situation, death would not be appropriate under the law. Could you reach that decision even if the circumstances made you angry?
Well, I guess we're going back to the emotion aspect of it. I'm pretty level-headed in that aspect. It doesn't, this situation hasn't really affected me any, one way or another. But depending on the evidence and how I felt of mitigating versus the other one, I would, make a decision on that, and I believe I could do so to weigh it.
Could that decision be life without the possibility of parole if you thought it was appropriate?
If I found it was appropriate, yes.
Okay. The judge briefly talked to you or made you aware of the fact that insanity is a possible defense in this case. So forgive me for the somewhat personal nature of the question, but I think you'll appreciate why I'm asking it. Do you or someone close to you, have you gone through or experienced significant mental illness? Have you had any personal experience with that?
I wouldn't say significant. I think everyone has their spurts of depression and anxiety every once in a while with, life that's going on. But I don't have a history of that in my family nor to myself.
Any friends or loved ones or nothing like that?
Not particularly, no.
Okay. Do you believe that some people can feign or make up mental illness?
That's where it becomes difficult because if you're making a decision based upon specific evidence of one case, sometimes it can be found in previous evidence of, let's say, previous rap sheet history, because let's say they did oddball things that relate to insanity aspect or mental health related concerns, then it would connect the dots in a way.
Right.
But I feel like some people could fake it, and the evidence based upon that specific situation could show or not show that insanity aspect.
Conversely, do you believe that mental illness is real?
Yes.
Do you agree that some people suffer it and it has a real impact on their life?
I would say so. And some situations make it worse in certain times.
Is there anything about your life or history or background that you think would make it difficult for you to fairly weigh whether or not a person, number one, had a mental illness, and then number two, that mental illness led them to not know what they were doing, that it was wrong? Anything about your personal beliefs or situation you think will make it hard for you to do that?
I don't have a problem personally making a decision on that. Based upon the evidence, it would help me farther connect the dots to be able to understand, the reality of it in that situation. So it depends on, how much evidence and so forth, how strong the evidence is.
Could you imagine a circumstance where a person had a mental illness and based upon what you heard, you felt like they were insane at the time and should not be held criminally responsible?
If
So the question is,
yeah.
could you imagine a circumstance where that's the way you would feel? That's the
Yeah,
result
I
you
would
would
say certain mental illnesses can be improved upon. You know, I think there's always that underlying factor that people have, but I feel like it gets to a certain point and someone could say blow their top.
Right.
And at that moment, it could be an insanity aspect.
And you could find that if appropriate.
Yes.
Can I have a moment, Judge? I don't have any other questions. Thank you, sir. Thank you.
Thank you. Mr. Lenneman, you may inquire.
Thank you, Judge. How are you doing, sir?
Good.
What kind of work do you do?
I'm in school for my bachelor's for cybersecurity.
Okay. Are you cybersecurity?
Yes.
What's your plans to do with that?
Eventually, it's called security data analyst. They manage like the big data servers and the big warehouses. That's kind of my plan long term.
All right. Did you ever think about going into law enforcement?
More so reserves for the military,
Okay.
but due to health concerns, I wasn't able to. But never law enforcement myself.
Okay.
If anything would be close to cybersecurity, would be kind of forensics, but I've never explored that route.
And you grew up in a family that had a lot of respect for law enforcement?
I mean, we don't particularly have family members that have been directly in the police. I mean, way back when, like 60s.
Right.
But nothing particular. I mean, I have respect for law enforcement, military, and so forth, you know, leaders. But if that answers the question.
Yeah, thank you. Thank you very much. So, when you said, when you were talking about law enforcement, how you put that higher in general kind of public, what were you saying?
I don't know. I feel like they're kind of the, what's the word for it? They're like the securing force of the law. And so I guess they hold more value to me. And like I said, it sounds bad to some people than like a general public citizen.
Right.
But obviously, depending on the situation, you murder a bunch of citizens, let's say Pulse situation, totally different situation. It's very hard to rule one way or another. I guess just my respect is more for higher law enforcers.
So what you're kind of saying is, when it comes to like the death penalty, an officer would be higher up than everyone else, but there's a situation where if there's multiple
Or if there's children involved.
children involved.
Yeah, it depends on the
that would
situation.
push it up more.
I guess, yeah, it depends on the situation.
Okay. So, I think the judge asked you about the issue of looking at a murder, considering the murder. And in your mind, there's a murder. It's first-degree murder. There's no defense. It's not an accident, anything like that. Do you believe that they would deserve the death penalty in that situation?
I guess it depends on my feelings and the evidence at the time. Because like I was mentioning before, you know, putting it bluntly, it either is like rotting in prison and dying in prison, or some people would argue the death sentence may be the right thing to do, but it also could be argued as the easy way out. Some people would think rotting is kind of them suffering for their crimes that they committed.
Right.
So I guess it depends on the evidence and how I was feeling with what I discussed with my jurors and made that unanimous decision and so forth.
Okay. And so what we're talking about really is a personal feeling that you would have, that there's something that when there's a premeditated murder, that some circumstance that you would automatically vote for the death penalty?
It's difficult to say because one life, even law enforcement and so forth, is kind of hard to make that one flip or another versus, let's say it's a pulse situation where it's 50 people. I would think that's like warranted in my mind right away. So it's kind of hard to make that decision, I guess, off the top of my head with just one or, two
Right.
people or something, because
Right.
it could be an insanity thing. It could be anger management problems. I don't know. It's
Right.
hard. Yeah.
Right, but you said coming out of the box, you would give the law enforcement a little bit higher.
Yeah,
than everybody
standard
else.
wise, I would say. Yeah.
In regards to the death penalty?
Correct.
Okay. Can we come sidebar, Judge?
Yeah, come on over.
Thank you very much, sir. I appreciate your time.
Sir, you also told me you were a full-time student, and this was going to affect your ability to, it might affect your ability to pay for school.
Well, that's what the work study was for that we were discussing that one time. But yeah, I'm a full-time student, but fully online.
All right. Well, I appreciate your service, I do, but I think we're going to excuse you at this time.
Okay.
So thank you very much. You're discharged as a juror, and you're free to go.
Well, thank you for your time as well. I mean, I enjoyed the process of learning this, and hopefully in the future I can become a juror.
I sincerely hope we see you again. I'm sure you'll get another summons. All right.
Thank you.
sir.
Which way do you want me to exit?
That way. The deputies are going to help you with that. In the meantime, I need juror 293, who was in seat 13. Yeah. Seat 13, panel 1. Good morning. Have a seat. As much as you can, with everyone staring at you, try and relax. All right. I've got some questions for you, and then I'm going to turn it over to the lawyers. Let me start with, you told us that you'd heard something about this case.
Yes, ma'am.
What have you heard? You're going to need to put that mic up
Oh,
near
sorry.
your mouth.
I mean, just on TV when it was all happening. I seen the news footage and,
Can't hear you.
okay. Just when it was on TV. Okay, I seen the news footage.
When was that?
I guess when they arrested him. I don't know when, I don't remember the
So,
date.
A couple of years ago.
Yes, ma'am.
All right. Since that time, have you watched any more news coverage about this?
No.
Or read anything?
No,
Have you talked to anybody about the case?
no,
Have you heard anybody else talking about it?
no.
All right, so your memory is from the initial arrest time.
Yes, ma'am.
What do you remember hearing?
Well, I remember when they had the helicopters out looking for him, and then they caught him, and then they caught him on the ground, and I guess OPD was there arresting, and that was it.
Okay. Based on the, is that the only, did you see one news story or several?
Oh, several, yes.
Okay. Based on what you were hearing on the news, did you form an opinion as to whether Mr. Loyd was guilty or not?
It felt to me like he was guilty.
Okay. And let me tell you, man, we're not looking for one answer or another. We need people to tell us the truth
Yes.
about this to see if you can do your job as a juror. Some cases you can, some cases you can't.
Right.
All right, so would you say that coming into this courtroom, you have a feeling that Mr. Loyd is guilty?
Yes, ma'am.
The law requires jurors to start presuming Mr. Loyd is innocent. Can you do that
Yes, with facts.
with facts? Okay.
Yes.
And by that I mean, when you start, you can't be sitting there thinking, well, I think he's guilty, but I'll listen and see if they can prove to me he's not. Is that what you would be doing?
That's the way I feel, yes.
Okay. State. Defense. All right. Thank you, ma'am. I don't think this is the case for you, but we really appreciate your service. You're discharged. You're free to
Thank you.
go. The mask is a gift.
Okay.
Thanks. That was seat 13. All right. I'm going back to juror number 207 in seat 1, panel 1. Welcome back. All right, have a seat. Relax. All right. This is, I know, an awkward situation. You've never been in it before, so try and relax as much as you can. So you've never heard anything about this case prior to what I told you this morning?
No, Your Honor.
Okay. Can you tell me what your position, if you have one, what your position is on the death penalty, please?
So what do you mean exactly?
I'm sorry?
What do you mean exactly?
Are you opposed to the death penalty, for the death penalty? Have you ever thought about it prior to today?
So this is my first time over here, so I'm a little bit nervous. I don't know, but
I can barely hear you. You've got to
Oh.
get that mic closer to you. Okay. Thanks.
this is my first time over here. I'm a little bit nervous, but I believe like there's nothing about the law, you know. If justice got to be served, and
Okay. To sit as a juror in this type of case, we have to know that you're able to follow the law. So the law in the state of Florida is this, which is the penalty for first-degree murder is life without the possibility of parole. But in certain cases, the death penalty becomes a possible sentence. You have to sit through the guilt phase, listen to all of that, and if and only if Mr. Loyd is convicted of first-degree murder, then we go to what's called a penalty phase, where now you're going to listen to aggravators, which are reasons, legal reasons the state believes death is the appropriate sentence, and mitigators, which are reasons the defense believes life is the appropriate sentence, and life is without the possibility of parole. Mr. Loyd would die in prison. You follow me so far? Okay? Both sides present their evidence. Once all that evidence is presented, I will give you the jury instructions. You and your fellow jurors go back into the jury room. And now you're looking at the aggravators, you're looking at the mitigators, you're weighing it all out. You have to make an individual decision as to whether you believe life or death is the appropriate sentence. all 12 jurors must vote for death for a court to be able to impose a death sentence. If even one juror votes for life, it's life without the possibility of parole. You got it so far?
Yes.
You have to have an open mind about this, and you have to be willing to listen to both sides. Do you believe that you can do that?
Yes, I do.
Is there anything about the process I just described to you that is causing you to hesitate?
No, ma'am.
Is there anything about the fact that this is the death of a police officer that would cause you to automatically want to impose death?
No.
Do you believe you could treat this the way the law requires you to treat it? Weigh the aggravators, weigh the mitigators.
Absolutely.
Mr. Loyd has raised the defense of insanity in this case. And as I indicated to you, this is not the entire insanity instruction, but I'll just give you an overview. Insanity, it's the one time the defense has to prove something. Other than that, the state has to prove everything by reasonable doubt. The defense has the burden by clear and convincing evidence to prove, one, Mr. Loyd had a mental infirmity, disease, or defect, and that because of this condition, he did not know what he was doing or the consequences, or although he knew what he was doing and the consequences, he didn't know it was wrong. That's generally what the defense of insanity is. Like everything else, you have to be able to listen to the evidence about this with an open mind, with no predisposition to say, insanity, I'm never going to accept that defense, or I'm always going to accept that defense. Open mind where the evidence leads you. Can you do that?
Yes, ma'am.
Do you have any doubts whatsoever about that?
No. No,
All
so
right.
far.
Is there anything that would stop you from, at this moment, that you feel would stop you from being a fair and impartial juror in this case?
No, ma'am.
All right, thank you, sir. State, you may inquire.
Good morning, sir. Over here. How are you?
Pretty good. Thank you.
Have you ever been a juror before?
No, ma'am. No, sir. This is my first time.
Okay. So, do you watch the news at all?
No.
Not at all. Do you watch any crime scene television shows?
Sometimes.
Okay. So the judge was asking you some questions about the death penalty, and you indicated that, I believe, I'm taking it you're basically neutral on the topic. Would you agree with that statement?
Yes.
Okay. So my question is, have you ever seen on TV or heard about in the media or talked about with a friend a case or situation where you thought the death penalty was appropriate? Let me give you an example. And this is an extreme example. The Pulse nightclub shooting. Did you live here in Orlando when that happened?
No.
You did not. Are you familiar with that situation?
Yes, I heard something about that.
Right. So obviously it was sort of a hate crime, the murder of many, many individuals, approximately 50. Any situation like that where you thought to yourself, be appropriate in that situation?
Probably, yeah.
Okay. What circumstances have you thought about when you thought that that was appropriate? If you could just, and there's no right or wrong answer. We're just asking for your opinion, that's all.
So there's like a lot of sick persons out there, you know,
Right.
and I mean nobody deserve like who live or who dead, who's gonna be dead, you know. Nobody got that right. So I mean, I believe in second chances, but sometimes I don't know.
It depends on the circumstance?
Yeah, it depends.
Okay. But I take it from your question that in your mind there are first-degree murders where a death sentence would be appropriate.
Yes, absolutely.
Overrule. Go ahead.
Conversely, may I proceed, John? I'm sorry.
Yes, you may.
Conversely, I take it from your comments that you do not believe the death penalty is appropriate for every first-degree murder. Or do I have that wrong?
I mean, it's complicated, you know.
It is complicated,
As
I
I
agree.
said, this is my first time involved in one of these cases,
Right.
one of these scenarios. So I don't even know.
Well, But let me back up and maybe describe the circumstances, the context for this, okay? The only time the death penalty is ever appropriate, ever, for any crime is first-degree murder. You understand?
Yes.
So you can't get the death penalty for sexual battery or rape or anything like that. It's only first-degree murder. All right? And there's only two punishments for first-degree murder: life in prison without parole or death. Okay? So if and only if Mr. Loyd was convicted of first-degree murder, then the jurors would have to decide which one of those two was appropriate. Does that make sense?
Yes.
Yes, sir.
All right. So can you imagine somebody being convicted of murder where a life sentence was appropriate rather than death? Or do you think that a person should automatically get the death penalty for every first-degree murder?
That's why we have to listen to the evidence, so we have to listen both sides.
Right. I understand. I just want to make sure that you understand that and you accept that.
Yes.
So do I understand you to be saying that you would not automatically vote to give a death sentence to everybody convicted of first-degree murder?
I believe we have to listen first,
Okay.
and so we judge.
Okay. So if Mr. Loyd were convicted of first-degree murder, we would present evidence of what are called aggravating factors. And those are things that are very much like they sound. Things about how the crime was committed, or sometimes about the nature of the victim, that make the crime above and beyond a normal, if there is such a thing, first-degree murder. So for example, something that has nothing to do with this case, but is an aggravating factor under Florida law, is that the victim was a child under the age of 12. Right? So most people hear that and they say, yeah, that makes sense, because if you kill a kid, then that's an aggravating factor. We have to prove at least one aggravating factor beyond a reasonable doubt in order for a death sentence to be a possibility. Does that make sense?
Yes, sir.
All right? And the jury would have to unanimously find that in order to move on to the next phase. If we presented that evidence and you made that finding, and no matter what, the defense would have an opportunity to present evidence of mitigating circumstances. And those are things about the defendant's life or background or character that they believe indicate that a life sentence rather than death is appropriate. Make sense?
Yes.
Okay? Jurors have to be willing to listen to the mitigators before making a decision on the aggravating factors. And, before making a decision as to whether death is appropriate. Does that make sense?
Yes.
It's sort of like what you've been saying. You have to listen to everything. Could you listen to the evidence of mitigating circumstances before making a final decision?
Yes, sir.
Would you promise to do that no matter what?
I do.
Okay. And then, after listening to all the evidence, the jurors will weigh the aggravating factors against mitigating circumstances. And if the aggravating factors outweigh the mitigating circumstances, then you can determine whether or not you believe as an individual that death is the appropriate sentence. So if you listen to all that and listen to the law as the judge instructs you, and you believe personally that death was an appropriate punishment, could you raise your hand and vote for a sentence of death?
Yes, sir.
Conversely, if we didn't prove it, or if you found that the mitigating circumstances were significant, could you vote for life in prison without the possibility?
Could be.
Could be. Okay. Do you think you're leaning one way or the other?
No, let's just finish the question. Have a seat. Okay, go ahead.
Are you leaning one way or the other as to either sentence as you sit here right now? In other words, do you think, not having heard anything, do you think that death is more appropriate for first-degree murder than life in prison?
In this case?
Well, you don't know anything about this case. So generally,
Well, like I said, I have to listen both sides, then we judge. So
Okay.
I can't really tell you like what's gonna be like more appropriate, but that's why.
well, so I'll try to ask it a little bit differently. Do you think that if you heard that a person was guilty of first-degree murder, that they should be more likely to get death than a life sentence without parole? In your opinion?
So it's my opinion. So, it's complicated, like as I said. So I have to get more involved. So
Okay.
No, what's gonna be better?
Okay. Are you willing to go through this process and listen to the evidence and make your decision based only on the evidence in the case?
Yes,
Okay. Thank you, sir.
welcome.
I want to ask you about insanity a little bit. So forgive the personal nature of my question, but do you believe that, or I'm sorry, have you had any personal experience with significant mental illness? And by that I mean either you or someone close to you has had a significant mental illness.
No, sir.
No. Do you believe that mental illness is real
Yes, I do.
and that people suffer from it?
Yes.
Okay. Do you believe that mental illness should automatically excuse someone from being responsible for their actions?
I don't know.
No.
I don't know.
So I take it to mean that there are circumstances where even you would find that even if there were a mental illness, that person could be held responsible,
Yes.
right? However, if it were proven to you that a person had a mental illness and that they didn't know what they were doing was wrong, in other words, that it met the prongs of insanity under the law, could you find a person guilty, not guilty by reason of insanity?
No, I don't know.
You're not sure? Okay, talk to me about
I'm not
that.
sure. I'm not sure.
Talk to me about that. Why could you find one and not the other?
I mean, it's not because I got like a mental illness. I gotta go around like killing people, and like that's. I mean, like I said, sometimes you have to judge.
Right.
Sometimes.
Do you think that there's ever a circumstance where you could be persuaded that a person should be not guilty by reason of insanity?
Yes, why not?
You think there is a circumstance where you could do
Yes.
that? Right. So if it were proven to you that a person had a mental illness and that because of that mental illness they didn't know what they were doing or that it was wrong, could you find them not guilty by reason of insanity?
Could be.
Okay. Possible for you.
It's gonna be possible.
Okay. Can I have a moment, Judge? That's all I have, sir. Thank you very much. Thank you. Your Honor.
Thank you.
Mr. Letterman, you may inquire. Go ahead and inquire, then we'll do the sidewalk. I'm listening.
Good afternoon. How are you doing today, sir?
Pretty good, sir. Thank you.
What kind of work do you do?
I work for Public Distribution Center.
Okay. What do you do there?
This is like a warehouse, big warehouse. I just driving. I'm forklift driving.
Okay. Now, the prosecutor spent a lot of time talking about the death penalty, and I'm going to talk some more about that too. But when he was talking to you about insanity, you had indicated at first you could not ever vote for insanity, and then later on you said you could, and I'm not understanding what that means.
Well, that means like I'm nervous. It's the first time in being involved, so sometimes like I don't want to be like scared of my answer. At the same time, just trying to look for the right answer. That's probably what happened.
Now, when you say look for the
Mr.
right
Letterman,
answer,
Let me intervene here for a moment. Sir, I understand that you're nervous. I want you to understand there are no right or wrong answers that you can give us. You just need to tell us what you actually believe and think, okay?
Okay.
So put aside being nervous and just be honest. All right? Go ahead, Mr. Letterman.
okay. So what is your honest thought about insanity as a defense?
You need to turn your mic on, Mr. Letterman, because I can't hear you.
It is on, Judge.
Is it?
Yeah.
Go ahead.
Hello?
All right. Go ahead.
I mean, what do you mean exactly? What?
Okay. So one of the defenses in Florida allows a defendant to raise an affirmative defense, meaning that we have to prove that he was insane at the time of the killing, in this case, the killing. And so there are some people who don't believe in that, they don't like it, they don't want to have anything to do with it, and some people will accept it and follow the law. Where are you?
I just following the law. If we're gonna get proof that guy was insane, he should be judged.
Okay. Now, in this particular case, as you heard from the judge, my client has already been convicted and sentenced to life in prison on another murder case. How do you think that's going to affect your ability to listen to the evidence when you know that?
So, well, I don't know exactly, so I have to listen both sides. Answer or my judge.
Right, but what I'm asking you, listen closely what I'm asking you, okay? I want your opinion, not listen closely to both sides. I want to know what you're feeling. Do you think the fact that my client has been convicted of first-degree murder, do you think that's going to influence you to lean more towards them, the prosecutors, than Mr. Loyd?
No, sir.
Why?
Because I got my personal opinion, you know.
Okay,
So I got based on that, I'm gonna keep my judge. That's why.
what is your personal opinion? You say you have a personal opinion.
Well, not right now, but I mean, like, if I just know about the case better, I mean, like, I don't know.
Let me ask you about your language. Where are you from?
I'm from Cuba.
Okay. And how long have you been in this country?
10 years, sir.
Okay. Do you ever feel like you have a difficult time communicating with people?
Yes.
Okay. And in this particular case, there's going to be 11 other people who are going to be jurors, and you're the 12th. So you have a right, like everyone else, to voice your opinion. Are you going to be concerned about the ability to voice your opinion because of the problem you believe you have communicating?
No, that was before, not right now, but no.
When you say it was before, what do you mean?
So when I first came here to this country.
Okay. Now, there was some conversation about the death penalty, and I was kind of confused by some of the answers you were given, okay? I don't want to hear about, oh, I'm going to listen to the evidence, I'm going to listen to the evidence. I want to hear what your personal belief is, okay? If you have problems understanding the question, just ask me to say it again, okay?
Okay.
We good with that? Okay. So my first question is, if someone is guilty, you know for a fact they're guilty of premeditated murder. They thought about it before. It wasn't an accident. It wasn't a mistake. It's clearly premeditated murder. Do you think that person deserves the death penalty all the time?
Yes, sir.
Okay. Thank you, sir.
All.
All right, let me see the attorneys inside. Or were you done? I'm sorry, Mr. Ron. You said thank you, so I assumed you were done.
Yes, I'm done, Judge.
Let me see the attorneys inside.
Now, this case involves the killing of a police officer. If you have any feelings about that,
Yes, sir.
can you tell me what they are?
I mean, that's really like a bad thing. And so we're supposed to judge that actions because those not like the right actions.
Okay, but do you think that if you were comparing the regular person who was murdered versus a police officer who was murdered, that this would bother you more and concern you more?
No, sir. The same thing. It's a human being.
So, now I want to talk to you about the death penalty, okay? Do you think that the sentence of life without the possibility of parole, as opposed to the death penalty, is a sentence that you could consider?
Could be.
Do you think that life without the possibility of parole versus the death sentence is a lesser sentence, or have trouble with that sentence?
No.
When you think about the death penalty, and if you're on a scale of 1 to 10, 10 being that you're really, really for the death penalty, 1 is you're really against the death penalty, where would you fall on that scale?
6.
6. So you lean more towards the death penalty.
Could be.
Why?
Oh, this is a kill somebody,
No.
so that's why.
So you already factored in the fact that he already killed somebody and what your opinion is in regards to the death penalty.
Yes, sir.
Can I come sidebar?
Yeah. Mr. Lamb, turn your mic on, please.
The fact that you know that Mr. Loyd is convicted of first-degree murder, would that affect your decision in the first part of the case, the guilt and innocence?
No,
Why not?
because I mean, I'm sure about what I think.
Sir, I can't hear you. I'm sorry.
I'm pretty sure about what I'm thinking.
What are you thinking?
That's like, this is not his first killing case. So what makes you think he's not gonna do it again?
Okay, so here's my question. Maybe I'm not understanding you. In terms of your feelings about the fact that he was convicted of first-degree murder, as you sit in the jury and listen to the evidence and then ultimately go and make a decision about him, that's going to factor in to your decision that he was convicted
No.
of first.
No,
So what are you saying? He did it before. Why are you saying that?
well, I mean, I'm just asking you. I don't know exactly. I'm just asking you because I mean, like I said, I believe in second chances, but guy's not like doing this the first time.
Right.
He probably is gonna do it again.
Okay. And so when you're listening to the evidence, is that something you're going to be thinking about?
I just wanna listen to the evidence. That's it.
What are you going to be thinking about, that he was convicted of first-degree murder?
Yes, I do.
Okay. Now I want to talk to you about the death penalty. The death penalty is only in play if Mr. Loyd is convicted of first-degree murder. You understand that?
Yes.
You won't have to decide anything before that. You understand?
Yes.
Now, it's an individual decision. You're the one who makes the individual decision. Would you be able to, if you had an opinion, whether it's life or death, maintain that in the face of other people telling you you're wrong,
Yes.
no matter what?
Yes.
Okay. And would you allow other people to be bullied by jurors who are trying to get them to change their mind in the penalty phase?
No.
Would you protect them?
Yes.
Okay. Now, I heard you talk about mental health. You said that, I thought you said that that's something you can consider as a mitigating factor.
Yes. I do.
What about race? Could you consider that as a mitigating factor?
I mean, I'm not judging people because of their race.
No. If something in his life affected him, and we prove it to you, would you be able to consider that race as a mitigating factor? Some people can, some people can.
I'm not so sure.
Okay. What about trauma, if he suffered trauma?
It could be part of the mental illnesses, right?
Okay, so you can consider that.
Could be.
Okay. And what about brain damage?
It's the same thing. Could
Okay.
be.
Those are all the questions I have, Judge.
All right.
Come sidebar.
All right, sir. We're going to have you come back for the third day of jury selection. We're giving you a packet that includes the instructions for jurors if they're chosen as jurors, because that would be the day that we would pick the jury. And it's called the sequestration packet. It's got a lot of information for you. The other thing it has is this. You need to pack a suitcase before you come the third time, because if you're picked as a juror, you're being sequestered that day. Leave it in your car. Don't bring it into the courthouse, but pack, all right? They're also giving you a number for you to start calling starting Thursday. They'll tell you when we know what day it is you're supposed to come back, because at the moment we don't know, okay?
Hey, excuse me, Your Honor. I got a situation right now. Friday, after my first day coming over here, HR called me.
Who called you?
HR from my
Yes.
my job, and they said they're only gonna pay for 3 days instead of
Okay.
the 3
Can you
weeks.
afford to miss the rest of the 3 weeks of pay?
I'm sorry.
Can you afford to miss another 3 weeks of pay after that? Would you be able to pay your bills?
No.
Any objections from state? Any objections from defense? All right, thank you, sir. You're free to go. All right, I think we have one juror left in the room. Is that correct? It should be the juror in seat number 9. There's 2. Who? All right, bring in seat 5. Yes. No, I'm telling them that. Okay. But the slip, you gave him the slip with the phone number on it, right? Okay. Yep. Thanks. Juror in seat number 5, juror number 32 is being called in. Have a seat, ma'am.
Yeah, thank you.
All right. Good morning.
Good morning.
Take a breath. Try to relax. I know this is a little awkward. Let me start by telling you, we're not looking for any particular answers from you. All right, there are no right or wrong answers to these questions. We're looking for you to be honest with us and tell us what you actually think and feel, okay?
Yeah.
You haven't heard anything about the case, is that correct?
No, I haven't.
So tell me what your beliefs are about the death penalty.
I honestly, I'm not a very decisive person, so.
I'm sorry, you're going to need to speak up a little bit.
I'm not a super decisive person, so I've never had to be in any kind of situation where I had to really think about that.
Okay.
So I really don't have an opinion whether,
So you
it
haven't
should be
heard
an
any
option.
opinions.
Huh?
Prior to coming into this courtroom, you hadn't really thought about it much?
No, not really.
Okay, and have you hadn't formed any opinions? Is that what you're telling me?
Yes.
Okay, so let me go over this with you. Jurors in this case, ma'am, we may never get to this point, but we have to ask you about it in case we get to this point, all right? If Mr. Loyd is convicted of first-degree murder, then we go to what's called a penalty phase. And at that penalty phase, the state's going to present to you aggravators, which are legal reasons they believe death is the appropriate sentence. The defense is going to present to you mitigation, which are reasons that they believe that life is the appropriate sentence. The sentence for first-degree murder in the state of Florida is life without the possibility of parole, but in certain cases where there are aggravators that are proved beyond a reasonable doubt, death can become a possible sentence. You follow me so far?
Yes.
Right. At the end of all that evidence that's presented, I'm going to give you all some written instructions on what you're supposed to do with this evidence, and you and your fellow jurors are going to go back in that jury room, and you're going to weigh out the mitigators and the aggravators. And as a group, you're going to reach a decision, except the decision, while it's reached as a group, is also an individual decision. The vote is individual. Each juror has to decide whether they believe life is the appropriate sentence or death is the appropriate sentence. It takes 12 jurors in order for a judge to be able to impose a death sentence. If even one juror votes life, it's life, without the possibility of parole. Mr. Loyd will die in prison. You with me so far?
Yes.
To sit as a juror in this case, you have to be open and able to consider both sentences. Okay? You can't be saying, if he's convicted of first-degree murder of a law enforcement officer, I'm automatically sentencing him to death, or I'm automatically sentencing him to life. You see what I'm saying? You have to be able
Yes.
to listen to the evidence, weigh it all out, and reach a decision. Can you do that?
I think the guilty versus not guilty would be something I could do, but the death sentence, I think it's one of those things that I probably would have really hard time doing that, because personally, I wouldn't want to feel responsible for somebody being killed.
It's not supposed to be easy to decide, your vote in a case like this, especially, again.
Yeah, but
So are you just telling me that you just couldn't do it?
I don't think I could do it and continue my life sort of, as is. Just because, in my position, I don't think I could even fire somebody from a job without feeling like there was bigger consequences on their life. So I think that would be very difficult.
All right, ma'am, thank you. State, any questions?
No, Your Honor.
Defense? All right. Thank you, ma'am. We appreciate your service. You are free to go. Your discharge as a juror. You can keep the mask, but you're free to go. All right? Thank you.
Thank you, Your Honor.
And then that means I have juror in seat 9, 108. She was juror number 108. Good morning, ma'am. How are you?
I'm good. How are you?
Okay. I'm going to need you to speak up so we can hear you.
Okay.
And I'm going to need you, to the best of your ability, to relax. I know this is sort of an awkward situation, but for you, but just relax. I'm not looking for any specific answers from you. We're just looking for you to tell us what you honestly think and feel, okay? You haven't heard anything about this case, is that correct? If I remember what I told you about shaking your head,
Yeah.
you got to answer out loud.
Sorry, that is correct.
All right. So as you sit here today, do you have any preconceived notions about whether Mr. Loyd is guilty or innocent?
The information you shared before was, incredibly disturbing. But,
You understand that you have to presume he's innocent until the state, and if the state proves he's guilty beyond a reasonable doubt.
correct.
They've got to present evidence, and you can follow that.
Yes.
All right, tell me what your position is on the death penalty, please.
I think that if somebody goes through this process and, they are found guilty, and that is, the result of that sentence, then, that's kind of my stance. If that's the situation, then.
So is it your belief that if someone is convicted of first-degree murder, the appropriate sentence is death?
Yes.
Is there any situation in which you could see yourself voting for life?
No.
State, any questions?
No, Your Honor.
Defense? All right, thank you, ma'am. You're free to go. You're discharged as a juror. We appreciate your service.
Thank you.
You get to keep the mask. The deputies will escort you out. Thank you. All right, and now we should have no one in the jury room. Is that correct? You're moving the 1030s in there? Okay. So here's what I'm going to do, because it's 25 to 12. I'm going to bring the 1030 group in, give them all the preliminary instructions. If there's anybody that obviously has has heard everything to know about this case, I'll go ahead and ask them. I'll release the rest of them to go to lunch, and then we'll go to lunch and we'll try and catch up at some point. All right. So this panel includes juror 6094 from panel 1, seat 14, from the 9 o'clock group. Did 232 show up? Did juror 232, the guy who was going to be an hour late, did he show? All right, so this panel is actually 12 people, including jurors 6094 and 232 from the 9 o'clock group. And they were seats 14 and 15 in the 9 o'clock group. Yes, sir.
It just suggests that either during the panel conversation or maybe as a starter to the first question of the individuals, if anything's changed or they learned any additional information. In other words,
Yeah, I've made a note of that.
I
yeah.
assumed you did, but
He wasn't one of the ones that told me he wasn't going to get
No,
paid.
he
I have
wasn't.
several I have a note for.
it's no
but
one's
yeah.
fault. It's just one of those things.
We're just going to, we'll talk to him again. Yeah.
Yes, Your Honor.
I've made a note. Thank you. Ready? With their original seat numbers? Good woman. Thank you. All right. Great. Thanks. Bring them in whenever you're ready. Okay. Yes, ma'am. What can I do for you? Yeah, I'm well aware of this. All right, if you all will raise your right hand, we're going to re-swear you in. All right, have a seat, bud. All right, I'm sorry for the wait. My optimism about how long it's going to take us to do things is eternal, but misplaced often. All right, I notice a bunch of you don't have the clear mask on. Once you start answering questions, I'm going to let you stay with the others if you want to right now. Once you start answering questions, you're going to have to put the clear mask on. Sorry, folks. I know they're a torture chamber. So you're here for phase 2 of jury selection. Here's what I'm going to do. I'm going to read you some instructions that I have and some explanations about what we're going to be doing. and it's close to lunchtime, so then I'm going to let you go to lunch. I might talk to a couple of you, but the rest of you are going to be able to go to lunch. Again, you're not to talk to anybody during lunch or read anything. So let me start with asking this question, though. Is there anybody who either heard anything on the news, read anything, or anyone told you something about this case or talked about it in front of you? Anybody on this group, in this group? Nope. All right, juror seat number 32, you're juror 421. Yes, ma'am. 32 was your original seat number, folks. That's why we're calling it. Yes, ma'am. Don't tell me anything that you said, heard, or read, but did you hear it, read it? What happened? You saw it coming up? Hold on. We got to give you a microphone. Yeah. Sorry.
I saw the trial coming up before we had the other thing the other day.
Oh, you saw it? Oh, I'll get to that. No, I meant since you were here on Friday.
No.
Okay, thank you. All right, this is phase 2 of questioning. As I told you, this is a death penalty case, so we conduct the questioning in several phases. This is going to be individual. Voir dire day, we're going to be asking you individual questions about this. But before we do, let me explain to you a little bit more about this case. Let me start with this. In this case, Mr. Loyd has been charged by indictment. And folks, an indictment is a piece of paper. I have it in my hand. It's just a piece of paper that tells someone this is what we're charging you with. This is what we're accusing you of doing. You have to tell people what you're accusing them of doing. This is how we do it. It's not evidence of guilt. It's not evidence of anything. It just tells you what the charges are. You are not allowed to consider the fact that someone's been indicted as evidence of guilt. Everybody with me so far? All right. In this case, he's been indicted on count 1, first-degree murder with a firearm of a law enforcement officer. Count 2, attempted first-degree murder with a firearm of a law enforcement officer. Count 3, aggravated assault with a deadly weapon. Count 4, carjacking with a firearm. And count 5, possession of firearm by a convicted felon. Again, the fact that these charges exist doesn't mean he's guilty of them. These are just the charges. In the state of Florida, the only charge that potentially qualifies for the death penalty is the first one, first-degree murder. Okay? There are 2 possible penalties for the crime of first-degree murder in the state of Florida: life without the possibility of parole or death. The automatic sentence upon conviction of first-degree murder is life without the possibility of parole. In certain cases, we call them capital cases. This is one of them. Death is the second choice. Okay. All potential death penalty cases are divided into 2 parts. The first part is known as the guilt phase, and the second is known as the penalty phase. Let me talk to you about the guilt phase. The guilt phase is pretty much conducted the same way as we do all criminal trials. You will be asked to return a verdict of guilty or not guilty on all counts, and your verdict must be unanimous on all of the counts, meaning each juror has to agree on each count either to acquit or convict. But as I previously said, only murder in the first degree qualifies for the death penalty in some cases. The burden of proof for the government is the same in the guilt phase of a capital case as it is for every other type of criminal case. It is proof beyond a reasonable doubt, and the instruction you will receive on reasonable doubt will be identical to the one given in all other criminal cases. The burden on the state is not higher because of the possible penalty. When you're deciding guilt in phase 1 of the case, you will be instructed to ignore the possible sentence during this phase. In other words, we ask jurors to decide whether a defendant is guilty or not on the charges, including murder 1, on its own merits, and you will be told to disregard the possible consequences of your verdict. The only question you are to answer during the guilt phase is whether the defendant is guilty of murder in the first degree, as well as any other offenses charged, or guilty of a lesser included offense, or not guilty. And we expect you, of course, as a juror, to carefully consider the facts before you reach a decision. The fact that a defendant might face a death penalty is to play no part at that stage of the proceedings. If and only if the jury returns a verdict of murder in the first degree, the jury will reconvene for the purpose of rendering a verdict as to which sentence, death or life imprisonment without the possibility of parole, should be returned. If that happens, a special set of rules and instructions come into play. I'm just going to give you an overview of it now. These are not the specific rules that, or jury instructions that you're given. Because the death penalty is reserved in Florida for one class of crimes only, and that is murder in the first degree, the legislature has created special rules for juries to consider in reaching a verdict in the penalty phase. The legislature recognizes that not all first-degree murder cases deserve the death penalty. So they created a list of circumstances which juries are to consider in reaching a verdict in a death penalty case. Some of these the prosecution finds helpful, some of these the defendant finds helpful. The ones the prosecution relies upon are called aggravating factors. The state is required to prove those factors beyond and to the exclusion of a reasonable doubt, and they are limited in number by statute. The ones the defendant relies upon are called mitigating circumstances. Mitigating circumstances do not need to be proven beyond a reasonable doubt. They only need to be proved by the greater weight of the evidence. Mitigating circumstances are not limited by statute and may include matters relevant to the defendant's background or character or the circumstances surrounding the offense. And they will be offered as a basis for a verdict of a sentence of life in prison without the possibility of parole. That sentence means the defendant dies in prison. There is no parole in the state of Florida. Before you may vote the court impose a sentence of death, the state must prove beyond a reasonable doubt that one or more of the aggravating factors they're alleging exist. The process of weighing the aggravating factors and mitigating circumstances to determine the proper punishment is not a mechanical or mathematical process. The law contemplates that different factors may be given different weight or values by different jurors. In your decision-making process, you and you alone are to decide what weight is to be given to a particular factor. Regardless of your findings in this respect, however, you are never compelled nor required to vote for a sentence of death. The final step in this phase of the trial is for each of you to determine whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. The court may not impose a sentence of death unless each juror individually finds the defendant should be sentenced to death. Even when death is a possible sentence, each juror must independently decide whether life imprisonment without the possibility of parole or death should be imposed. Regardless of your prior findings, the law never compels nor requires any juror to determine the defendant should be sentenced to death. Any single juror has the right to vote for a sentence of life imprisonment without the possibility of parole. If after deliberating, the jury unanimously agrees that the appropriate sentence is death, then your verdict may be for a sentence of death. If the jury does not unanimously agree that the appropriate sentence is death, then your verdict must be for a sentence of life imprisonment without the possibility of parole. Now again, this is just intended to give you a broad outline of the penalty phase rules because none of you have experience with it. As I said, I'll give you detailed instructions if you're on the jury and you get to that point. Let me say this too. The fact that I'm talking about the death penalty is not to be taken by you as any indication one way or another as to whether or not this is a case which justifies a death penalty. I don't know that and you don't know that. I'm only discussing this because it's a possibility. It doesn't presuppose anything. We have to be ready just in case it happens and you have to understand how you would be asked to proceed. We're going to be asking you some questions about this procedure and all the things we've talked about today. I'm going to tell you a couple of other things. The lawyers are going to go into that in some detail. I'll ask a few general questions. Some of the questions are going to be on the death penalty. I'm going to give you an idea of the type of questions you're going to be asked just so that you can think about it a little bit. They may or may not come their way, but I think they probably will. You're going to be asked about whether you have any moral, religious, or personal feelings about sitting in judgment of a defendant's conduct in this case. We will ask you your feelings about the death penalty, and if you're in favor of the death penalty, whether or not you agree with the premise that a sentence of death is not appropriate for all first-degree murder cases. You may be asked whether you would agree to weigh the aggravating factors and mitigating circumstances with an open mind and determine whether death or life in prison without the possibility of parole would be an appropriate sentence. And you may be asked whether you're so opposed to the death penalty that you could not consider it as a penalty under any circumstances. Many people have very strong feelings about the death penalty, both for and against it. The fact that you have such feelings does not disqualify you to serve as a juror as long as you're able to put those feelings aside and apply the law as I instruct you. In other words, you must be willing to be bound by your opinion concerning the death penalty in delivering your verdict. I'm sorry, but it's getting late for me. In other words, you must be willing to be bound by your oath as a juror to obey the laws of the state in delivering your verdict. There will be questions about whether your opinions, your personal opinions concerning the death penalty would substantially impair your ability to follow my instructions. Mr. Loyd in this case has raised a defense of not guilty by reason of insanity. We're going to be asking you about that. Very generally, the defense of insanity requires the defense to prove by clear and convincing evidence that Mr. Loyd suffers from a mental infirmity, disease, or defect, and that because of this condition, he did not know what he was doing or its consequences, or although he knew what he was doing and its consequences, he did not know it was wrong. So you're going to be asked some questions about your position on that and whether you can listen to that defense with an open mind. I'm going to read you a statement about this case. This is by no means exhaustive. It's just a general statement. On the morning of January 9th, 2017, defendant Markeith Loyd is alleged to have entered the Walmart store at 3101 West Princeton Street. Mr. Loyd had an active warrant for his arrest. Orlando Police Lieutenant Debra Clayton attempted to take Mr. Loyd into custody on the information she received regarding Mr. Loyd's involvement in the Dixon homicide when it is alleged Mr. Loyd shot and killed Lieutenant Clayton following an exchange of gunfire before fleeing the Walmart and eventually being apprehended about a week later. Mr. Loyd's trial for the killing of Sade Dixon and her unborn child began on September 27, 2019, and concluded on October 23, 2019. Mr. Loyd was convicted and sentenced to life without the possibility of parole. Now, having read that statement to you, talk to you all a little bit about this. How many of you all have heard about this case? Just raise your paddles. Okay. So let's see. 14, 15, 17, 19, 21, 27, 30, and 32. Okay, you can put your paddles down. Of those of you that raised your paddles, please don't tell me anything you've heard. Based on what you've heard, have you formed an opinion as to Mr. Loyd's guilt or innocence? So 17, 19, 30, and 32.
21 also, Judge.
And 21, I'm sorry. Anybody else? No. Okay, so here's what I'm going to do since it's 5 minutes to 12. 17, 19, 21, 30, and 32, stay here in the courtroom with me for a minute. Well, actually, you all go back into the jury room, change into your clear mask for me, please. The rest of you may go to lunch. I need you back here at 1:30. Deputies will meet you outside the courtroom and direct you. And then we'll do the individual questioning then. Don't look at anything, don't read anything, have a good lunch. Keep your clear mask because you don't want to lose those. You'll need them for when you come back from lunch. All right, thank you. So 17, 19, 21, 30, and 32 to the jury room, please. Everyone else, you're free to go to lunch. You can go out that door.
Those of you coming back, leave your paddles on your seat. The ones going into your room, take your paddles with you. The ones clicked on the left hand is right there.
All right, bring in 17, please. And by that, I mean the juror in seat number 17, who is juror number 104. Hi, welcome back. I need you to talk into that mic so that we can hear you. And we're not looking for any specific answers from you. We just need you to tell us the truth, okay? Your juror number is 104, is that correct?
Yes,
All right. You said you've heard about this case and you formed an opinion.
correct.
What have you heard about the case?
I basically just heard what the guy done, like who he shot, and in one of my classes, like we had like a small discussion about it because I'm in a class called hospitality law, and like one of the things we had to do was like discuss like major things happening, and so like that was one of the topics.
Okay. How much news coverage of this have you watched or read?
Not much of the news.
Okay. Did you read anything in preparation for the discussion in your class?
No.
And you said you've reached an opinion on this case?
Yeah.
What is your opinion?
I think that like he should have the death penalty.
Okay. So you think he's guilty and he should be sentenced to death? Is that a yes?
Yes.
All right. Do you think the law requires you to have an open mind about this and presume he's innocent? Can you do that?
Right. Yes.
You can?
Yes.
You can presume he's innocent? Or
Yeah,
you-
if there's enough like evidence.
I'm sorry, what?
Evidence. But it would be hard.
If he can prove to you he's innocent, you'd be okay?
Correct, but it would be hard.
Okay, thank you. State?
No objection.
Defense? All right, thank you, ma'am. We're going to I don't think this is the case for you. I'm going to discharge you as a juror. We appreciate your service. The deputies will escort you out. You can keep the mask.
Okay, thank you.
Juror in seat 19 is going to be my next one. This can't be right. Yeah, it is. I'm sorry. Juror in seat 19 is juror number 94. Good morning. Good morning.
Good morning.
All right, just to verify, you're juror number 94, is that correct?
I am juror number 94, yes.
Okay, great. Just answer the questions truthfully, man. We're not really looking for one answer or another. We just need to know what
Okay.
you actually think, all right? You indicated that you've heard about this case. How have you heard about it?
In the news, on the newspaper,
How much coverage have you seen?
Back when it happened, I saw and watched a lot of it.
Okay.
I found it
And-
an interesting and intriguing case.
Okay. And after he was arrested, did you watch more of it?
A little bit, yes.
Okay. You indicated you formed an opinion as to whether he's guilty or not. Is that correct?
Yes.
And what is your opinion?
I am pretty convinced that he is guilty, that he did it.
All right. Jurors have to be able to set all that aside and start with an open mind about this. Do you think you could do this? You actually have to presume he's innocent. It's not even an open mind. You have to presume he's innocent.
I know I have to presume that he is innocent, but after what I saw and I read, that's going to be an interesting challenge.
Okay. If you can't do it, just tell me so.
I don't think I could.
Okay. Thank you. State?
No objection.
Defense? All right, ma'am, I appreciate your honesty. Your discharge, this isn't the case for you. Your discharge as a juror, we appreciate your time and your attention. All right?
You're welcome.
Have a good day. Juror in seat number 21. This is juror number 45. We're still on the first panel. Hi. All right. Just tell me the truth. Don't worry about what the answer is. I'm not looking for any particular answers, all right? You indicated that you'd heard about this case.
Yes.
Tell me what,
If it's the case that I think it is, I heard it a long time ago.
all right. Do you remember what you heard?
If it's the case, I'm trying to remember, but like, if it's the case, sorry, my phone's on. I can't shut it off because I've got an update and I don't know how to shut it off. My thing is, I don't know if it is. I don't know if it, like, he looks kind of different, but the one that I was thinking of was the one somebody had a patch on their eye, but I
Okay.
don't know if that's the same case.
Okay.
But yeah, back then I kind of had an opinion back then.
What's that opinion?
I just don't like agree with any kind of like a case of murder or whatever. Like, I'm kind of too kind-hearted where I kind of feel bad for people.
I'm not following who it is you're feeling bad for.
Well, like, from what I heard from the case back then, I kind of felt that he would have been guilty. From what I heard on the news, though.
All right, so you have a feeling that Mr. Loyd is guilty.
Well, I don't know by hearing everything, but what I heard on the news, I felt that back then. That's why I wanted to say that, because I don't want to try to pretend like I never thought that, because back then I thought that.
Oh, no, again, you need to tell us the truth.
Yes.
All right. In order to sit as a juror, you have to presume someone is innocent.
Okay.
Not that they have to convince you that they're innocent. You have to presume they're innocent
Yeah.
and believe that and wait until, and if the state can prove that they're guilty beyond a reasonable doubt. Do you think you can do that in this case, or would you have that lingering?
I don't think I'd have that lingering in now, years later, but at the time when I heard the case, that's where I kind of, you look at something and you're kind of like, wow, that's messed up on the whole situation that happened.
Right.
But I can block that out, but I just don't want to just pretend like I never had a feeling of that, because that's not fair to him. You know what I mean?
Correct. No, you're doing the right thing, which
Yeah.
is by telling us. Do you have any doubt in your mind that you could sit as a juror in this case and presume him to be innocent?
Yeah, if I got the information on everything that happened. And I think I've grown up a little bit as from years ago. Kind of don't really pay too much attention to the news anymore.
Okay. State, just on this sole issue, I'm going to send her, yeah.
motions at this time, Judge.
Do you have any questions at this time on this sole issue?
No.
Okay, let me see the attorneys at sidebar. We'll be right back.
No, Your Honor, I apologize.
I'm sorry? All right, ma'am, I'm sorry. All right, I'm going to need you to come back at 1:30 for more questioning. I appreciate your candor.
Okay,
I
that's
want you to
fine.
think over the lunch hour about whether you have any doubts about your ability to sit as a juror, but we'll call you back in. In the meantime, don't talk about the case, don't read anything. You know the rules, all right?
problem.
We'll see you
Thank
back
you.
at 1:30 outside the courtroom. The deputies will direct you
Okay,
at that time. All right, thank you. Juror in seat number 30, who's juror number 241. Hello, ma'am. How are you?
Good, how are you?
All right. I'm just going to ask you a couple of questions. Just be honest with me. Don't worry about what the answer is. I'm not looking for one answer or another. I just need you to tell the truth, okay? You indicated that you'd heard about this case. How much have you heard?
So I was in school when this
I
happened.
can't hear you. I don't know if the mic's not on or it's just not near enough to your...
I was in school when this happened, so it was talked about in most of my criminology classes, if not all of them. So I'm pretty aware.
Okay. So this actually became a topic of discussion in your classes?
Yes, ma'am.
And did you follow any of the news coverage?
Yes, ma'am.
Okay. And have you followed it since the original arrest?
No, ma'am.
But
I
you said...
have not followed it since, I guess it kind of went on the wayside, and then I got called here. I haven't.
Okay. When you got your jury summons, did you follow, before you came to court, and I told you not to, did you look at any stories or anything?
No, ma'am.
Did you talk to anybody about it?
No, ma'am.
You said you'd formed an opinion as to his guilt or innocence.
Yes, ma'am.
What is your opinion? You need to get that mic near your mouth so we can hear you.
I think that, I guess,
I can't hear you, ma'am. I'm sorry. I know you're having trouble saying, I just need you to tell me the truth. Do you have an opinion as to whether he's guilty or not?
yes, ma'am.
What is it?
Guilty.
You think he's guilty?
Yes, ma'am.
All right. Jurors are required to be able to presume him to be innocent at the start of the trial, and until and if the state can prove he's guilty beyond a reasonable doubt. Do you think you can do that, or would you be sitting there thinking, I think he's guilty?
I would be sitting here thinking that.
That he's guilty? Okay, thank you. State?
No objection, Your Honor.
All right, thank you, ma'am. I very much appreciate your honesty. We all do. You are excused as a juror in this case. This isn't the case for you. Thank you for your service. Have a good day. That was juror in seat number 30, juror 241. And lastly, juror in seat 32, please. Hi.
wanted to tell you, you look better in person than that picture that's on the screen downstairs.
Thank you very much. You talking about the picture down in the jury room?
Yeah.
That was taken many years ago, but thank you. I'll keep that in mind.
Okay.
How are you this morning, or this afternoon now?
Nervous, I guess.
Yeah, this is a little nerve-wracking for jurors. Just try and relax. Just tell me the truth. We're not really looking for one answer or the other. We just need to know the truth. You indicated that you'd heard about this case. How much have you heard?
What have I heard?
How much have you heard?
I'm a news junkie.
I forgot I turned my mic down. You're a news junkie?
Yeah.
So you've been following it?
Yeah, I didn't this weekend. We have a little house in Crescent City, and I went there and decorated for fall so I could keep myself busy.
Yeah, plus now you can't. You've been ordered not to. But prior to that, were you following it all pretty closely?
Yeah.
Have you formed an opinion as to whether Mr. Loyd is guilty or not?
I have cop friends, and Debra Clayton was a sub at Dr. Phillips High School, and I taught there.
Okay, so you knew her personally?
Correct. No, I wasn't friendly with her. Just we knew that,
All right.
it was one of our SROs.
Do you believe, jurors have to be able to presume that Mr. Loyd is innocent until and if the state proves he's guilty beyond a reasonable doubt. Do you believe you can do that?
No.
All right. State?
No objection.
Defense? All right, ma'am. Thank you so much for serving and for your honesty. Your discharge as a juror, I don't think this is the case for you. Your discharge as a juror in this case, you're free to go. Have a good day. That's it for folks in the jury room, right?
That's correct, Judge.
All right, we're going to take a lunch recess until 1:30, and then we'll resume questioning the 10:30 group. By then, the 1:30 group will be here, so it's going to be a long day, folks. Court's in recess. Rebecca, you in room 1? Okay, thanks. All right, we're back on the record on State versus Loyd. Mr. Loyd is present with his attorneys since this morning. Mr. Loyd has been wearing the same clothes. He's got a black button-down shirt, dress shirt. He's got on dress pants. He is wearing jail shoes and he's shackled, but his feet are underneath the table and cannot be seen by a jury. Count 5 in this case was not severed, correct? Okay. All right. We got jurors? Okay. All right, let's bring in the juror in seat 14, juror 6094. He's from the 9 o'clock group. He was just late this morning. Morning. Or
Morning.
Good afternoon, actually.
Oh, yes.
Hope you had a good lunch. Did you see anything or hear anything about the case at lunch?
No, ma'am.
All right. We're going to be asking you some more questions. The important thing to remember is we're not looking for a specific answer. There are no right or wrong answers to these questions. There's just what you believe and what you think. Okay? So let me start with, you indicated that you'd heard something about this case. Is that correct?
I saw the news reports when I believe it was 2017.
Back when it happened?
Yes, ma'am. When they were showing live footage on the news.
How much did you see?
Not too much, maybe one report's worth.
Okay. And do you remember anything about what you saw in that report?
There was footage from a Walmart, and they stated that the suspect was what had happened, what he had done. Didn't hear too much about what had happened the days before, what had led up to the incident, but not enough for me to make a profound statement about what to judge or anything.
And since then, you hadn't seen anything or heard anything till you came to this courtroom?
Maybe once or twice. Not really on the news, though, just in passing, talking to people.
Okay. Do you take a wild guess how many conversations you had about this case?
2 at most.
Did you overhear other people talking about it or read stuff or anything else?
No, ma'am.
Based on all of that, have you formed an opinion as to whether or not Mr. Loyd is guilty?
I can't, no, ma'am.
All right. The law requires jurors to presume him to be innocent until and if the state can prove he's guilty beyond a reasonable doubt. It's just the law. You think you can do that in this case?
I believe so, yes, ma'am.
Any doubts in your mind about your ability to do that?
No, ma'am.
All right, can you tell me your feelings about the death penalty or your beliefs about it, please?
I believe it has its place in the right cases, but I'm not against or for it. I don't have any prejudice towards the death penalty.
Okay. Do you have any belief that in some cases the death penalty should be automatic?
No, I can't say.
So if you're chosen as a juror in this case, and if Mr. Loyd was convicted of first-degree murder, that's when the decision about the death penalty comes into play. So here's what happens. There's a penalty phase. Both sides get to present evidence. The state's going to present evidence of aggravators, reasons they believe death is the appropriate sentence. Defense is going to present evidence of mitigation, reasons they believe that life is without the possibility of parole is the appropriate sentence. You with me so far?
Yes, ma'am.
All right, you have to be able to sit there and listen to it with an open mind, listen to all the evidence. Then you go back in the jury room with your fellow jurors. You must determine that at least one aggravator has been proven beyond a reasonable doubt before you can even consider death as a possibility. But let's say that you determine that. Now you've got to weigh aggravators and mitigators. You go through your process. It's a group process, but it's also fundamentally an individual process. You're weighing those out, and in the end, you have to decide whether or not you feel life or death is the appropriate sentence. Do you think that you could do that with an open mind?
I believe so, yes, ma'am.
Do you think you would be predisposed towards one sentence, or predisposed towards death because it was a police officer who was killed?
No, ma'am.
Do you have any qualms about imposing a death sentence? And qualms is probably not a good term, but do you have any doubts that you could do it?
No, ma'am.
Do you have any doubts that you could impose life if that was the appropriate sentence?
I don't.
All right. As I indicated to you all, Mr. Loyd has raised the defense of insanity. And I gave you a very brief rundown of what is involved in that. Do you have any immediate reaction to listening to evidence about an insanity defense?
No, on the contrary, I'd like to hear all the evidence.
Okay. So it's something that you could listen to and weigh and reach a verdict on?
If that's the case that's trying to be proven, yes, ma'am.
All right. Thank you, sir. I don't have any other questions for you. State, you may inquire. I'm sorry, just for the record, you are juror 6094, is that correct? All right, thank you.
Good afternoon, sir.
Good morning. Afternoon.
From based on what you just said, you indicated that the death penalty has its place in certain cases. So based on that, I'm gathering that if the jury found the defendant guilty of murder, you were asked to consider the proper sentence in this case. If the evidence convinced you that death was the appropriate sentence in this case, in your mind, could you vote for that?
Yes, sir.
And if, likewise, if the evidence convinced you that life was the appropriate sentence in this case, could you vote for that also?
Absolutely.
Now, the judge earlier indicated about the aggravating factors, and those, again, are factors that may make the death penalty more appropriate in a certain case. They are limited by statute. The judge will tell you what the aggravating factors you're allowed to consider. Can you confine your focus just on those aggravating factors the judge tells you is permissible to consider and not look at anything else?
Yes, sir. That would be fair.
Okay. As far as mitigating factors are concerned, they can be pretty much anything. Can you come into this process with an open mind and consider any mitigating factors that are presented to you?
Yes, sir.
Okay. Now, this isn't the time for us to talk about any of the details or evidence that you may hear regarding aggravating factors or mitigating circumstances. So I'm going to just ask you some general questions about those factors. Do you think that Mr. Loyd deserves to have a jury who will remain open-minded and truly consider any and all mitigating factors that are presented to you?
Absolutely.
Okay. Even at first blush, if you heard something that was a mitigating factor, and at first blush, without hearing any evidence about it, you thought, well, I don't know if that's really important. Can you hold off your judgment on that until you hear all the evidence surrounding a mitigating factor to actually make a decision?
Yes, sir.
Okay. So if I were to stand here and rattle off 100 different mitigating factors, are you telling me that you would truly consider each and every one of those before making your decision of what the appropriate punishment in this case would be?
I think it's only fair. Each one is weighted.
Okay. Do you have any, I'm not going to ask for detail about it, but do you have any religious or moral beliefs that might interfere with your ability to vote for death in this case? Some religions have that concern. Do you have any concerns?
No, sir.
Okay. If you're selected for this jury, you may be put in a position where you're back in the deliberation room talking amongst the jurors about the evidence, about the law, and expressing different viewpoints amongst the 12 of you. Would you be able to listen to other people's viewpoints and consider those viewpoints and maybe forming your own decision?
I think that's the best way an intelligent viewpoint can be gained. Listen to all the sides.
Obviously, no one would tolerate bullying or yelling or screaming or anything like that, but do you feel that sometimes disagreement and different ideas are productive in a conversation?
Sometimes.
Okay. Are you willing to consider other people's viewpoints, even if they might not agree with you, and maybe reconsider your position if they bring up something you didn't think of?
100%.
Okay. The judge indicated that if a vote for death must be unanimous, okay? If any one juror feels that life is the appropriate punishment in the case, the sentence in this case would be life, okay? If the jury unanimously comes back and says death penalty is appropriate in this case, everyone's going to know you voted for it. Okay. If you're back there and you determine after hearing all the evidence and all of the law that death is the appropriate punishment, are you able to come back in this courtroom, raise your hand, and tell the judge that this person deserves to die for what he did?
Overrule.
Well, it sounds like at that point I've already made peace with it, so I would be.
Okay. I'm going to ask you a few questions about insanity. The judge explained to you some of the factors surrounding that as well. Because the insanity defense has a component of mental health, I'm going to ask you a little more personal questions. And I don't mean to pry, but I think you probably understand why I need to ask those questions. Do you or any close friend or family member have had any experience with a mental health issue?
A family member, yes, sir.
Okay. Did that person seek treatment?
Yes.
Okay. And is that person doing better as a result of the treatment?
That and other factors, yes, sir.
Okay. So I'm assuming because you've had some personal experience with a mental health issue, do you believe that mental health issues are real in society?
Absolutely.
Do you believe that if someone simply says they have a mental health issue, that's always the case?
No, sir.
Would you be able to listen to all of the facts and evidence surrounding a mental health issue in an insanity defense before you come to a decision of whether or not insanity is an issue in this case?
Yes, sir. I think that's needed.
Is there anything in your life, your background, that you think we need to know about that will determine whether or not you would be a good juror for this type of a case? And before you answer, I'm looking forward, maybe some jurors may have had the death of a loved one, the murder of a loved one, which could obviously be an issue in a case like this. Anything like that in your background?
I've seen death, but I don't think seeing that is going to be my greatest asset in this case. I think, well, maybe it did. Maybe it helped me have my open mind. But I think that's going to be the best factor in this kind of case. Be able to see all the evidence without prejudice.
So bottom line, this ultimate question: can you reserve judgment and consider all the evidence in the case before you make a decision?
Yes, sir.
Thank you, sir.
You're welcome.
Thank you, Mr. Brexton. Mr. Lenneman, you may inquire.
Good afternoon, sir. How are you?
Great. How about you, sir?
Great, thank you. What kind of work do you do?
I work for Lockheed Martin. I'm a mechanical engineering technician.
Now, you said when you were talking about the information you had heard in the news, that it was not enough of a profound statement.
That's correct.
What does that mean?
Honestly, the only thing I can remember is that the reporter had said Mr. Loyd was on the run after killing one of the deputies. and I didn't see it. The only thing I had was this woman's words to go off of, and it just wasn't enough for me to make a judgment call.
When you see the woman's words, you mean the newscasters?
Right, yes, sir.
Have there been situations when you've heard enough in the news to make a profound statement?
Not too often, because I usually just don't, I'm ashamed to say I don't keep up with it enough, because it doesn't affect me really. But I guess there was one case, probably when the Casey Anthony trial was the only one that I can remember that was on TV enough and around enough places for me to see the court proceedings and enough of the evidence for me to kind of base a judgment towards that, but still not with 100% certainty.
Right. So you have made judgments on things when you've heard facts in the news?
Partial judgments, yes, sir.
Okay. Do you always believe the news?
No, sir.
Do you think I should be concerned that you have made a decision based on the news alone? You're saying Casey Anthony case.
I only said that just to say that that was the closest I've ever come. It's not like I was ready to condemn her one way or the other.
And it was based on everything you heard in the news?
Right, yes, sir. Seeing the court proceedings. Yes, sir. That's what I'm pertaining to, yeah. There were actual court proceedings.
Okay. Now, I think you said you were talking to some people about this case?
Not exactly this case, and nothing recently. This is only within the past 4 years that this has been going on. I've heard it, or he's come up in conversation maybe twice, and I'm probably exaggerating with that.
Do you remember what the conversations were?
Absolutely not.
You consider yourself someone who becomes emotionally connected with a feeling like anger or hate when you see something on the news that disturbs you?
No, I think that's just a part of me getting older. I've detached from that.
So there was a time you had that in your life and you don't no longer?
Oh, sure, in my 20s, yeah.
And what do you account for that not being in existence now?
Probably certain people leaving my life. Part of growing up, I guess, you lose, honestly, it probably happened after I lost my mom to cancer. Seeing her suffer and things just, I'm not as quick to come to a conclusion anymore.
Judge?
Right.
Now, you heard that this case involved the issue of insanity. And one of the issues, or one of the things you would hear if you were on this jury would be the instructions from the judge on insanity. And one of the issues is essentially that if Mr. Loyd was found not guilty by reason of insanity, then it would be the judge's decision on where to sentence him in terms of the hospital, or confinement, or otherwise. That's the rule. In this case, you heard the judge tell you that Mr. Loyd has been convicted of first-degree murder of Sade Dixon, his girlfriend, and the unborn child that she was carrying. And so this information is part of it. How do you think that's going to affect your thinking, not in the second part of the case, but in the first part of the case, when we're dealing with guilt or innocence?
Well, it's definitely something that my mind is going to recall to, and I'm going to try to find factors as to maybe why, but it won't be the main focus.
And I know we're asking you a lot of tough questions, and only you can answer them. But when you say it's not going to be the main focus, is it going to be something that you factor in to your decision on the guilt or innocence of Mr. Loyd?
I think I'd be lying if I didn't say I would weigh it in partially.
Okay. Judge, can I come sidebar?
I need to ask him. Yeah, let me see the attorneys at the bench. Thanks. All right, sir, let me give you some, I'm sorry. I always forget you have to get back to your seat. Let me explain something to you. You were told that Mr. Loyd was convicted and sentenced to life in the Miss Dixon case. That information cannot be used by you to determine guilt or innocence in this case, all right? It's used for a different purpose, and that will be explained to you during the trial. All right, you understand that?
Okay, yes, ma'am.
All right, go ahead, Mr. Lund.
Now, I know this is tough because you want to follow the law. You want to do what's right. We have things that happen in our life, prejudices and so forth, that some people can't put aside.
I'm sending
even when
you
they're
email.
told they have to follow the law. We want to follow the law. Now, a few minutes ago, we talked about this issue where you said you would have a hard time removing it from your decision-making process, the fact that he was convicted.
Well, not necessarily a hard time. It would be in my mind, is all I mean by that. It would not guide my decision towards a verdict in this case. I didn't want to put a heavy factor on that. It would be in my mind, is all I meant.
So is that what you are saying that you said earlier?
Yes, sir.
Okay, even though you didn't use the same word?
My terminology, but that is,
How would it be in your mind? What would you be thinking?
maybe just, I would have to look at evidence and determination on it.
What about if you heard from Mr. Loyd? You get to consider things that require prior felony. If you get heard from other families, and they're telling you things about this, would you be thinking about that? As you listen to other people talk about Mr. Loyd?
Not necessarily the charges, but probably his frame of character would be what I would be listening for.
And because, other than this issue which we just talked about, these prior convictions, you would have no other information about his character. You would be using that when you're listening to the other people talk, right?
Well, I'd have to use what the other people, what they stated as witnessing. That's all I would have.
Well, my question is, are you going to be using the other fact that he's a convicted felon? Thinking about that.
Well, I can't. I don't.
I want to talk to you about the death penalty a little bit.
Okay.
You heard that Mr. Loyd was sentenced to life without possibility of parole.
Yes, sir.
What do you think about that as a sentence?
I think it's devastating.
You think it's as serious or more serious than the death penalty sentence?
Personally, I think it's more serious.
Why?
Because then the individual has an entire lifetime to live with that, the sentencing versus going on to death row. It's it's shorter than a life sentence.
And you were asked a question, I think, by the judge, but you say it. Your thoughts on the issue of automatic death. If someone
Mr. Lenneman, I need you to stop. Mr. Lenneman, Mr. Lenneman, Mr. Lenneman, I need you to stop for one moment. Let me see the deputy at the bench, please. Hold on one second. This has nothing to do with any of this. I'm sorry, folks. That had nothing to do with any of this. Go ahead, Mr. Lenneman.
So you were talking to the judge about your thoughts on the automatic death penalty. And you understand that that would be you knowing that someone committed the offense, first-degree murder, not an accident, not an excuse, actual first-degree murder. Are your thoughts still the same?
No, I think, I couldn't say there'd be an automatic death sentence in this case.
Well, that's what I'm asking.
Right. No.
I think you said that before on this case, but do you think that there is a case that once you hear the facts, that there could be an automatic death penalty. There's no excuse, it's first-degree murder. You've heard the facts, it's premeditated. Is there a case that could be?
Maybe hypothetically, I'm not sure. And didn't Texas instill some law where there's a certain amount of eyewitnesses that it is an automatic death penalty?
Now, this is a question for you personally. It's you personally
Yeah.
making a decision in your mind that there should be an automatic death penalty in certain circumstances. And I'm asking you, if there's a first-degree murder case and it's premeditated and it's not an accident, and there's no excuse, would you find any first-degree murder case to be automatic in your mind?
No, I don't think so. No.
Why is that?
I just don't like that thinking where it's just automatic. Everything should be laid out and taken into account.
But what kind of things do you think are important to take into account?
I'm not sure. All the evidence, the testimony, I'm not sure. I'm willing to listen to all the sides, though. You know, I deal in a field where we have to pay attention to everything, many different variables, and this is a very dynamic atmosphere.
Now, you have said there are death penalty has its place in the right cases. What are those cases? Objection, Your Honor.
Sustained. Rephrase.
You had indicated there are certain situations. Objection.
Sustained. Rephrase.
That situation would be...
Hold on, sir. You can't answer the question.
Objection.
Sustained. Rephrase.
Now, you had talked about how you think it's important that jurors converse.
Right.
And you were talking to these gentlemen here.
Yes.
That gentleman there.
Yes, sir.
Okay. Do you understand that the law is, in this state, there's instruction, jury instruction, that decision decide that
Yes, sir. That's what the judge said.
So if you believe that the death penalty is not appropriate, would you listen to someone else and change your mind?
I think that's a hard question to answer. I can't answer that without hearing the argument.
So you think it's important to have an argument about your opinion in regards to the death penalty?
Yes.
Why?
I feel like I'm getting lost in the question here. So are you saying, you asking if I could be dissuaded from having a staunch want for the death penalty?
Or for not the death penalty, either way.
I'm willing to listen to any argument either way, but I'm not going to have a prejudice towards voting for life or voting towards death.
Okay, and that's not really what I'm asking. I just want to make clear. Let's go through some of the things.
Okay.
Death penalty statute consists of, number one, the state has to prove at least one aggravating factor. The jury unanimously has to find.
Right.
You follow that?
Yes.
Okay. So the next step is making a decision what the aggravating factor is. That's an individual decision. You don't have to agree with them or disagree with them, you talk with them, or whatever. The final decision on what the aggravating factors are yours. If you make a decision on what the aggravating factors are, and you have a belief in that, are you going to let someone change
could, because I think beliefs are dangerous in that aspect. I think a good idea is much better.
Okay, so now let's go to the second step, or third step. Now you get to review the mitigating circumstances that are placed before you, okay?
Right.
You have to make that decision on the mitigating circumstances on a lesser degree than reasonable doubt. With lower threshold, you individually have to make it. If you do that.
100%.
Okay. Now, there are certain mitigating factors that you may be asked to consider. And I'm going to generally talk about some. They may not have anything to do with this case, but I want generally an idea. There may be a generally raised schism is considered a possible mitigation.
Right.
Could you consider something like that?
I could.
Okay. Now, mental health. Something to do with mental health may be possible. Could you consider something like that?
Yes, sir.
Okay. Someone who has possibly rated, is that a possible mitigating circumstance?
Yes, sir.
Trauma. Trauma in the life. Could you consider that?
Yes, sir.
Okay. So once you go through the mitigating circumstances, you get to decide which one exists in your mind. First, they have to be proven. If they're proven, you have to give them some sort of weight. Could be a little weight, could be a lot of weight. You get to make that individual decision. Okay? So remember, you're doing this as an individual, not a group. Certainly, you can talk amongst yourselves about this. This is really an individual decision making.
Yes, sir. Is there deliberation every day with the jurors, or is that only at the end?
Jurors deliberate until they reach a verdict. And it's not every day. It's at the end of the guilt phase, and if necessary, at the end of the penalty phase.
Okay.
Other than that, you're in the courtroom listening to.
Okay.
All right?
You got that?
Yes, sir.
Okay. Now you've done the mitigating circumstance. Wait for now. The next thing you have to do is you have to weigh the mitigating circumstances against the aggravating individual decision. There may be one of each that may be so weighty to you that that's enough to outweigh the other. There may be collective decisions that you see a bunch of stuff on one side that weighs heavy to you. Whatever it is, you make a decision on what it weighs. Understand? Individual decision.
Yes.
It's your decision.
Right.
Okay. Now, once you make that decision, you have to decide then whether first mitigating outweigh the aggravating. Okay?
Okay.
If they do, life is the only sentence. You understand?
I do.
If the aggravating circumstances outweigh the mitigating circumstances, then death may be a sentence. You understand?
Okay, I'm getting a clearer picture. Yes.
Okay. So now you've done all that, and then you have to step back. You have to make an individual decision. No matter what the finding is, if it's mitigating outweighs aggravating, you're done. You were done already. But if the aggravators in your mind outweigh the mitigators, then now you're in a position of decide whether death is the appropriate sentence.
I see.
That is an individual decision too. Collectively, if all 12 agree, then that is the verdict. If one person decides that that is not appropriate, even if they feel the aggravating circumstances outweigh the mitigating circumstances, the law says you are never compelled to vote for death under any circumstances. So that's something that's always in play with you. These are all jury instructions you will get. You follow me?
Sir.
Okay. So now we're in that situation. Everyone has made their decision. I don't know what the process is, or you can talk, or verbalize what it is, but you don't have to. You can all just vote your conscience and your belief and go about your business as you understand.
Yes, sir.
So it's not necessary to talk, and if you think it's important, that's fine. That's up to you. Okay?
Okay.
The most important question I have for you is that if you have a belief in something, and it's a strong belief, I know you had talked about, you think, communication and discussion are important, but if you have a strong belief, and you don't believe it's going to waver in any way, form, or fashion, would you maintain that belief?
I would. I have to hold on to my convictions.
Okay. Now, do you think it's fair, whether it's death you voted for, life, do you think it's fair that someone is going to come to you and say, you're wrong, I want you to change your opinion, you need to do this, you need to do that. Do you think that's fair?
No.
Okay. That's called bullying. Would you agree that if you were not asking for bullying,
100%.
okay, and if you see someone else, whether they're going to life or death or whatever, being bullied, would you stand up?
Absolutely.
Those are all the questions I have, Judge.
All right. Thank you. Either side have a motion at the bench? Or you good?
I still maintain my previous, do I need to come sidebar?
No. Anything from state?
No, Your Honor.
All right. Same ruling. Sir, we're going to need you to come back for a third session. All right.
Okay.
We have a package for you this time. It's a jury sequestration packet. Remember I told you the jury would be sequestered?
Yes, ma'am.
So if you're picked for the jury, you're sequestered that day. So you have to engage in the activity of packing for jury sequestration before you show up for the third time.
Okay.
Leave your suitcase in your car. Don't bring it into the courthouse. If you're picked for the jury, the deputies will escort you out there to get your belongings. If you're not, sorry, you'll have to go home and unpack. But you need to pack, all right?
Okay.
The jury sequestration package gives you a lot of information about what it is to be sequestered as a juror.
Okay.
We're also giving you a letter for your employer and a slip of paper giving you a phone number to start. Don't start calling before Thursday. You're a purple dot now.
Okay.
We're going to put a purple dot on your badge so you remember. And when you hear the purple dot group is to report on such and such a date, that's when you come back. We don't know.
Oh, so we don't
may
know.
not know right now.
Okay.
Okay, so as far as I have, my notes say you didn't have any vacations or trips or anything planned this week. So
No, ma'am. I had a friend coming into town this weekend, but I'm staying in town. It's not.
enjoy being with your friend. We're not going to call you back before next week.
Okay, so I'm going to work tomorrow and.
Until Thursday.
Okay.
And then start calling every day.
Okay.
All right? Any questions about that?
No, ma'am. I don't believe so.
Thank you so much, sir. We appreciate it. You're free to go today.
Okay, great.
Remember,
Thank you.
no news stories, no talking to your friends. Walk away if somebody tries to talk to you.
No worries.
Thank you.
Thank you.
I'm sorry, before we call in,
It's working fine on mine. Are you spelling it correctly?
What job are you in? Are you in Markeith? EM section?
Are you in the correct session?
oh, okay, I was going in under Rebecca.
Nope. All right, try it again. Nope. Is that a laptop? Bring your laptop here, Mr. Moran. Yeah, stuff like that. Yeah, that's it.
That's it? Okay, this is October 9th.
No problems. All right. Let's bring in the juror in seat number 15, who is juror number 232, He's from the first panel. He's also from the 9 a.m. group. He was late this morning. Good afternoon.
Good afternoon.
How
Good
are
afternoon.
you? All right, sir, welcome back. Any problems at lunch with anyone trying to talk to you about the case or hearing anything you weren't supposed to? All right. Let me start by telling you that there aren't any right or wrong answers to these questions. There's just what you actually believe or think. And that's all we want to hear from you. Okay. You heard something about this case, you said?
I saw it on the news
When did you see it?
when everything first happened.
So back in 2017?
Yes.
How much did you see?
Probably everything that aired on Channel 13.
So you watch Channel 13 pretty regularly?
Yes.
And do you still watch the news pretty regularly?
Yes.
Have you heard anything about the case since the time it originally happened and the time you came to jury duty last Friday?
Just that they, starting jury process.
Okay.
That's all.
What do you remember about what you heard on the news?
I remember that they were saying he had shot his girlfriend and the baby. And he was on the run. And then I was told that, I saw that when he had shot the deputy. And then I saw the actual footage when he was arrested. And the officer kicked him in his eye. So I
Okay.
saw that on Channel 13.
All right. So you saw quite a bit.
Yes.
And after that, did you see quite a bit more over
Yes.
the years?
I watched Channel 13 because I need to get the weather. I have a lawn service. So that's how I kind of plan my day.
Okay. So based on all of that, have you formed an opinion as to whether or not Mr. Loyd is guilty or not?
I didn't form an opinion. I just knew what the officers did to him. They should be held accountable for it.
Okay.
Because he was, laying on the ground with his hands out, and they just came up and started kicking him in the face.
Okay. That fact that you're talking about is not relevant to the issue of whether or not Mr. Loyd is guilty of the charges he's facing now.
I understand.
So, and I understand your position. Do you think that, it sounds as if you're pretty angry with the police about what happened.
Yes.
Do you think that you could put that aside and just focus on the charges he's facing and whether or not the state has proved it beyond a reasonable doubt?
Yes, I can put that to the side.
Okay. And then if he was convicted of first-degree murder and there was a penalty phase, you now have to make a decision about life without the possibility of parole or death. Do you think you could put what happened with the police officers aside, or do you believe that would be influencing you?
No, I think I can put it to the side.
Okay. You had some concerns initially on Friday about your ability to be fair, correct?
Yes.
And what were those concerns?
Well, I knew one of the witnesses.
What witness?
And so on Friday, I was basically trying to get out of it because I need to go to work and various things like that. I have a case going on with the insurance. I was in an accident the end of June, so I'm trying to get that settled.
Okay, so you got a lot going on.
Yes.
All right, the witness that you know, which witness was that?
It was Richard Roof.
How well do you know this witness?
We grew up in the same neighborhood together.
So are you all close? Do you socialize together?
I haven't socialized with him in a while. When he went out to the military, and then he came back and was working with the force. I would see him out on duty sometimes.
Okay. So if he took the stand to testify, you know, there's a jury instruction that says that, yeah. It's whose father? Okay. Do you know the dad or the son?
The son.
Yeah. So who's testifying? The son or the dad?
I'm sorry, can you speak up a little bit?
Is the person that you know to be, the roof that you know, does he work for FDLE, Florida Department of Law Enforcement?
I don't know exactly who he's working for. He was an officer with OPD.
How old is he about?
He's 50, 51, 52.
Well, let's say it is the son, not, you know, or that you know the son and it's the dad. It's the Roof family. Is that
Yes.
going to influence you? If they take the stand, you have to weigh all witnesses under the same rules, okay? You can't give one witness more credence than another. You got to go through the rules we give you to weigh testimony of witnesses. You can believe or disbelieve any witness you choose, but everybody takes the stand, you know, starting out equal, okay?
Okay.
Do you think you can do that, or would you be thinking, yeah, I know these folks. I believe what they're going to say?
I can do it.
Okay. Tell me about your job. What's the problem with your job?
Well, I have two jobs. I work at the airport for Avis, delivering rental cars, and I have a landscaping business.
Okay. So if you're in here for 3 weeks, are you getting paid at those two jobs?
No,
Can you afford to pay your bills if you're not getting paid?
no.
Any objections from state?
No objection.
State, defense? You can. All right, sir. I don't think our notes, I'm sorry. All right, sir, I don't think our notes reflected that you weren't going to get paid, so I'm going to excuse you as a juror. Thank you very much. We appreciate you coming in, but you're discharged. You're free to go.
Okay, thank you.
Thank you. Good luck to you, sir. All right. Next up, I have, let's bring back the juror in seat. Wait a minute. Seat 21, please. She's returning for additional questions. Welcome back, ma'am. You're juror number 45, correct?
21. I mean, 45, yeah. I'm
Yeah,
sorry.
your seat's 21. There's too many numbers, I get it. All right, did you have a good lunch?
Yes, thank
Did you have a chance to think about everything you know about the case and whether or not it would influence you in making a decision in this case?
Yeah, I don't think anything like I was telling you in the past, whatever, when I was watching it in the beginning. I don't think it'll influence anything on a decision.
Okay. And you did say that you originally thought Mr. Loyd was guilty when you were watching
Yeah,
that.
when I watched it on the news.
Have you heard or seen anything that would change your mind about that?
No, I don't really watch the news much anymore.
Okay. So as I told you, you've got to start believing that he's innocent.
Mm-hmm.
Can you explain to me how you went from thinking he was guilty to believing he's innocent now?
Well, a lot of the times I've learned certain things on the news they over exaggerate on certain things. So I kind of don't really like go by what they say as the truth, kind of. But back then I would kind of watch the news and think it was.
I'm sorry, the mic's going lower and lower, and I'm having trouble hearing you.
I said back then I kind of would watch the news and just kind of get sucked into everything that they would tell you. But now I don't really pay attention. But honestly, I do have a heart, so I kind of feel sorry for people.
So who do you feel sorry for in this case?
I don't feel sorry for anybody right now, but I do have a soft heart, so I can't like make a judgment on somebody. You know what I mean? Like I can't make a judgment on somebody because I feel sorry for it's kind of weird, but I feel sorry for, I see like different parts of, it's hard to explain.
So you're a sympathetic person or an empathetic person?
Yeah, like I kind of look at all the different angles of each side.
All right. So your job as a juror in the guilt phase, determining whether or not Mr. Loyd is actually guilty of the charges that have been brought against him, is to listen to the evidence, to the end of the evidence. You have to listen to everything before you make a decision. And then, and this is a very brief description of your job, you have to determine whether or not the state of Florida has proven beyond a reasonable doubt that he's guilty of the charges. If, based solely on the evidence you heard in this courtroom, you believed him to be guilty, could you vote guilty?
Yeah, I could, but I'll be honest with you, like I've never been on a jury before. And like, since I was here Friday, I kind of thought about it and I was like, I'd feel bad putting somebody's life in my hands, kind of making that decision for them. But that's just, like I said, because I have a heart for everybody kind of thing.
Well, it's not supposed to be easy. I mean,
I know.
jury duty is tough, and we recognize that, and we want jurors to take their job very seriously. And in a case like this, if you reach the penalty phase where you have to decide between voting for life without the possibility of parole or death, yeah, that's pretty serious, and we want you to take it seriously. So let's assume you've gotten past the guilt phase. You're in penalty phase now. State's going to present evidence of what are called aggravators, reasons they believe the death penalty is the appropriate sentence. Defense is going to present evidence of what's called mitigators, reasons they believe life without the possibility of parole is the appropriate sentence. Would you be able to listen to both sides with an open mind?
Yes.
Okay. And in the end, after you go back into the jury room and you're weighing these aggravators and these mitigators, you believe that the appropriate sentence is life without possibility of parole. Would you have a problem voting for that?
I wouldn't have a problem doing the right thing. Just the only thing about me is like, I probably after the fact, whether it was whatever I decide, if it was something where I had to make a decision where somebody was guilty, I would probably have I would feel bad.
Okay. Well,
I mean, I'm just being honest.
So could you vote for life without the possibility of parole?
Could I, if that's what I had to do?
Well, if that's where the evidence took you, is that what you would do?
Yes.
And if at the end of all of it, you believed that the appropriate sentence was death, could you vote for death?
I could do it, but I'd probably still feel bad.
Okay. Mr. Loyd has raised what's called the defense of insanity. I kind of briefly explained that to you all. Is there anything about that defense that would cause you to say, I'm never going to listen to testimony about that, I can't accept it?
No.
Would you be willing to listen with an open mind to the testimony and make a decision based on the evidence and testimony in the courtroom?
Yes.
All right. Thank you, ma'am. I'm going to turn this over to the lawyer state.
Oh, I thought I was done, sorry.
No, you're not done, sorry.
Good afternoon, ma'am. Generally, what are your feelings about the death penalty?
I mean, I feel bad for anybody who gets it, but then we all have to, I guess, accept our responsibilities for our actions. And we know that there's a possibility for anything that we do, just like if we speed.
Do you think the death penalty is an appropriate sentence in certain types of first-degree murder cases?
I mean, I would never want to wish death on anybody, but I mean, legally, if that's what has to happen.
Well, it never has to happen. You're never required to vote for the death penalty.
Okay.
That's up to you. That would be an individual decision for you to make if we got to that point in this trial. Knowing it's an individual decision that you have to make, and you don't have to vote for the death.
Okay.
Can you envision any situation or any set of facts where you would vote for the death penalty?
I mean, the only thing I could think of that anybody would deserve the death penalty would probably be taking another life, but I mean, still, I don't feel like I should, you know, be the one to do the same to somebody else.
Okay. So
Kinda. It's kind of weird.
you just said that you don't feel that you could be the one to vote for the death penalty and potentially take somebody's life based on that vote.
Like, I don't feel like, I don't like consciously, like I would feel like bad.
Okay.
You know what I mean? It's like, I'm a forgiving person. So like, even if people have done things to me, I don't like hold it against them or whatever. So I can be a tough person, but then at the same time, I have a soft heart.
Knowing that you would never have to vote for the death penalty, and I'm not going to ask you what the circumstances are,
Yeah.
but can you see a set of facts in your mind that you would say, this case deserves the death penalty and I am willing to vote for it, despite feeling bad about it?
Yeah, I would do what needs to be done, what the right thing is to do. You know what I mean?
Okay.
Like if the evidence shows it and that's what my job is to do as being a juror, then I would go with it. But the only problem I have with it is, like I said, my heart. You know?
You mentioned that you would do what needs to be done, and if it was your job as a juror to vote that way. You understand that your job as a juror would never be required for you to vote that way. It's always up to you.
Okay.
You'd never need to vote for the death penalty. It would have to be a decision you made after looking down into the depths of your soul, the heart of your hearts, listening to all the evidence in the law. Do you think that's the right sentence in this case if we got to that point?
Okay.
Looking into down into the depth of your soul of whether you could do it, would you be able to, if you looked at the evidence, and if you thought that the death penalty was appropriate, considering all of the evidence, looking down into your heart of hearts, would you be able to walk into this courtroom, raise your hand, and say, this man deserves to die for what he did? Now, it's one thing to ask that question if you're hanging out with family and friends outside of a courtroom, but looking at it in a situation where you may find yourself actually in that situation, do you think you could do that?
I think I can. Like walking in here Friday, I think it kind of makes you realize how serious, because I've never really been in a courtroom.
Mm-hmm.
So I think when you walk in, it kind of, I don't know, it's just weird how to explain it.
There are things called aggravating factors, and those are limited by statute. And I think the judge may have mentioned this briefly. You'd be able to fine your decision on whether the death penalty is appropriate to just those aggravating factors that the judge tells you are appropriate in this case.
Yes.
Okay. We talked a little bit about mitigating factors, and those are factors that may make the life in prison the appropriate punishment in this case, as opposed to the death penalty. Would you be able to consider any and all mitigating evidence that is put before you before making an ultimate decision as far as what a proper punishment should be?
Now, as a juror, do we vote, like, do you guys tell us what we're voting on? We don't decide the punishment. So, I mean, I know that's a silly question, but I'm just asking. Sorry.
Ask your question again. Do we what?
I was saying, as a juror, we don't, like, you're the one that decides punishment. We just kind of decide if they're guilty or not.
The way this works, ma'am, are you talking about penalty phase?
Yeah.
Guilt, I have nothing to do with your vote on guilt or not guilty. That's totally up to the jury. On penalty phase, you're going to be given some specific instructions by me. You vote either life without the possibility of parole or death. In order for a judge to impose a death sentence, the jury has to unanimously vote for death.
Okay.
If any one juror votes for life without possibility of parole, the sentence is life without possibility of parole.
Okay.
Okay?
Did that answer your question?
Yeah, sorry.
Okay. Talking about the mitigation evidence, would you be able to consider any and all mitigation presented to you and listen to the evidence that addresses those types of mitigation evidence before you make your ultimate decision?
Yes.
Regardless of what the mitigation is, could you consider that evidence?
Like, you're saying, listen to all the evidence and make my decision with the evidence? Yes.
Do you have any religious beliefs that might influence your decision in this case as far as whether the death penalty would be appropriate versus life in prison?
I mean, I'm religious. I believe whatever happens is in, like, whatever happens with me or anybody, I do believe that it's in God's hands.
I believe some religions have some stances on the death penalty. Does your religious affiliation will abiding by your religious faith affect your decision in this case at all?
No.
Okay. One of the issues that I believe you heard the judge talk about was the issue of insanity. And obviously that involves mental health component. Okay. I'm going to ask you a few questions, a little more personal than before, but I think you probably understand why I need to ask you some of those.
Fine.
Do you or a close friend or family member have ever dealt with a significant mental health issue?
My niece has had nothing major, but she's had depression.
Okay.
I don't know if that's counted. Yeah.
Did she seek any kind of treatment for that?
Yes.
Any kind of medication to help assist with that problem?
Yes.
How's she doing?
She's doing fine. She was just in a bad place at that time. And then I had her move with me.
Ma'am, I can't hear you. You
Yeah,
got to
good.
get that mic
Oh,
up
I'm
next to
sorry.
your mouth. Go ahead. Thank you.
No, she's doing good now. She was just hanging around the wrong crowd and stuff like that.
So obviously, if mental health issues have affected your family, you do believe mental health issues are real in society, right?
You'll probably laugh at me, but I always feel like me praying helps me more than that's where I go.
Okay. Do you feel that mental health issues, though, affect certain people in the world?
I believe so.
I believe you said praying has always helped.
To me, yeah.
To you?
Yeah.
Okay. Do you think it is reasonable for certain people with mental health issues to maybe seek a different route, such as medication and therapy and things like that.
Yeah, people do that.
Rephrase the question, Mr. Buckman.
Do you feel there are other additional avenues that may help with mental health issues?
Overruled.
Yes, I believe so.
Okay. Would you be able to listen to all the evidence and make a determination only after listening to all that evidence whether a mental health issue exists in this case and whether insanity has been proven in this case?
Yes.
Okay. Is there anything else in your life that might make you uncomfortable being a juror in this type of a case? For instance, I don't know if it, obviously, but a loved one was killed or murdered in a case or something to that effect. If it jumps out in your mind, that's kind of what I'm thinking.
No.
Nothing.
Thank God. Huh?
Nothing like that at all.
No.
Okay. No further questions, Your Honor.
Thank you. Mr. Lenneman, you may inquire.
Thank you, ma'am.
Thank you.
Good afternoon. How are you?
Good, how are you?
My name's Terry Lenneman. I represent Markeith Loyd. Gentleman sitting right there. You can imagine my concern that when you came in here initially, you said you were predisposed to believing that my client was guilty.
Mm-hmm.
And then you had talked about how you have changed that process over time. But a few minutes ago, when the judge asked you, was there anything specific that caused you to change that opinion, you said no. Is that fair to say?
Yeah.
Okay. So why should I believe that you don't have the same opinion you had back then today?
Because I think when you watch the news and you listen to everything they say, that you just automatically listen to what they're telling you. And that's kind of, just by watching it, you just kind of feel, from the evidence that they were saying or whatever. But I think like coming in here, I think I've grown a little bit more as kind of not making quick judgments. And like I said, when I walked in here the other day, I kind of felt like how it's actually a real, not that it's fake when you see it on TV, but I think you kind of get the feeling of how it's actually, like I said, like walking in here kind of thinking like, wow, this is actually a person here that, if I get picked, I'm responsible, and that you have to make a honest decision, because I would not want to make the wrong decision on somebody's life.
So before you came here, which was, I guess, Friday, right?
Mm-hmm.
Before Friday, you had watched a bunch of stories on Mr. Loyd's case?
No, that was probably way back in the day.
Okay, way back in the day, back when this happened, 2017, you watched a bunch of stories on his case, and you became of the belief that he was guilty. You had a firm conviction.
As from what the news was saying.
Okay. And then up until the time that you walked in here, you still had that firm conviction.
No, because I wasn't really sure what the case was. But then when she was mentioning more of the case, then I realized what it was.
Okay. But before you came in here, you didn't know what case it was.
No, I wasn't sure.
And you had watched TV and had a firm conviction about my client's guilt.
Back then.
Back then. And there was nothing, as you told the judge, leading up to coming in here that changed your position. Nothing came up that changed your position about what you believed back there.
I just never thought about it after it was on the news, really.
Okay. And then when you came in here, this is the first time that you started to address in your mind your old conviction of guilt.
Well, like I said, I think I'm try to be as honest as I can with people. I don't like to only see one side of everything. I usually take everything and try to focus it in my mind, but I don't usually try to focus on one part of something.
So you want to appear, because you believe you want to appear to others that you're fair.
I feel I am.
Okay. And that's important to you.
Yes.
Okay. And so when you started talking about this with the judge, you wanted to let her know that you thought yourself was fair.
Well, I wanted to tell her that I've seen the case back then and that I did have like a judgment back then to be honest to everybody and to be honest to him. You know what I mean? Because I didn't want to try to pretend like I never seen it or anything like that.
And the judgment was he was guilty.
Yes.
What about the case that you remember?
I don't know if it's the same case, but if it's the same case, because it was a long time ago, if it's the same case, I don't know if it was something.
You said he had a patch on his eye.
Yeah, I don't know. Is that him?
That's him.
Okay. And I think if it was back then, I think something about a pregnant girlfriend.
Okay.
Sorry, what did you just say?
Something about a pregnant girlfriend.
So you
But I
remember?
didn't remember if that was the same one.
Okay. It was the same one. As a matter of fact, the judge read from a statement of facts earlier that he was convicted of killing a pregnant girlfriend.
But I didn't know that Friday. That's why I was saying that's when it kind of registered on what case it was.
Okay.
Because I didn't recognize him because I thought he had the patch. So I was like, oh, that's not the same guy.
Okay. Okay. So how were you able to set it aside? The beliefs that you had back then, how were you able to set them aside?
I mean, I don't know how I set it aside, just trying to do the right thing and listen to the evidence and try to be fair on both sides.
So you want to be fair, you want to listen to the evidence, right?
Mm-hmm.
But you didn't do anything in your mind to set it aside from your belief in the past, right?
Well, I think with me, my conscience is the person that I am, I wouldn't want to make a decision on somebody just on my opinion, on my thoughts or opinions, especially something as serious as this.
So how are you going, if you had this firm belief of his guilt back then, how are you going to remove that completely?
You'll laugh, but honestly, I always say you'll laugh because some people probably think, yeah, okay, right. I already started praying for God to touch my heart and to, if I get called, to help me, to guide me through the whole thing, even for me emotionally, to guide me through it.
Did you have that belief back then in 2017?
No, because I didn't take it as serious. It was just a thing on the news.
So now you have a firm religious belief. Is it okay if I call it religious?
You could say that, because I try to get closer to God to be a better person.
Okay.
And not be, I don't know, not kind of have a heavy heart. And that's something I've been working on for a while.
And you prayed to God to set that aside in your heart, that guilt that you felt when you came here, specifically when you came here.
Well, actually, when I was taking a shower.
A shower on Friday?
Yeah, Friday when I went home.
Okay.
Because it was kind of, making me feel like, oh, I don't want to make a decision on something like that. And then I just prayed about it. That way I can kind of take a lift off of my my shoulder kind of.
And
Ma'am, I can't hear you, I'm sorry.
Oh, I'm sorry. I was just saying I prayed about it so that way I kind of take a lift off my shoulder.
And you're relying on your connection and your prayer to get you past what you felt before.
Well, I've kind of, like I said, I don't watch the news anymore because I just don't try not to pay attention to all the stuff that goes on there. And as for me, I've been trying to change like who I am and not let things affect me how they used to.
Okay, so I want to make sure that you answer my question. You were relying on God as early as Friday night in your prayer and your connection to Him to help you set aside these beliefs you had of my client's guilt.
Yeah, that's how I help myself.
Okay. Thank you, ma'am. I have some other questions I'd like to ask you.
Can I see the attorneys at sidebar, please? Ma'am, I can't tell you how much I've enjoyed listening to you and talking to you today, and as have the attorneys. I'm getting the feeling this isn't the case for you.
Okay,
So I'm
that's
going to
fine.
excuse you from this and discharge you as a juror with our thanks. We appreciate all the time you've given to this
All right,
and
no,
all
it's
the
okay.
thought. But
I appreciate it.
thank you so much, ma'am.
Have a good day. Thank you.
All right, we're going to take a quick 10-minute break. We still have a couple of the jurors from 10:30, all of the jurors from 1:30, and the 3 o'clock jurors have started arriving. So, like I said, make plans, folks. We're going to be here late. Court's in recess. All right, we're back on the record on State versus Loyd. Mr. Loyd is present along with his attorneys. State Attorney's Office is present. Let's bring in the juror in seat number 25, and it's juror number 27.
Make yourself comfortable right there.
Welcome back, sir. All right, sir, did anyone talk to you? Did you hear anything about the case at lunch, anything like that?
No, ma'am.
All right. We're going to be asking you a series of questions. All we need you to do is to tell us the truth. There's no right or wrong answers to these questions. There's just what you think and feel, okay? Let me start with, you told me you haven't heard anything about this case, correct?
But just what you've told us Friday and today, ma'am.
And today?
Yes, ma'am.
Right, all right. All jurors are required to presume that Mr. Loyd is innocent until and if the state can prove he's guilty. As you sit here right now, can you do that?
Yes, ma'am.
All right. Can you tell me what your feelings are, your position is on the death penalty, please?
I'm open. I don't have any decision one way or the other. I guess I've never been in a situation where I've had to think about it or decide.
Okay. Are you opposed to the death penalty in any way?
No, ma'am.
Are you someone who believes that in certain cases the death penalty should be automatic?
I would say whatever the law or whatever fits based on the guidance and the information we're provided, I guess that would determine the decision.
Okay. In this case, if Mr. Loyd was found guilty of first-degree murder, you would then enter the penalty phase of this, and that's when you address the issue of life without parole versus death. So you would, as a juror, you would be asked to listen to the evidence the state presents as to aggravators, reasons they believe that Mr. Loyd should be sentenced to death. The defense presents evidence of what called mitigation, which is the reasons they believe that Mr. Loyd should be sentenced to life without parole. At the end of all the evidence, I'll give you the jury instructions on what you're supposed to do with all of this, but then you go back into the jury room with your fellow jurors and you have to weigh the aggravators and the mitigators. And we encourage you to talk about it among yourselves, but in the end, each juror has to make an individual decision as whether you believe life is the appropriate sentence or death. In order for a court to be able to impose a death sentence, the jury must vote for death unanimously. And any juror can vote for life at any time. And, you know, if one juror votes for life, it's life. You understand that?
Yes, ma'am.
You with me so far?
Yes, ma'am.
You have to be able to have an open mind about listening to the aggravators and the mitigators. Do you believe that you can do that?
Yes, ma'am.
At this point in time, do you have any issues or any concerns about your ability, if the evidence led you to believe, and all the facts and everything you'd heard led you to believe that life without parole was the appropriate sentence, would you have any problem imposing life without parole?
No, ma'am.
And if the evidence and all the facts and everything you heard led you to believe that death was the appropriate sentence, would you have a problem voting for death?
No, ma'am.
Mr. Loyd, as I told you, has raised the defense of insanity. And I briefly read a little bit of the instruction to you. Do you have any automatic reaction to a defense of insanity?
No, ma'am.
Is that something that you could listen to, and if it was proven, you could vote for it?
Yes, ma'am.
Right. And then lastly, you heard me tell you that Mr. Loyd was convicted of the shooting of Sade Dixon and her unborn child.
Yes, ma'am.
I'm telling you that that information cannot be used to determine whether or not he's guilty of this case, in this case. You understand that?
Yes, ma'am.
I'll explain to you later on, if you're on the jury, what that information can be used for. Can you follow that instruction?
Yes, ma'am.
All right, thank you, sir, very much. State, you may inquire.
Thank you, Your Honor.
Regarding your views about the death penalty, seems like you're neutral either way, kind of right in the middle.
Yes,
Okay. Some cases it may be appropriate, some cases it may not.
Yes,
All right. The judge asked you a question a few minutes ago about whether you felt that certain cases automatically deserve the death penalty. You said you'd basically follow whatever law you were instructed. Okay. And you understand in Florida, there is no such thing as an automatic death penalty type case. Okay.
I would, if you say so.
Okay. In order for the death penalty to even be eligible, certain additional factors have to be proven to you beyond a reasonable doubt that make this murder more egregious than a typical first-degree murder. And typical murder is not a really good term, but I think you might understand where I'm coming from.
Yes, sir.
Okay. Even if you found in your heart that this murder, you were angry about this murder, that there were a whole lot of aggravating factors in your mind,
Overruled. Go ahead.
would you still be able to listen to the mitigating evidence to determine if it's appropriate in this case?
Yes.
Oh. Overruled.
So even if we're shown to you that this is a premeditated murder, not accidental, would you still be able to listen to all the evidence, especially the mitigation, before you make an ultimate decision in this case?
Yes, sir.
You've heard the term aggravating factors, and those are factors that are limited by the statute itself, by the law. The judge will tell you, if we get to that point in this trial, what those aggravating factors are. And you can only consider those aggravating factors that she tells you are appropriate. Can you do that?
Yes, sir.
Can't consider other stuff that you may think is bad. You have to focus on these aggravators if they're presented to you.
Yes, sir.
All right. As far as mitigating factors, those are factors that tend to show that life in prison would be the proper punishment in this type of a case. Okay? Would you be able to listen to any and all mitigating evidence presented to you and truly consider it before making a decision in this case?
Yes, sir.
All right. If at first glance or first blush you hear some evidence, and this is not the time for us to talk to you about the details and the evidence that relate to aggravating factors and mitigating circumstances. That's later. So even if at first blush you may hear something that is presented as mitigating to you, and without hearing any evidence, you might be thinking, well, I don't know if that's really mitigating. Can you agree to hold off your judgment until you hear all the details and all the evidence dealing with the aggravating or mitigating factor? Yes. Do you think that Mr. Loyd deserves to have a jury who will listen and consider all mitigating evidence before?
Yes, sir.
If I were to stand up here and start rattling off 50 different mitigating factors that could possibly come about, am I correct that your answer would be, yes, I would consider all the evidence before I make the decision? Yes. Now, after hearing the evidence about an aggravating factor or a mitigating factor, you can come to a variety of different conclusions. Say that you can say it has been proven, but I don't think it's very important in my decision-making process, and give it little weight. Or you can say that's a really piece of information and give it a lot of weight. That is up to you. Do you have any religious or moral beliefs that would interfere or make it difficult for you to make a decision such as the proper punishment in this case?
No, sir.
The decision as far as whether what death penalty is appropriate in this case or life in prison is appropriate in this case is an individual decision that you would be asked to make. Okay? Knowing if one person on the jury votes that life in prison is the proper punishment, that ends up being the sentence in this case. The life will be imposed as the punishment in this case. It would require all 12 jurors to decide that the death penalty is the appropriate punishment for that to be a sentence in this case. Do you understand?
Yes, sir.
Because it has to be a unanimous verdict if the death penalty is to be imposed. If the 12 of you come back and vote death penalty is proper in this case, obviously it's going to be unanimous and everybody would know you voted for it. Knowing that everybody would know you voted for it, would you be able to come into this courtroom, raise your hand, and tell the judge that this man deserves to die for what he did if you felt that was the appropriate punishment in this case?
Yes, sir.
Now, that's an easy question to answer. Maybe if you're hanging out with friends, talking on, at a party or something, a little different context when you may find yourself in that specific situation. Do you think you can do it?
Yes, sir.
Okay. Switching gears a little bit, the judge mentioned defensive insanity will likely be an issue in this case. I'm going to ask you a few questions about your feelings toward mental health issues. I don't mean to be deprived, but obviously I think you can tell it's an important question to ask. Do you or any close friends have any experience dealing with significant mental health issues?
That I'm aware of.
Do you think that mental health issues are a real thing in the world, or do you think it's kind of made up or it's bogus?
No, I would definitely say that.
Okay. Would you be able to listen to the evidence in this case dealing with whether a mental health issue exists before you make a final decision as far as whether insanity has been met?
Yes.
Okay, you could listen to all the evidence before you come to that.
Yes, sir.
Is there anything in your background or your life that makes you feel you would not be a good juror in this type of a case?
I don't believe.
Okay, you can be fair?
Yes, sir.
Thank you, sir. Anything else?
Thank you, Mr. Rutzer. Mr. Lunneman, you may inquire.
How you doing, sir? Good. What kind of work do you do?
I work at the department.
In the city of Orlando, or?
State of Florida.
Okay. And specifically, what kind of work do you do?
I'm the regional supervisor for HIV prevention, counseling, testing, and linkage.
Okay, great. And is that a lifelong working for the health department? You've been doing that most of your adult life, or?
No, sir. I was a mechanical engineer up until 2012.
And if I may, and if it's private, we can talk in private. Why did you switch fields?
I relocated from Boston to Florida.
Okay.
It was a position, a job.
Now, I guess when you first came in the courtroom and were asked some questions, and even now, it seems like you're very structural in terms of following rules. Would you agree with that?
Yes.
Okay. Because you didn't reference to what the rule was. You said, if it's the rule, I'm going to follow it.
Yes.
Would that be fair to say?
Yes, sir.
Okay. Why do you think you're that way?
I just think it's who I am as an individual, as an engineer. As a supervisor, decisions are made based on policy. It's just how I've been professionally, how I've been my whole life.
Okay. And where does, emotion fit into that?
And I think emotion comes to personal relationships. I don't look at it as business relationships.
Okay. You're obviously dealing with a lot of tough stuff as a supervisor in that capacity with the health department, right?
With emotional? I'm not sure what you mean by that, sir.
Yeah. With emotional, are you dealing with day-to-day people who are dealing with that, or you just supervise people who supervise them?
I supervise the staff that link people to care with testing and services. So I don't deal with clients directly anymore.
Okay.
I used to. I was a medical case manager for about 3 years. So now I don't deal with staff. Now I don't deal with clients directly. I deal with staff directly.
And what did you do as a medical case director?
Link clients to services. So if somebody was diagnosed, we would link them to care and services.
Okay. Now, I think you had said you really never thought about the death penalty before today, kind of. Is that right? Yes. Okay. So obviously you had a little bit of time to reflect that this was a death penalty case because you found out on Friday, you had the whole weekend, obviously today, while you have been waiting. Has anything popped up in your mind in terms of thoughts about this being a death penalty case? Not at all.
I could just sort of take it at days to come. I'm not sure that I would make it to the trial, so I guess I would decide as things went through. I don't know enough about the case to make decisions.
And I'm not asking you about the decision you would make. We're not allowed to really do that. What I'm asking you is, what are your thoughts about the death penalty?
I guess I would about the situation, whether it's warranted or not warranted, or whether it is applies to the situation or not applies to the situation.
Okay.
I've never been in a situation where I had to consider it or be part of it.
Right. So some people, you ask that question, they say, I'm completely for it. Some people say, I'm against it. Some people have opinions about it, one way or the other. Do you have any of those things going on?
I'm really neutral. I'm not educated on it, but it's never been part of any decisions I've ever had to make or it's never impacted me, so I've never got involved in the decisions.
The fact that you would have to make an individual decision on someone's life, how do you think about that?
I think that if it applied to that situation, then I would make that decision or determine that decision after I had all the information to see if it applied and was warranted.
Okay. But you understand the application and the decision whether it's warranted or not all comes down to you personally. It's an individual process. Yeah. You don't have any problem dealing with that?
Not yet.
Okay. When you say not yet, what do you mean?
I mean, so far in my life, I'm not, I don't have an opinion on one side or the other, so I would have to have the information.
Okay. And you didn't have any strong feelings about the death penalty where you believe someone should always get it? The death penalty, is there a circumstance you believe that someone should always get the death penalty? Okay. Your opinion, not anything, anyone else's, your opinion. Like, you see a mass murder. Is that something that you would think someone deserves the death penalty?
No, because there can always be extenuating circumstances.
Okay, great. Now I'm going to ask you some questions about the death penalty itself. Now, the way it works in Florida is that if Mr. Loyd is convicted, and only if, of first-degree murder, then we would go into a second trial with the same jurors, and you would be given a set of instructions on what the law is, as you've been told by the judge, and you will have to listen to evidence put on by the state and the defense and make a decision. Following me?
Yes, sir.
Okay. So the law says your decision goes kind of like in this order. Number one, you have to decide whether one aggravator, all of you jurors have to decide whether one aggravating factor was proven beyond a reasonable doubt for you guys to go forward with the death penalty issue. You understand that?
Yes, sir.
It's still an individual's decision to you, as is everything in the second part of the case, but as a group, you have to agree.
Yes, sir.
You understand that?
Yes, sir.
That's the only time, as a group, you have to agree in the penalty phase. Everything else is on you. And even though the state talked about this concept that all the jurors have to come back to have a death sentence unanimously, that's 12 individual decisions that are made. Understand that?
Yes, sir.
One of which is yours.
Yes, sir.
So the next step is mitigation. You have to look at, actually the next step is you have to look at the aggravating factors. If there's more than one, you have to decide on which ones you individually believe have been proven beyond a reasonable doubt. Okay?
Yes, sir.
You put those in a little compartment. Next thing you do is you look at the mitigation. Mitigation could be anything. And that has to be proved by a lesser standard than beyond a reasonable doubt. And then once you decide that, just like you decided the aggravators, you have to give the aggravators a certain amount of weight, whatever you feel the weight should be. And with the mitigators, you have to give the individual collectively a certain amount of weight. How much value those are to you. You understand so far?
Yes, sir.
Okay. So then you have the aggravators, the mitigators, and then you weigh those yourself individually. If you believe the mitigation outweighs the aggravation, you always have to vote for life. It's an individual decision, but if you believe that the mitigation outweighs the aggravation, you have to vote for life. Do you understand that?
Yes, sir.
If you believe the aggravating factors outweigh the mitigating factors, you may vote for death, but you are never required to vote for death. The legislator has said, and you will hear a jury instruction, that you are never required to vote for death in any circumstance. You understand?
Yes, sir.
Once that's placed in front of you, the aggravators versus the mitigators, then you have to make a decision. If the aggravators outweigh the mitigators, the next decision you have to make is whether you are going to vote for death individually. Understand that?
Yes, sir.
Okay. So now we've talked a lot about how individual this is. How do you feel if you believe you reached one verdict, one way or the other? How do you feel about the fact that someone may try to bully you into changing your opinion?
I'm an independent person. I've never been bullied.
You're not going to allow that to happen under any circumstances.
Not so far in my life.
Okay, and you understand that there is no bullying that's allowed in the jury room. You know, specific, it may be something from history, current, so forth and so on, and that's presented to you, you would be able to consider that as a mitigating factor.
Yes.
And going back to the mitigators, you would be able to give it weight.
Yes.
Correct?
Yes, sir.
Okay. How about trauma? Would you be able to consider generally trauma that someone suffered in their life?
Yes, sir.
Okay. Now, the judge told you clearly, without question, that in the first part of this case, you already know that Mr. Loyd has been convicted of first-degree murder of his ex-girlfriend and an unborn baby. You know that as a fact, okay? He has a conviction for it. She told you absolutely you cannot use it at all in the first part of the case. You understand that?
Yes, sir.
My question is, there are some people who hear something like that, and even if they're told they can't consider it, would not be able to not consider it. Are you one of those people?
I would have no problems not considering it, if that's
Okay.
what you're asking.
Thank you. Now, we talked about respect being an essential part of the second part of the case. Respecting jurors, respecting each other, respecting decisions, and you said you can do all that.
Yes, sir.
There's a certain part of the case in the penalty phase, if we should get to that, it's entitled victim impact. And the legislator has decided, and it's incorporated into the jury instructions, that a juror gets to hear from family, friends, or someone else in the victim's life about the uniqueness of that person. It's an absolute requirement. You will hear it in this case. The thing about that is the legislator and the jury instructions tell you you cannot consider that on the issue of being an aggravating factor in death. So although you can consider it, it has to be separated from your decision to vote for life and death. Can you do that?
Yes, sir.
Okay. One second, Judge.
Sure.
Hold on. One more area, and we'll be done, sir. You, and I know that we've talked about that you're very structural in your thinking, and sometimes in your speaking. So, you had said earlier about the death penalty that you need to learn about the situation. What are you talking about?
I guess I would need to learn on when it should be applied or when it would fit, and what would be the circumstances in which it would be warranted or not warranted.
Okay.
And be able to weigh pros and cons and determine on whether that fits appropriately or inappropriately.
Okay. So generally speaking, and the judge has already read you some instructions. They're consistent with what we've talked about. That's kind of the format you're going to get. You're going to get instructions of how to weigh things and determine things and ultimately make a decision. So is that kind of what you were talking about?
Yes, sir.
Okay, you weren't talking about anything specific with the death penalty or death penalty case.
I guess it would be this situation specifically.
Understanding how the rules work.
Yes, sir.
Okay. And what we talked about, are you comfortable following those rules? Assuming the judge is going to give you, and I'm confident you will, are you comfortable following those rules, what we discussed?
Yes, sir.
Okay. I have no further questions, Judge. Thank you.
All right. Either side need to approach?
No.
No, Your Honor.
All right, sir. We're going to ask you to come back one more time, last time. Unless you're seated on the jury, then you'll be here every day. But we don't know the date yet. You're now going to be a purple dot. When you're calling into the jury phone number, you're listening for instructions for the purple dots. I have no idea what day it will be, but I can tell you it won't be this week, so don't even start calling until Thursday, all right? We're giving you a package of information. In that package is included a jury sequestration package that provides you quite a bit of information about that sequestered juries need to know. The day you come back for final questioning, you have to have packed a bag enough for sequestration, because if you're picked for the jury, we sequester you that day. Leave it in your car. The deputies will help you come get it if you need it. If you don't, you'll just go home and unpack. All right? Do you have any questions?
No, ma'am.
All right, so everything's in there. Have a good afternoon. Thank you for your service. Do not look at anything, read anything, let anybody talk to you about this case. All right? You're free to go for today.
Thank you, ma'am.
All right, thank you.
I should leave this here, ma'am?
Yes, sir, please. Thank you. So that's the juror number 27 and seat number 25. All right, I need the juror in seat number 26, who is juror number 5. All right, sir. Good afternoon. I know it's been a long day. Did you have a good lunch?
Yes, I did. Yes, I did. Thank you.
All right, sir. I need you to just be honest with us. Don't worry about what your answer is. There's no right or wrong answer to these questions, okay? Did anybody at lunch or after lunch, have you heard anything? Anybody talk to you anything at all about this case?
No.
All right. And you've never have you heard something about this case before this? You have not?
No.
Okay. So tell me what your position is on the death penalty, or what your beliefs are about the death penalty.
Oh, well, that's a very complex question.
Yes, it is.
And I'm man of faith. I believe in God. I don't go around judging people. I believe that people should be held accountable for their behavior. However, when it comes to the death penalty, I cannot say I believe or I don't believe, because of the fact that it all depends on the situation. People have to, obviously, as I mentioned before, be held accountable for their act based on the structure of the society, and there's rules that everybody have to follow, and based on that, sometimes we have to follow guidelines, and if we feel that this is the best approach based on the guidelines and which need to happen, I probably say, yes, I believe.
All right, sir. Jurors in these cases, if Mr. Loyd was convicted of first-degree murder, and only if, then there's a penalty phase, and that's when the death penalty becomes an issue in these cases. At that time, what you're required to do as a juror is you're going to have to listen to evidence from the state. They present aggravators, reasons they believe death would be the appropriate sentence. The defense presents mitigation, reasons they believe life without parole is the appropriate sentence. I give you at the end of all this evidence, I give you the jury instructions, and you and your fellow jurors retire to the jury room to talk about this. You're going to weigh the aggravators and the mitigators and decide. You have to make an individual decision as to whether you believe life or death is appropriate, okay? If at the end of weighing all of that, you came to the decision that you believe the appropriate sentence in this case was life without the possibility of parole, could you vote for that?
After reviewing all the facts, and if this warrants that, I'd probably say yes.
Okay. And if after reviewing all of the evidence, the facts, everything that you've heard, weighing it all, you believed that the appropriate sentence was death, could you vote for that?
Well, never being in that situation, it's hard to say. I believe, again, that if for some reason that's the structure, this specific situation, after reviewing all the facts, warrant that step, I probably will say I'll probably support it.
Okay. Do you have any doubts about your ability to do that?
Well, it is very difficult for me to answer this question, because in my line of business, I dealing with specific situation every single day. And I have learned the hard way that sometimes you have to step back and listen, understand the whole situation before you even have an opinion. Again, I've never been in this kind of situation. I'm just going to be very honest with you. It is very difficult. These are questions that for me, they're very difficult to answer, because they're based on assumptions.
Okay.
What can I do? What can I not do? It's hard for me to say, because again, I have never been in this kind of situation before.
I understand that we're asking you to predict the future. Do you have any moral or religious objections to the death penalty?
I think that, again, if for some reason there's a structure in society that require or warrant after certain aspects that had happened, and that warrant that decision, and I don't have any problem. I think that I probably support it if I feel that that's something that needs to be supported based on the facts.
As I told you, Mr. Loyd has raised the defense of insanity in this case, and I briefly read to you a little bit of the jury instruction on that. Could you listen with an open mind to any evidence that was presented as to the defense of insanity?
Well, I think that every single fact, they need to be here before. This is something that is very, very serious and critical. And I think that in order for you to make this kind of decision, you really, really have to be able to consider all the facts that there in this specific case.
Okay. Then last thing, you remember I told you that Mr. Loyd had been convicted of the murder of Sade Dixon and the unborn child, correct?
Correct.
All right. I'm now telling you that that information cannot be used by jurors to decide whether or not Mr. Loyd is guilty of this case. Do you understand that?
Yes.
Do you believe that you can follow that instruction?
Yes.
All right. Thank you, sir. I'm going to turn this over to the lawyers. Mr. Buxman, you may inquire.
Good afternoon, sir.
Good afternoon.
So it sounds like based on your questions that you just answered for the judge, certain cases you feel the death penalty could be appropriate, certain cases it may not be, right?
Correct.
Okay. Do you understand that in Florida, in order for a case to even be eligible for the death penalty, the state has to prove certain additional factors called aggravating factors, which make this case more egregious than maybe a typical first-degree murder case?
Yes.
Okay. There is no such thing in Florida as an automatic death penalty if someone's convicted of first-degree murder. Do you understand that?
Yes.
So no matter what evidence you hear about a first-degree murder, whether it was premeditated, there was no accident, there was no defense, that in and of itself does not mean that the death penalty is automatically appropriate. Does that make sense?
Yes.
You would have to consider in determining the proper punishment both the evidence that deal with the aggravating factors as well as mitigating factors. Mitigating factors are things that could cause the proper sentence to be life in prison as opposed to the death penalty. You'd have to consider all that before making your decision.
Yes.
Can you do that? Consider all the evidence before making your decision.
Well, I do that for a living.
I'm sorry?
I do that for a living.
You do that for a living. What do you work at the Hyatt, I believe?
Yes. Yes.
What do you do on a daily basis at the Hyatt?
Well, I am the director of operation, and my job is obviously the planning, financials, customer service, accountability, and dealing with not only with customers' grievances, but also associates' grievances too as well. And through this process, I'm working side by side with HR to make decisions on next steps to take based on different situations that had happened in the hotel.
You get a lot of responsibilities, it sounds like.
Yes.
Okay. The aggravating factors that we've been talking about, the thing, death penalty, an appropriate sentence in this case, those are confined and limited in number by statute. You only can consider those aggravating factors the judge tells you can consider. Can you confine your focus just to those things the judge tells you can consider?
Yes.
Mitigating factors are a little broader. Are you able to, you probably have already answered this, but let me just make sure. Are you able to consider all of the evidence that relates to mitigating factors before you make a decision as far as the proper punishment, what the proper punishment should be in this case?
Yes.
Okay, and now this is not the time for us to talk about the evidence that deals with the different aggravating factors or mitigating circumstances, what goes into each of them in this case. This isn't the time for that. So even at first blush, if you hear something is presented to you as a mitigating circumstance, and at first blush, you may think, I'm not sure if that's really important. Can you agree to hold off your decision on whether it's important until you hear all the evidence?
Yes.
So if I were to stand up here and rattle off 100 different mitigating
I'm sorry? Overrule. Go ahead.
If I were to stand up here and talk about 100 different mitigating circumstances, would your answer be the same that you're telling me you would consider each and every one of those before making a decision?
Yes.
Now, once you hear all the evidence, you can decide whether has that aggravating factor or mitigating factor been proven. If it has been proven, you can say, I want to give that a little weight, it's not very important in my decision. Or you can say, oh, that's very important, I'm going to give it more weight. But the focus is, you need to hold off on making that decision until you hear all the evidence. Make sense?
Yes.
Do you think Mr. Loyd here deserves a jury who will consider all that evidence before making a decision?
Yes.
Once you hear all the evidence, you'll be asked to then do a weighing process to determine and to analyze the aggravating factors in relation to the mitigating factors and determine whether one outweighs the other, which will then lead into your decision of what the proper punishment should be in this case. The decision, if the jury votes that, if one person on the jury votes that life, then that becomes the sentence in this case. So that decision as far as what the proper punishment is an individual decision for each of the jurors to make. You understand that?
Yes.
In order for the death penalty to be a punishment in this case, all 12 jurors would have to unanimously agree that that is the proper. Okay, do you understand?
Yes.
Obviously, if the decision has to be unanimous and the jury comes back and makes that decision and says the proper punishment in this case is death, everyone would know that you voted for it, right?
Correct.
Would you be able to walk into this courtroom and raise your hand and say, Judge, in this case, I believe the death penalty is appropriate and that this man deserves to die for what he did?
Overruled.
Now, that's one way to ask that question if you're with a bunch of friends and outside of a courtroom just talking. It's a different analysis if you're actually find yourself in that situation being the one to make that decision. Do you think you could make that decision if you felt the evidence supported it and you felt that was the right decision?
I probably will, but I have to be 100% sure.
Okay. If you were 100% sure in your mind that that was the right thing to do, you could do it. Is that what you're telling me?
Yes.
Okay. Another issue in this case, like the judge indicated, is the issue of insanity, which involves mental illness. Do you or a close friend or a family member, have any of you dealt with a mental illness in the family?
No.
Okay. Do you feel that mental illness is a kind of a real thing? Some people think, oh, mental illness, that's bogus. What do you think?
I think that people could use that sometimes as a tool to not take responsibility for their behavior, and some other situation is fact in life.
Okay. Will you be able to hold off judgment until you hear all the evidence on the case to determine whether insanity is a viable defense in this case?
Yes.
Okay. Thank you, sir. No further questions, Your Honor.
Thank you. Mr. Lyman, you may inquire.
How are you, sir?
I'm doing well, thank you.
I didn't hear the whole job that you had. You said you worked at a hotel?
Correct.
And what do you do?
I'm the director of operations.
Okay. So you're responsible for a lot of people and a lot of things?
Yes.
Okay. Now, if I was to use a scale, and we were talking about where you think you fall on the issue of the death penalty, and 1 would be never voting for death, and 10 would be always voting for death, where do you think you would place yourself on that scale?
I will tell you right in the middle.
Right in the middle, like a 5?
Yes.
Okay, and why do you say that?
Because some people deserve not to go through that process, some others might not. I don't think anybody deserves to go through that. But however, there's, again, certain circumstances and structures set up in society that require certain steps to follow, and that person's behavior warrant to do something, to go through this process, I think that I probably will go and support something like that.
Okay, so you can follow the law.
Correct.
Okay. Now I want to talk to you about a little bit about the law, okay? So the way it works is that in order for you to consider the death penalty, Mr. Loyd would have to be convicted. So to get to the second part, it's like a second trial, Mr. Loyd would have to be convicted first of first-degree murder. You understand that?
Yes.
Okay. And then you would be given instructions, which the judge read parts of some so far, but you would be given more elaborate instructions on what the rules are that you have to follow, okay? So the first rule is that the entire jury has to find that at least one aggravating circumstance, and those are the things the prosecutor talked about that would enhance Mr. Loyd's sentence. At least one of those have to be proven beyond a reasonable doubt by the entire jury. Okay, you following?
Yes.
Okay. That's the only thing the entire jury has to decide. Everything else is individual. It's your independent decision on every other piece of decision-making that you have to make in regards to the death penalty, okay?
Okay.
Okay, and it's obviously a serious situation, as you already voiced, okay? So after that finding of the one aggravator, the next decision you would have to make is you would have to look at the aggravators, whether there's one or more than one, that the state presented to you, and you individually would have to decide which one they proved beyond a reasonable doubt. And once you decide of that aggravator being proved beyond a reasonable doubt, then you would have to assign a weight to it. You can assign little weight, some weight, a lot of weight. It's all up to you individually. You understand?
Yes.
So the next thing then is you would have to look at the mitigation that I present to you. And it could be a dozen things. It could be more or less. But each one of those mitigating circumstances that you are provided, you have to decide whether they are proven. And the standard for proving those is less than beyond a reasonable doubt. It's a lower standard. So you would have to look at each one individually and decide which one were proven or all of them proven. That's all up to you individually. You following?
Yes.
Okay. Then you have to take the mitigating factors and you have to assign each one weight. You may find some more weighty, some less weighty, some a little bit of weight, medium weight, great weight. It's all up to you. It's all your decision. Once you do that, you have the mitigation. And in your mind, you have to look at then the aggravating factors and the mitigating factors, and you have to assign weight to the whole part, the aggravators and the mitigators. And then once you do that, you have to decide whether the aggravation outweighs the mitigation or whether the mitigation outweighs the aggravation. Okay? If you find the mitigators outweigh the aggravators, it's always a sentence of life. There's nothing but a sentence of life. You're done with your job, it's over. Okay? If you find the aggravators outweigh the mitigators, then you go to the next step. And the next step is deciding whether you believe Mr. Loyd should receive a death sentence. The law says, without question, and you'll hear this from the judge, you are never required to vote for death, period, ever. That's up to you individual, and if you want to decide not to vote for death for whatever reason, maybe it was something you heard in the trial, maybe it's something in your heart that you feel, some mercy, whatever it is, you never have to vote for death, even though the aggravators outweigh the mitigators. You understand that?
Yes.
It's still an individual decision. The decision is vote for death or not vote for death. That's yours, okay? Collectively, in order to have a death sentence in Florida, Each individual decision of all 12 jurors has to be voting for death. If one of the jurors vote for life and the other 11 vote for death, it's considered a life verdict. And Mr. Loyd would be sentenced to life. Do you understand that?
Yes.
Okay. Now, a couple things I want to talk to you before we wrap this up. Number one, do you feel like you're the type of person that if you made your mind up about something, that you're going to stick to your beliefs?
Well, I think that no, because if I only can make my mind up when I have all the facts together.
And I'm not asking you to make your mind up today. I'm talking about you sitting back in the jury room. You have been given all the facts you're going to be given, and you making a decision, one way or the other. Once you make that decision, are you going to stick by it?
It can change.
Okay. And what kind of things would change it?
New facts.
There is no new facts, okay? You can be certainly talking to other jurors about their opinion. There's nothing prohibiting you communicating with other jurors about what their decision is, what they believe, what you believe. But at the end of the day, you have to make the decision yourself. You understand that?
Yes.
Once you made that decision, hearing from other people, listening to other people, respecting other people, would you stick with your decision?
Yes.
Okay. So that's the next thing I want to talk about. Do you think it's important to respect other jurors' decisions?
Absolutely.
And why is that?
Everybody have a different opinion.
Okay.
Have to be respected based on different perspectives.
Okay. And would you agree that as a juror in this case, you would respect any other juror's opinion, whether it's life or death, you're going to respect it?
Absolutely.
Okay. And would you, if you saw another juror trying to bully a juror about their opinion, would you voice your concern about that?
Absolutely.
Okay. If I can have a second, Judge. One more quick area, sir. Now, the judge told you absolutely, unconditionally, you're not allowed to use the knowledge that you have in the first part of the trial about Mr. Loyd's prior conviction for murder. You remember her telling you that?
Yes.
Okay. There are times when even a juror is told that they are unable to do that. Are you able to follow the judge's instruction?
Yes.
Okay, thank you, sir. I have nothing further, Judge.
Either party wish to approach?
No.
All right, thank you. This is juror number 5, seat 26. Sir, we're going to have to ask you to come back one more time for the final jury selection process. You're now a purple dot. We're going to give you a purple dot for your badge. So when you're calling in to the jury room to find out when you're supposed to come back, you're listening for instructions to the purple dots. We're also giving you a jury sequestration package. It explains to you what it's like to be a juror that's being sequestered and what you need to bring, and et cetera. When you come back for that last day of questions, you need to have packed the night before. Leave your suitcase in the car. If you're not picked as a juror, obviously you're just going home, but if you are picked as a juror, we sequester you right then and there. So the deputies will go with you to your vehicle to get your belongings to take you to the hotel. And the phone number that you call is in the packet. Do not call before Thursday. We're not going to need you before next week at the earliest, so just start calling Thursday. Listen for instructions for purple dots. Any questions?
No, no questions.
All right, thank you so much, sir. You have a good afternoon.
Thank you.
You're free to go. I need the juror in seat 27, please. And this is juror number 334. The juror in seat 25 is on the panel, right? On the final panel. Juror in seat 25 went through to the final panel, right? Yeah, okay. Good afternoon, ma'am. How are you?
I'm fine.
All right, welcome back.
Thank you.
We just have a few more questions for you. Let me start, and again, ma'am, the important thing is for you to tell us the truth. Don't worry about whether it's right. There's no right or wrong answer to these questions, okay? You said you'd heard something about this case. Can you tell me what it is you've heard?
Well, I heard it all over the news a couple of years ago.
Okay. How much of that did you listen to?
I listened to quite a bit of it because I watch the news every morning when I'm getting ready for work.
Okay. Do you watch the same channel all the time or different channels?
Pretty much the same channel all the time.
And which one is that?
Channel 2.
Okay. Based on what you heard, did you form any opinion as to whether or not Mr. Loyd is guilty?
Yes.
Okay, what's that opinion?
From what I heard on the news, it sounded like he was guilty.
All right. Is this something that you talked about with friends or family when it was all on the news?
When it was all on the news, yes.
Okay. And did they agree with your assessment at that time that you felt like he was guilty?
Yes.
To sit as a juror in this trial and be fair to both sides, but to be fair to Mr. Loyd, you have to presume he's innocent.
Mm-hmm.
Okay. You got to put everything you heard aside, and your verdict has to be based solely on what's heard in the courtroom. But you have to start by presuming he's innocent. Do you think you can do that?
I think so.
Okay, why?
Because you said something today that had me thinking about it while I was at lunch, and that was the defense position of insanity. And that was not something that I had thought about before, and it intrigued me. And I remembered from a while back, growing up, my dad always told me there's 3 sides to every story: your side, his side, and what really happened. So I've only heard one side of what was on the news, and I would like to hear the other side.
Okay. So when you're sitting there as a juror, describe for me what you're thinking, which is it, I think this man's innocent, and I'm waiting to see if the state can prove this beyond a reasonable doubt. I think this man's probably guilty, but I'm willing to listen to see if I'm wrong. Or I think he's guilty, and I think he should prove to me that he was either insane or he's not guilty, or something else.
Your second comment, that he's probably guilty, but I would still like to hear, to see if I'm wrong about that.
Okay. State?
No objection.
Fence? Okay, ma'am. I appreciate your service. I appreciate your willingness to serve more than you can possibly imagine, but I don't think this is the case for you. You're free to go, and the mask is a gift, a second gift to you, along with the first one. All right.
Okay.
Thank you so much. Have a
Thank
good,
you.
You're discharged as a juror in this case.
Okay.
Juror in seat 28. This is going to finish this group. So what I'm going to do for the next 2 groups, 130 and 3, is I'm going to bring them both in at the same time, instruct them both at the same time, find out who has formed opinions, and we're going to do it that way. Since I have 2 groups waiting and it's 4 o'clock. Let's get 28 in here. This is juror number 220, seat 28, panel 1. Good afternoon.
Good afternoon.
I bet you thought you were never going to get in here. Well, of these two groups, I have two more groups waiting. Makes you feel any better. All right. You've never heard anything about this case, is that correct?
No, ma'am.
All right. Tell me what your beliefs or position is on the death penalty.
I've never really thought about it. Never had to make a choice of if somebody's going to die or not. So my views on it is, depending on what is presented, is what I would answer to.
All right. In these cases, let's say Mr. Loyd was actually convicted of first-degree murder. That's the only time you have to make the decision about a life sentence or a death sentence. So the guilt phase is over, and now you're in the penalty phase. State's going to present evidence of what are called aggravators, legal reasons why he should be sentenced to death, they believe. Defense presents mitigation, reasons they believe that he should be sentenced to life without parole. You have to listen to all of it with an open mind until the end. Then you go into the jury room, and you and your fellow jurors can talk about it as much as you want. You have to weigh the aggravators, weigh the mitigators. I give you jury instructions about all of this. But in the end, it's your individual vote, and you have to decide, after weighing all this, life without possibility of parole or death. So if at the end of that, you believed that the appropriate sentence was life without the possibility of parole, could you vote for that?
Could, yes.
And if at the end of that process you believed that the appropriate sentence was death, could you vote for that?
More than likely, yes.
Okay. Do you have any hesitation about that?
No.
Mr. Loyd has raised the defense of insanity, not guilty by reason of insanity. I read you a brief blurb about the instructions for that. You have to be able to listen to that defense with an open mind. You can't start out thinking, this is nonsense, I'm never going to accept this. You have to listen with an open mind, and if the evidence leads you that way, accept the defense. Is that something that you can do?
Absolutely.
You also heard me say that Mr. Loyd's been convicted of the murder of Sade Dixon and her unborn child, and that he was sentenced to life on that. You remember when I read that to you?
I do.
Right. I'm now instructing you that that information cannot be used by you to determine whether or not Mr. Loyd is guilty of these charges. Do you understand that?
Completely.
Do you believe you can follow that instruction?
Without a doubt.
I mean, later on in the case, I will explain to you what that information can be used for, but it cannot be used to determine guilt.
Okay.
Thank you, sir. State, you may inquire.
Oh, still, okay.
Not yet.
How
Good
you
afternoon,
doing?
sir.
Good afternoon.
So it sounds like you're relatively neutral as far as the death penalty. It could be appropriate in some cases, it may not be appropriate in others.
Yes.
All right. Now, in order for the death penalty is not an appropriate sentence for every single type of first-degree murder. You understand that?
Yes.
The legislature has determined that in order for the murder to be eligible for the death penalty, the state has to prove certain aggravating factors that make this murder more egregious than a typical first-degree murder.
Okay.
Sustained as to that. I'm going to rephrase that.
Yes, ma'am. The state has to prove certain aggravating circumstances to set this murder apart from other murders.
Okay.
Okay. And only if that is done does the case become eligible for the death penalty.
Okay.
In Florida, there is no such thing as a murder qualifying for an automatic death sentence. Do you understand that?
Yes.
So no matter what evidence is shown of the first-degree murder, it was premeditated, there was no accident, there was no defense, those kind of things, there still has to be evidence shown of aggravating factors, and you'd have to consider the aggravating factors along with mitigating evidence and factors to determine what the proper should be.
Okay.
Can you follow the law that says you have to focus on all this evidence before you make a decision, and the death penalty is never automatic? Follow that law.
Yes.
Aggravating factors are confined to certain things that are in the statute, and the judge will tell you which aggravating factors are appropriate if we get to that point in this trial. Can you agree confine your focus just on those aggravating factors the judge tells you are relevant to this case.
Yes.
You will also hear, if we get to that point, evidence of mitigating factors. Can you agree to listen to, this is not the time for us to talk about the details and the specific evidence that relate to aggravating and mitigating factors in this case. That'll happen later. Can you agree to listen to all of the evidence dealing with mitigating factors and consider it before you make an ultimate decision of what the proper punishment should be?
Yes.
Do you think Mr. Loyd deserves to have a jury that will remain open-minded and listen to all evidence presented to it about mitigating factors before making a decision?
Absolutely.
Okay. If I were to stand here and mention 100 different aggravating factors, would your answer always be the same of I would consider it and evaluate it before making my ultimate decision?
Yes, 100%.
Now, once you hear the evidence and evaluate the evidence as it relates to aggravating factors and mitigating circumstances, then you can decide it hasn't been proven. The evidence hasn't proven that factor. If you find it's proven, you can say, I don't think that is very important or very weighty in my decision. Or you can say, that's a really important piece of evidence and very weighty in my decision of what the proper punishment should be.
Yeah.
As long as can you assure, though, that you will listen to all the evidence before you reach that decision?
Of course.
All right. The judge, I believe, told you that the decision as far as what the proper punishment is in this case is an individual decision made by each individual juror.
Yes.
If one of the 12 of you decide life the proper punishment, that becomes the sentence. Does that make sense?
Yes, sir.
If all 12 of you determined that the death penalty was the proper punishment, only then does that become a punishment in this case.
Completely understand.
Obviously, if it has to be unanimous, and that's what happens, and the jury comes back and it's a unanimous decision for the death penalty, everyone would know you'd vote, right?
Correct.
Knowing that, would you have any concern or any hesitation coming into this courtroom, raising your hand and saying, Judge, this man deserves to die, if you believe the evidence supported that sentence?
Yes.
Judge Marquez also mentioned the insanity defense, and that is involving mental illness. Do you, a close friend or a family member, have any involvement with mental illnesses?
Not personally, but family members work in the facilities, yes.
Okay. So I gather by that statement that some people think mental illness isn't really real. People believe mental illness is a real issue in
It can
certain
be
people.
treated, yes.
Would you be able to listen to all the evidence about the circumstances surrounding a mental illness to determine if it exists and what the ramifications are of that before you make a decision whether insanity is a defense?
Absolutely.
All right. Thank you, sir. No further questions, Your Honor.
Thank you, Mr. Buxton. Mr. Wenneman, you may inquire.
Oh, one more.
Afternoon, sir. How are you?
You, sir.
So when you first heard the judge reading the fact that Mr. Loyd was convicted of the murder of Miss Dixon and her unborn child, what were your thoughts?
Really no thoughts on it. This is different. Whatever the case is here is different from what happened in the past. Can't live in the past.
So you're saying you had no feelings one way or another?
Not in the sense of guilt or not guilty of whatever this is.
Have you ever served on a jury before?
Never.
Did you know when you heard that, well, I'm not going to be able ever to consider that in the first part of the case?
No.
So when was it that you decided it wasn't important?
Well, I hate to go into some of my history, but I was like a grievance man. So everybody had their grievance. You had to hear what the grievance was about before you can make a determination. That's the same thing with this gentleman here. What he did in his past is his past. What he did here, I don't know. We'll have to figure that out.
So you said part of your grievance evaluation? I didn't understand.
Yeah, I belong to a union. I was a grievance man.
Okay, okay. And what union was that?
Steelworkers,
Yeah, was that up north or down here?
Pennsylvania.
Okay. And you came here to retire or?
No, work at Universal Studios.
Okay, okay. So, and then you heard the judge instruct you on the fact that you can't use it, but when you heard that, did you think that Mr. Loyd was 90% guilty and 10% innocent, or what did you think?
I keep telling you, I didn't think anything of that. That was his past, whatever this.
Okay. And so, do you feel comfortable enough to follow the judge's instructions on that issue?
No.
So you do feel comfortable enough to follow the judge's instructions?
Yes.
Okay. And you're saying 100% you're not going to let that factor into your decision?
No.
Okay. Now, Mr. Bruxman said, you know, there's no automatic death penalty in Florida, which I don't disagree with him. But there are some people who have really strong feelings about certain types of killings. So I want you to think in your mind of one, if there is one, that you strongly feel about, and whether you would consider not just automatically deciding to vote for death because you have such a strong feeling about that, you wouldn't be able to consider anything else.
No. Like I said, I don't know what he's actually done in this case. That would determine how I would feel.
Well, you heard he killed a police officer, right?
Yeah.
Okay. And you have some police officers in your
family? Passed away.
Who are they?
His a brother.
Okay. What department did he work for?
Narcotics.
Sorry, I didn't hear that.
Narcotics.
No. Where did he work as a police officer?
Western Pennsylvania.
Okay. And was his death related to anything to do with his service?
No.
Is he the only one that's in your family that's in law enforcement?
I have a brother-in-law, but I met him like twice.
Okay.
Don't really know him.
And was your brother a lifelong police officer?
No, he was in the military, and then he went to become a police officer for
Okay.
our local city.
Did you ever have any interaction with the people he worked with?
Who?
Your brother, you know, did you ever have any interaction with other law enforcement officers?
Oh, yeah. Absolutely. Small town.
Okay, so you grew up in a small town where everyone knew everyone.
Pretty much.
Okay. So what are your feelings about this case involving the death of a police officer and the fact that you have a deceased brother who was a law enforcement officer?
It's not going to have any factor because I know good police officers and I know bad police officers.
Okay. So that's not going to affect you at all?
No.
Okay. Now, what do you think about, you know that Mr. Loyd's doing life without the possibility of parole, based on what the judge read you, right?
Mm-hmm.
What do you think of that as a sentence as opposed to the death penalty?
Again, I think it would depend on the evidence that is presented and what the factors were here. I don't know.
Do you think that life without the possibility of parole, generally, in comparison to the death penalty, is a lenient sentence?
No, because you're in prison. I mean, for the rest of your life. I mean, you have no life.
Okay. Now, you said you didn't give it much thought about the death penalty before you came in here.
Mm-hmm.
Is that right?
Yeah.
But certainly you heard on Friday this was a death penalty case, so you had over the weekend to think about it.
Mm-hmm.
And obviously today, while you were waiting,
Mm-hmm.
do you have any other thoughts about the death penalty?
As of now, like I keep saying, I would have to hear what's being presented. Do I have any issue sentencing him to death? That's why you would have a panel.
Okay, and I understand that you'd have to hear more, but that's not my question I'm asking.
Okay, I apologize.
I'm
completely
asking
understand.
you personally,
Yes.
do you have an opinion about the death penalty
No.
at all?
No. If it's just, and that's what we decided, yeah, you would have to die.
You said it's justice, is that what you said?
If everything is presented, and we as a group decided the death penalty was what we were looking for, and we all agreed on that, I would probably follow suit.
Okay. So you would consider yourself like a follower of others?
No, more of a leader.
I'm sorry?
I would say as more of a leader.
Okay. Well, as a leader, I'm still not getting what you're telling me about your thoughts and opinions of the death penalty. Not the system, not the way it works, your thoughts and opinions, i.e., I don't like the death penalty, I do like the death penalty. Over the weekend, I thought about it. It's a great responsibility. It's not a responsibility. What are your thoughts? That's what I'm really trying to understand.
I'll be honest with you, I don't really know yet. I don't know in my mind if I would sentence a person to death unless there was enough evidence showing me that that person deserved it. In my mind, not in their minds, my mind.
Okay.
So yes, I probably would say I would give you the death penalty.
So you're leaning towards the death penalty?
No. I want to see the evidence first. I would want to see what was.
But you said a moment ago, I probably would say I'd give you the death penalty. What do you mean by that?
Well, if the evidence showed that, in my mind, that this person deserved the death penalty, everybody has certain morals in life. And if you cross my morals like any other person, yes, I would probably say yes to that.
Okay. So what's important to you is your own individual morals?
Somewhat.
Okay. And you believe that if that person that you're judging, whoever it is, crosses your own personal morals, you'd probably give them the death penalty?
Somewhat, yep. If you would harm my father or somebody like that close to me, yeah, death penalty would definitely be what I would want.
Okay. So, and I understand your father or your brother or someone close to you, but what about other people who cross your morals? They do something despicable in your mind. Would you give them the death penalty?
I'd have to see what that was all about.
Okay. How much of your morals would play into the decision to give a person the death penalty?
I mean, I've never had to come to that kind of.
I understand, but could you put a number on it? Could you say, all the time, anytime, 20%, 30%, 50%?
I really can't answer that, sir.
Okay.
I mean, there's no way of answering that without knowing what you're asking.
Well, I guess I'm asking, and I think I've asked, and I think you answered it on some level. I'm just trying to,
comprehend it. Would I put somebody to death if I felt they deserved it? Probably.
Okay. But that would be based in part on your own moral thinking.
Yeah.
Okay. I want to talk a little bit about The death penalty, I know the prosecutor talked about it some. We're going to go through this real quickly. Okay? So essentially in Florida, there's an instruction, jury instruction in the law. The judge will read to you. It's separate from what the law is on the first part of the case. The only way you get to this part of the case is if he's convicted, and then you have to make a decision, okay? So what happens is the prosecutor puts on evidence of aggravating factors. You heard that word before. He described it for you. We put on mitigating factors. They could be, a dozen, could be 10, could be 5, could be 50, okay? And so the first thing you have to do as a juror is that you have to decide as a group, this is the only time you're doing something as a group, that one aggravating factor was proven beyond a reasonable doubt, okay? All of you have to decide that. Doesn't matter what the aggravating factor is, but one aggravating factor was proven beyond a reasonable doubt. Collectively, you decide that, okay? Everything else follows is you individually. The next thing you have to do individually, because this is an individual process, the jury instructions say without question, it's an individual decision on these issues, including whether you vote for life or death. The next thing is you have to decide what aggravators the prosecutor has proven beyond a reasonable doubt. And those aggravators have to be, could be 1, could be 2, could be 3, could be many, okay? Once you decide that, then you would go down to the mitigation, whatever the mitigation is. The mitigation has to be proven to a lesser standard than beyond a reasonable doubt. And you would have to decide whether one or more of those mitigating factors have been proven. With the aggravating factors, you're going to give it some weight, whatever weight you think should be entitled to. It could be a great amount, a little bit, so forth and so on. On the mitigators, you're giving that weight too. Basically, you have 2 balls, and you decide which one is heavier. If you find the mitigation is heavier, then you have to vote for life. There's no question what you have to do. If you find the aggravators outweigh the mitigators, then you may vote for death, but you're never compelled to vote for death. The law says you never have to vote for death if you don't want to, okay? After you make that decision, the final decision you make is whether you're going to vote for the death penalty. Again, an individual decision. Collectively, if 1 or more of the jurors say life, it's a life verdict. Collectively, if all 12 say death, it's a death verdict. You follow me?
Absolutely.
Okay. So the next issue is you as an individual, when you're in this process, making a decision, weighing, that's an individual thing. No one can tell you whether to talk to other jurors or not. That's completely up to you. You can talk to jurors, you cannot talk to jurors, but the final decision is yours. Once you make that decision, do you think you are the type of person that will stick by your guns?
Yep.
Okay. So now the next question is respecting other jurors. Do you have any problem with respecting the person sitting to the left and right of you in their decision, no matter what it is?
Nope.
Okay, you're never going to try to bully them?
No.
And if someone's bullying them, are you going to speak up?
Yep.
Okay.
Sorry about yep. Yes.
There's also something called victim impact, okay? So the judge is going to read you along with the other instructions, if we get to the penalty phase, that the jury gets to consider the uniqueness of the victim. And there will be testimony, and there may be pictures about the victim. You get to consider all that, because obviously in our community, we all think that's very important. But the one thing about that is you cannot consider that information in deciding whether to vote for death or not. It's not an aggravating factor, okay? Can you follow that rule?
Yes.
Okay. 1 second, Judge. Okay, what? Oh, sorry. Those are all the questions, Judge, I would like to come sidebar.
He's going through, Teresa. All right, sir. It's been a long day for you. We're going to ask you to come back one last time for
Okay.
jury selection, for final jury selection. You're now a purple dot. Yeah, we're going to need your badge with the purple dot on it. We're going to give you a package. That package includes instructions for jurors if they're sequestered. I don't know what date we're calling you back because I don't know when we're going to get to jury selection. It won't be before next week, so you don't even need to start calling until Thursday, all right? But just call the number every day. When you hear purple dots report on such and such a date, that's you. You need to pack your bag for that day because if you are chosen as a juror, you will be sequestered on that day. So, and the deputies will go with you to your car to get your suitcase. Just leave it in the car. It's just there in case you're picked for the final jury. The number and everything you need to call is in that packet. Any questions?
You said a week or this Thursday?
Start calling the number to find out when you're supposed to come in on Thursday. We will not need you before next week at the earliest. So you just go on about your life, except avoid the news, the newspaper, and anybody who wants to talk to you about all this. All right? Thank you so much, sir. You're free to go today. All right, that's it for this group. As I said, we're going to put the other two groups together. So, Nan. All right, actually, State, you're going to need to flip around because I can't. Are you going to put 20 in the jury box or are you going to put them? All right, never mind. Let's put them in. Let's bring them in. Paddles corresponding to their seats. This is still panel 1. All right, there are some that are coming off panel 2 on this. All right, folks, we're going to need to swear you in one more time, so if you'll stand, raise your right hands, please. Face the clerk. Stand up, raise your right hands. Thanks. All right, have a seat, please. All right, ladies and gentlemen, I apologize for the delay. This has gone much slower than we anticipated. I'm aware of how late it is. We're going to try and move you through here as quickly as possible, but I don't want to have to make you come back tomorrow. So I'm going to try and get through this tonight. If you have any kind of issues, I know during seat 31, you have a child care issue. I'm aware of that, and we'll get you out of here in time. If you have any kind of issues, let the deputies know, and they'll help you with those. All right, you're here for individual juries questioning. This is phase 2 of this. As I informed you, this is a capital case. It's a death penalty case, and we question jurors in groups in these cases. So I've got a few instructions for you and explanations for you so you're aware of what it is we're doing and you understand the process a little bit better. And I'm going to inform you a little bit more about the case. Let me start by telling you that in this case, Mr. Loyd is charged by indictment. And I have the indictment here in my hand. It's a piece of paper, folks, all right, that we use in the state of Florida to tell people what they're charged with. You have to tell people what you're accusing them of doing. This is how we do it. The fact that there's an indictment you cannot consider that to be evidence of guilt. That's not how this works at all right? So he's been charged with first-degree murder with a firearm of a law enforcement officer, attempted first-degree murder with a firearm of a law enforcement officer, aggravated assault with a deadly weapon, carjacking with a firearm, and possession of a firearm by a convicted felon. This case is tried in 2 phases. The first phase is the guilt phase. The guilt phase is conducted pretty much the same way as we do all criminal cases. You're going to listen to evidence, testimony, physical evidence, all of that. You're going to listen to everything that's presented in the courtroom, and then you will be asked to return a verdict of guilty or not guilty on all counts. Your verdict must be unanimous on all of the counts, meaning that each juror must agree on each count either to acquit or convict. But the only count that qualifies for the death penalty is count 1, the murder, the first-degree murder, all right? If and only if Mr. Loyd is convicted of first-degree murder, do we move into phase 2. But sticking with the guilt phase, the burden of proof for the government is the same in the guilt phase of a capital case as it is for every other type of criminal case. It is proof beyond a reasonable doubt. The instruction you will receive on reasonable doubt will be identical to the one given in all other criminal cases. The burden on the state is not higher because of the possible penalty. When you are deciding guilt in phase 1 of the case, you will be instructed to ignore the possible sentence during this phase. In other words, we ask jurors to decide whether a defendant is guilty or not guilty on the charges, including murder 1, on its own merits. And you will be told to disregard the possible consequences of your verdict. The only question you are to answer during the guilt phase is whether the defendant is guilty of murder in the first degree, as well as any other offenses charged, or guilty of a lesser included offense or not guilty. And we expect you, as a juror, to carefully consider the facts before you reach a decision. The fact that a defendant might face a death penalty is to play no part at that stage of the proceedings. If and only if a jury returns a verdict of murder in the first degree, you will then reconvene for the purpose of rendering a verdict as to which sentence, death or life imprisonment, without the possibility of parole, should be returned. If that happens, a special set of rules and instructions come into play. And I'm just going to give you an overview of all of this now. There are only 2 possible penalties for the crime of first-degree murder. Life without the possibility of parole is the automatic penalty for it, or in some cases, death. Those are the 2 choices in a capital case. All potential death penalty cases are divided into 2 parts. Because the death penalty is reserved in Florida for one class of crimes only, and that is murder in the first degree, the legislature has created special rules for juries to consider in reaching a verdict in the penalty phase. The legislature recognizes that not all first-degree murder cases deserve the death penalty, so they created a list of circumstances which juries are to consider in reaching a verdict in a death penalty case. Some of these the prosecution finds helpful, some of these the defendant finds helpful. The ones that the prosecutor may rely upon are called aggravating factors. The state is required to prove these factors beyond and to the exclusion of a reasonable doubt. They are limited in number by statute. The ones that the defendant relies upon are called mitigating circumstances. Mitigating circumstances do not need to be proven beyond a reasonable doubt. A mitigating circumstances only needs to be proven by the greater weight of the evidence. Mitigating circumstances are not limited by statute, and they may include matters that are relevant to the defendant's background or character or circumstances surrounding the offense, and they will be offered as a basis for a verdict of a sentence of life in prison without parole. The state of Florida does not have parole. If you're sentenced to life in prison without parole, you die in prison. Before you may vote, the court impose a sentence of death, the state must prove beyond a reasonable doubt that one or more of the aggravating factors they alleged exist. The process of weighing the aggravating factors and mitigating circumstances to determine the proper punishment is not a mechanical or mathematical process. The law contemplates that different factors may be given different weights or values by different jurors. In your decision-making process, you and you alone are to decide what weight is to be given to a particular factor. Regardless of your findings in this respect, however, you are never compelled nor required to vote for a sentence of death. The final step in this phase of the trial is for each of you to determine whether the defendant should be sentenced to life imprisonment without possibility of parole or death. The court may not impose a sentence of death unless each juror individually finds the defendant should be sentenced to death. Even when death is a possible sentence, each juror must independently decide whether life imprisonment without the possibility of parole or death should be imposed. Regardless of your prior findings, the law never compels nor requires any juror to determine the defendant should be sentenced to death. Any single juror has the right to vote for a sentence of life imprisonment without the possibility of parole. If, after deliberating, the jury unanimously agrees that the appropriate sentence is death, then your verdict may be for a sentence of death. If the jury does not unanimously agree that the appropriate sentence is death, then your verdict must be for a sentence of life imprisonment without the possibility for parole. This is just a broad outline of the penalty phase, folks. The specific instructions are given to you if you're seated on the jury and if we get to a penalty phase. Let me say this too. The fact that I'm talking about the death penalty is not to be taken by you as any indication one way or another as to whether or not this is a case which justifies a death penalty. I don't know that, and you don't know that. I'm only discussing this because it's a possibility. It doesn't presuppose anything. We just have to be ready in case we get to a penalty phase. We're going to be asking you some questions about the death penalty. In general, there's some questions that you're pretty much going to get asked, so I'm going to tell you what they are now so you can start thinking about them. You're going to be asked whether you have any moral, religious, or personal feelings about sitting in judgment of a defendant's conduct in a case. You're going to be asked if you have the same types of feelings about the death penalty. We are going to ask you about your feelings about the death penalty and whether you're in favor of the death penalty. You're going to be asked whether or not you agree with the premise that a sentence of death is not appropriate for all first-degree murder cases. You will be asked whether you would agree to weigh the aggravating and mitigating circumstances with an open mind and determine whether or not life or death is the appropriate sentence. You will also be asked if you are a person who is so opposed to the death penalty that you simply would not consider it as a punishment in any case. Many people have strong feelings about the death penalty, both for it and against it. The fact that you have such feelings does not disqualify you to serve as a juror so long as you're able to put those feelings aside and apply the law as I instruct you. In other words, you must be willing to be bound by your oath as a juror to obey the laws of this state in delivering your verdict. Additionally, Mr. Loyd has raised in this case the defense of not guilty by reason of insanity. There's a specific insanity instruction that will be read to you if you're on the jury, but I'm just going to give you an overview of what it is. The burden is on the defense. It's the only time the burden is on the defense to prove by clear and convincing evidence that Mr. Loyd had a mental infirmity, disease, or defect, and because of this condition, he did not know what he was doing or its consequences, or although he knew what he was doing and its consequences, he did not know it was wrong. So we're going to be asking you questions about your ability to listen to that defense with an open mind. I have a statement about the case to read to you all. This is just a small blurb about the case, all right? On the morning of January 9, 2017, defendant Markeith Loyd is alleged to have entered the Walmart store at 3101 West Princeton Street. Mr. Loyd had an active warrant for his arrest. Orlando Police Lieutenant Debra Clayton attempted to take Mr. Loyd into custody on the information she received regarding Mr. Loyd's involvement in the Dixon homicide when it is alleged Mr. Loyd shot and killed Lieutenant Clayton following an exchange of gunfire before fleeing the Walmart and eventually being apprehended about a week later. Mr. Loyd's trial for the killing of Sade Dixon and her unborn child began on September 27, 2019, and concluded on October 23, 2019. Mr. Loyd was convicted and sentenced to life without the possibility of parole. That portion that I just read to you about the prior conviction cannot be used by you to determine guilt in this case. It is being told to you and used in the trial for a different reason, which the court would instruct you on later. All right? So, having given you these preliminary instructions and facts, how many of you have previously heard about this case? Just raise your paddles for me, please. All right. 31, 38, 39, 42, 46, 49, 50, 52. There's no way I have, oh, you're from the second panel, sorry, 57. All right, and from panel number 2, I have 1, 2, 4, is that a 4? 4, 6, 10, 14, and 15. For those of you who have heard about the case, how many of you have formed an opinion as to Mr. Loyd's guilt or innocence? Don't tell me what it is, just raise your paddles if you've formed an opinion. 31, 39, 42, 46, 49, 50, and from panel 2, 1, 2, 4, and 15. All right, folks, thank you very much. I'm going to send you all back into, are they going back in the jury room or the? Okay. Juror number 31, you please stay in the courtroom for me. The rest of you follow directions of the deputies. I'll be with you just as fast as I can, folks. All right. Can you move towards the middle there, please? Thanks. So we can all see you. All right, so your juror number 31 is in, you were in seat 31 and your jury number is 358, is that correct?
Yes.
All right, I need you to answer the questions truthfully. Doesn't matter what your answer is because there's no right or wrong. We're not grading you on this. We just need to know what's going on.
Okay.
How much information do you have about this case? How much have you heard?
I heard about it when it first happened.
Okay.
I remember because I worked in that area, so I was making sure that everything was safe around me.
Okay.
Haven't really heard much about it recently.
Did you watch a lot of the news coverage when it first happened?
The day of, yes. I don't really like to watch a lot of news. So
Could
after
you-
that, I just kind of let it go.
Okay. Could you actually see police officers and everything from where you work? Could you see what was going on?
No,
No?
no,
Could you hear any of it?
no. I was just around that area. I work in all different areas throughout the city, so.
All right. So after that day, have you heard a lot about it or read stuff about it?
Once or twice here and there, but not a lot.
Have you heard people talking about it, or if you know, coworkers, friends, family?
Yes,
And have you participated in those discussions?
somewhat, a little bit.
All right. Did you form an opinion as to whether or not Mr. Loyd is guilty?
I did.
And what's that opinion?
I believe he is.
Okay. Jurors have to be able to sit in these cases with an open mind, and they have to believe that they have to presume Mr. Loyd is innocent at the beginning of the trial until and if the state proves he's guilty beyond a reasonable doubt. Do you think you could put aside your belief he's guilty and do that?
Don't believe so.
Okay. State?
No objection.
Defense?
No objection.
All right, sir, I appreciate your candor. You are free to go. You're discharged as a juror in this case. Thank you.
Do I go downstairs to the lobby room or?
You're done.
Okay, thank you.
Thank you. You can keep the mask. That's a present.
Thank you.
Don't the placard there. All right. Juror in seat number 39, please. This is still panel 1, juror 184. Good afternoon.
Good afternoon.
You're the school principal, correct? All right, your juror number is 184. All right. Sir, you indicated that you've heard something about this case.
Yes,
What have you
ma'am.
heard? Just tell me what you've heard.
I just remember when it happened, all the news publicity.
Did you follow it?
Yes.
Did you watch it every night, every once in a while?
Am I okay?
Yeah, it depends on where you hold it, whether it echoes or not. Yeah.
I mean, continued on.
All right. When's the last time you heard or read anything about the case prior to coming to jury duty? Okay. Yeah, it was 2017. Have you talked about the case with family, friends, coworkers, anything like that? I'm talking about ever, not just now. All right. And as a result of all of that, did you form an opinion as to whether or not Mr. Loyd was guilty?
Yes,
And what's that opinion?
guilty.
Jurors are required to presume that Mr. Loyd is innocent until and if the state can prove he's guilty beyond a reasonable doubt. Do you believe that you could put aside your feeling that he was guilty and follow that, or would you still be thinking he was guilty?
I would have a very difficult.
All right, thank you, sir. State?
No objection, Your Honor.
Defense? All right, thank you, sir. We appreciate your service. I don't think this is the case for you. You are excused from this jury.
Thank you.
Need the juror in seat 42, juror number 224, panel 1.
I'm sorry,
4-2. Good afternoon, sir. How are you?
Doing okay.
All right, sir, you indicated that you've heard about this case?
Yes.
Can you tell me what you've heard?
It's mainly what was on the news, right? That he shot and killed his girlfriend or wife, whatever, and that kind of thing from the other case.
You got to keep the mic near you. Yeah.
Sorry.
I talk with my hands, so I sympathize. So, yeah.
Was at the Walmart, shot the deputy, ran, and then I remember the video of him getting and then being kicked.
Okay.
There.
Did you talk about it with friends and family and coworkers?
Not recently, no.
All right. When's the last time you recall, prior to coming to jury service, hearing or seeing anything about the case?
Few things on the news, just that there was another case, another case or another hearing and that kind of thing, but nothing in detail.
Okay. And as a result of that, you indicated you formed an opinion as to Mr. Lloyd's guilt?
Yes.
And what is your opinion?
I believe that he did it, yes.
Okay. Jurors have to start trials presuming that someone is innocent. It's just what the law requires until and if the state can prove they're guilty beyond a reasonable doubt. Do you believe that you can do that in this case, or would you start believing he's guilty?
Believe just because of some seen on the news.
Okay.
Have those views, it would be probably more of an uphill battle to change my views.
All right. Thank you, sir. State?
No objection.
Defense? All right. Thank you, sir. I don't think this is the case for you. We appreciate your service. You're discharged and free to go.
Thank you.
Juror in seat 46, please. Good afternoon, ma'am.
Hi, how are you?
I'm well, thank you. How are you?
Good.
You've been patiently waiting. I appreciate it. I really do.
Thank you.
Just answer the questions truthfully. We're not looking for a specific answer. We're just looking for what you really think and feel, okay?
Okay.
You indicated that you've heard about this case. Is that correct?
Right.
All right. How have you heard about it?
Well, the defendant was dating someone that I knew.
I'm sorry, you need to.
Oh, the defendant was dating someone that I know.
Do you know Mr. Lloyd himself? Or
I don't
just
know
the
him
person he was
personally,
dating?
but he was dating someone that I knew.
And what was the name of the person he was dating?
Jamesia Slaughter.
Okay. Did you and she talk about him?
Yes.
Did you form an opinion about Mr. Lloyd based on those conversations?
Yes.
Is that a good opinion or a bad opinion?
A bad opinion.
All right. And then you also heard about the case?
Yes.
Is that on the news and just folks talking about it?
Folks talking about it, and on the news.
Did you form an opinion as to whether he's guilty based on that?
Yes.
And what's your opinion?
I'm guilty.
All right. You have to presume he's innocent in order to sit as a juror in this case. Could you do that?
I don't think so.
All right. Thank you, ma'am. State?
No objection.
Defense? All right. Ma'am, thank you very much for your honesty. You're free to go. You're discharged as a juror in this case.
Thank
I don't
you.
think this is the case for you. All right. Juror in seat 49, it's juror number 246. We're still on panel 1. Good afternoon, sir.
Hello.
Sir, the only thing we're looking for is for you to answer the questions truthfully. We're not looking for any particular answer. There are no right or wrong answers to these questions, okay? You said that you heard about this case. How did you hear about it? All right, how much news coverage of this did you watch? Okay. And was this recently or? Okay. Did you also talk about it with friends, family, or coworkers, or everybody? No. Anywhere else that you heard about it? As a result of hearing about it and whatever you heard back when it happened, did you form an opinion as to whether or not Mr. Loyd is guilty? Okay, that he's guilty? All right. Jurors have to start trials presuming someone is innocent. That's just the law, until and if the state can prove they're guilty beyond a reasonable doubt. Do you think you could do that in this case? All right, tell me why you think you could presume he's innocent. Okay, so if you were sitting as a juror, I'm going to give you three options, and if none of them apply and there's a fourth option, tell me what it is, okay? You're sitting as a juror, you're sworn in, case hasn't started yet. Are you sitting there thinking, yeah, this guy's probably guilty, but I'm willing to listen and see if I'm wrong about that? That's option one. Option two, this guy's innocent. I haven't heard anything. The state needs to prove to me that he's guilty, and they need to do it beyond a reasonable doubt. Option three is, he's guilty, but if he can convince me otherwise, I'll listen. Do any of those three options apply to you? He's guilty and he needs to convince me. I'll listen. I'm willing to listen to him. All right. Thank you, sir. State?
No objection, Your Honor.
Defense? No objection. All right. Thank you, sir. I appreciate your willingness to serve, but this is really not the case for you, so I'm going to discharge you as a juror in this case with our thanks. You can keep the mask. All right. Thanks. Juror in seat 50, panel 1. It's juror number 29. Yes. Yeah, I'm going to do 1, 2, 4, and 15 from panel 2 if you want to bring them in there. Okay. Good afternoon.
Hello.
How are you?
Good. How are you?
Good, thanks. I know it's been a long afternoon for you. Got a few questions for you, all right?
Okay.
Just tell me the truth. Don't worry about, there are no right or wrong answers. We're not grading jurors on their answers, okay? We just need to know what you actually know and think.
Okay.
You indicated you knew something about this case. Is that correct?
Correct, yes.
Where did you get your information?
It was the local news.
Okay, do you always watch one channel or another?
It varies. Usually it's, I don't know the name of WESH.
Can you move the mic a little closer to you?
Yeah, it's usually WESH or I think the CBS, I can't remember.
Okay. And how much coverage did you watch?
Oh, I didn't sit and watch, but it was on the nightly news, the general updates I've seen and heard.
Okay. Were family or friends or coworkers or anyone talking about, this is before you came for jury duty, is what all my questions are about. Were they all talking about this case?
Are you talking about in there?
No. Before you all came to jury duty, did your family and friends and coworkers, did they talk about the case with you or in front of you?
No.
No? Did you form an opinion as to whether you think Mr. Loyd is guilty or based on what you heard?
Yes. I mean,
and what's the opinion?
Guilt.
Okay. Jurors have to come into jury to sit as a jury, presuming someone is innocent until and if the state can prove that they're guilty. Do you believe you can put aside your feelings and do that, or are you pretty much?
I mean, I would put aside my feelings if I
You
was
would what?
I would put aside my feelings if I was
Okay.
on a jury based on whatever information I'm given.
Do you think you could do that?
I would say yes. I mean, I don't know the complete details of everything.
Right.
But yes.
All right, so I'm going to give you a few scenarios. You tell me if any of them apply to you. And
Okay.
if they don't, just tell me that, okay?
Okay.
Scenario number one, you're sworn in as a juror and you think, he's innocent. I'm just sitting here waiting to see if the state can prove he's guilty beyond a reasonable doubt. Scenario number two, you're sitting there as a juror and you're thinking, yeah, I think this guy's probably guilty, but I'm willing to listen to see if he's not. And scenario number three, I think he's guilty, but if he can convince me otherwise, I'll vote not guilty. Do any of those three apply to you?
Yes.
Which one?
2 and 3.
2 and 3?
Yeah.
Okay, thank you, ma'am.
You're welcome.
State?
No objection, Your Honor.
Defense? All right, thank you, ma'am. I don't think this is the case for you. We really appreciate your willingness to serve. You are free to go. The mask is a gift.
Okay, thank you.
Thanks. All right, I'm now switching to panel 2. Juror number 1 from panel 2. This is panel 2. Good afternoon, sir. How are you? All right, sir, I'm going to ask you some questions. Just tell me the truth. Not grading your answers. There's no right or wrong answer. It's just what you honestly believe and feel. All right. You indicated that you knew something about, and just to confirm, your juror number is 199, correct? All right. You heard something about this case. Is that correct?
Yes.
And what did you hear?
When it happened,
You got to keep the mic close to your mouth. Sorry. I need you to speak up a little bit. I'm having trouble hearing you.
I've seen the news involved.
All right, so you watched TV, you saw the newspapers. Did you pretty much keep up with what's going on, or you just kind of watched it every once in a while? Okay. Since this originally happened, have you seen a lot of coverage about it?
Point, and after that,
Okay. So based on what you saw on the news, did you form an opinion about whether or not Mr. Loyd is guilty?
yeah,
Okay. So to be a juror in a case, you have to presume someone is innocent. That's what the law requires. And sometimes people can do it, and sometimes they can't. So in this case, do you believe that you could presume he was innocent, or would you be sitting there thinking, I think this guy's guilty?
like in
I'm sorry, I'm really having trouble hearing you. What?
and that
Okay, so you think you would stick to your opinion that he's guilty? All right, thank you, sir. State?
No objection, Your Honor.
Defense? No objection. All right, sir, thank you for your honesty. I don't believe this is the case for you, so I'm going to discharge you as a juror. Thank you very much for your service. You're free to go, and you can keep that mask.
Thank you.
Thanks. Seat number 2, panel number 2, juror 4047. Good afternoon, sir.
Good afternoon, Judge.
All right. I'm going to ask you a few questions. All I need you to do is tell me the truth. Don't worry about, we're not grading your answers. There's no right or wrong answer to this. It's just whatever you actually feel or think, all right? You indicated that you knew something about this case and that you'd heard about it. Where did you hear about it?
Mostly on the news, media.
All right. And how long ago was it that you heard about it?
When it first broke out, back in when it all started.
Did you see anything after that?
Just after the case, and then once COVID broke, I think it just like faded away.
Yeah. COVID was a rather overwhelming event. And you also indicated you formed an opinion about Mr. Loyd's guilt as a result of watching all of that. Is that correct?
Yes, Your Honor.
And what was your opinion?
I believe that he's guilty.
Okay. To sit as a juror in a case, in any case, you have to be able to presume the defendant to be innocent until and if the state proves they're guilty beyond a reasonable doubt. Do you believe you could do that in this case, or would you start thinking he's guilty?
I still think that he's guilty.
All right. Thank you, sir. State?
No objection, Your Honor.
Defense? All right, sir, I don't think this is the case for you. We appreciate your willingness to serve. You're excused from this case, and as a juror, you can keep that uncomfortable mask.
Thank you, Your Honor.
Thank you. Have a good day. Juror in seat number 4, panel 2, juror 469. Good afternoon, sir. How are you?
All right.
You're the gentleman that's planning the staycation.
Yeah.
Okay.
Yeah.
Well, let me ask you a few questions. No right or wrong answer. Just tell me what you think, all right? You said you knew a lot about this case. Is that correct?
Yes, ma'am.
How do you know about the case?
Oh, I remember pretty much when it happened. I seen it on the news and everything, you know. I just followed it on the news.
Okay. Did you follow it pretty closely?
A little bit, yeah.
All right. And after it first happened, did you continue to follow news stories about it or read stuff about it, anything like that?
No, I just watched it when it came up, you know.
Okay. So if it came up on the news, you watched it?
Yes, ma'am.
Are you a regular local news watcher?
Yes, I am.
All right. As a result of that, you said you'd formed an opinion as to whether or not Mr. Loyd was guilty. Is that correct?
Yes.
What is your opinion, sir?
Guilty.
Okay. To sit as a juror, you have to be able to presume that he's innocent until the state proves he's guilty beyond a reasonable doubt. Do you think you could do that?
I think he's guilty now.
All right. Thank you very much, sir. State?
No objection.
Defense? All right, sir. We appreciate your service. You are free to go. You're excused as a juror in this case. Juror number in seat number 15, panel number 2, and it's juror 255. Good afternoon, sir.
Good afternoon.
All right, sir, just a few questions for you. Just answer them honestly. No right or wrong answers to this. You said that you knew a lot about this case. Is that correct?
Not a lot, but I followed it since it was unfolding in the news.
Okay. So you followed it from the beginning?
Yes, ma'am.
And after Mr. Loyd was arrested, did you continue to follow news stories on it?
Kind of fell off the radar for a little bit, but I followed the trial.
The first trial?
Yeah.
Okay. As a result of all of that, did you form an opinion as to whether or not Mr. Loyd is guilty?
Yes, ma'am.
And what is that opinion?
That he's guilty.
Jurors are required to be able to presume a defendant is innocent until the state proves they're guilty beyond a reasonable doubt. Do you think you could do that, or would you consider him guilty?
I think I would have biases towards that, the
Okay.
guilty verdict.
So would you be more in the camp of, I think he's guilty, but I'll listen to see if I'm wrong?
I'll listen, but I'll probably come up with the same conclusion.
All right, thank you, sir. State?
No objection.
Defense? All right, sir, thank you very much for your honesty and your willingness to serve. You are, this isn't the case for you. You're discharged as a juror in this case. You are free to go.
Oh, okay.
And the mask is yet another gift to you that you probably don't want.
Thank you.
Thanks. All right. Going back to panel number 1, the only other juror who indicated he knew something about the case was in seat 57. It's a she, it's juror number 215, so let's talk to her first, please. No, I'm wrong about that. There's like 3 of them, but I'm going to start with 57. Go ahead. Good afternoon, ma'am. How are you?
I'm doing okay.
All right, I have a few questions for you. Just tell me what you think. There are no right or wrong answers to this. Just try and have a conversation with you, all right? First of all, you indicated that you had heard about this case. Is that correct?
Yes.
How did you hear about the case?
Back when, years ago, it was everywhere, all over the news. So everybody was talking about it.
Okay. And you said everybody was talking about it. Were friends and family,
Yes.
co-workers?
Yes.
Everybody you knew was talking about
Yes.
this? All right. Did you know anyone that was involved in the case?
No, ma'am.
After that initial, he was arrested, did you continue watching stories about it?
Yes, because it was all over the news.
Okay. So throughout the years since, it was 2017, from then until now, have you pretty regularly watched stories on this case?
No.
No? When do you think's the last time you saw anything?
I think that when the last trial happened.
Okay, did you watch the last trial or follow it?
I watched some of it, yes.
Okay. Based on all that, ma'am, have you formed an opinion as to whether or not Mr. Loyd is guilty?
In this case?
Yes, ma'am.
No, ma'am.
Okay. Do you have any inclination one way or another?
No, not unless I hear everything that happened.
In order to sit as a jury and as a juror in this case, you would have to presume that Mr. Loyd is not guilty and that he's innocent until and if the state proves he's guilty beyond a reasonable doubt. Can you do that?
Yes.
All right. Let me talk to you a little bit about the death penalty. Do you have thoughts and position on the death penalty?
I don't think I have either way. It just depends on the circumstances, I think.
Okay. So are you someone who has any moral, political, or religious objections to the death penalty?
No, ma'am.
Do you have, are you someone who believes that at any time someone is convicted of first-degree murder, they should be sentenced to death?
No, ma'am.
In this case, if you're seated as a juror, and if Mr. Loyd was convicted of first-degree murder, you would then go into what I call the penalty phase. State's going to present aggravators, reasons they believe he should be sentenced to death. Defense presents mitigation, reasons they believe he should be sentenced to life. You go back in the jury, I give you the jury instructions after all the evidence is presented. You go back in the jury room with your fellow jurors and you all weigh these aggravators and mitigators. And in the end, you have to make an individual decision as to whether life without parole is the appropriate sentence or death. If the evidence led you and the facts and everything you'd heard in the case led you to believe that life was the appropriate sentence without parole, would you vote for that?
Yes.
And if it led you to believe that death was the appropriate sentence, would you vote for that?
Yes.
All right. As I told you all, Mr. Loyd has raised a defense of insanity. Could you listen to that with an open mind?
Yes, ma'am.
And not make up your mind until you've heard all the evidence about it?
Yes.
And if you thought the evidence was established that he was insane at the time, could you find him not guilty by reason of insanity?
Yes.
All right, and lastly, as I told you, the conviction on Ms. Dixon's case can't be used by you to determine he's guilty of this case. You understand that?
Yes.
I'll explain later on, if you're seated as a juror, what that evidence is being offered to prove. Can you do that? Can you put that aside and not use that to determine guilt?
Yes, ma'am.
Do you have any doubts in your mind about your ability to sit on this jury and be fair and impartial to both sides?
No, ma'am.
All right, thank you, ma'am. I'm going to turn this over to the lawyers. Mr. Williams, you may inquire.
Yes, Your Honor. Good afternoon.
Good afternoon.
So I want to start by asking you some questions about you having watched the first trial. Did you actually watch the closing arguments on TV or something?
I only watched some of it because during working hours.
Right, because you got things to do. Yes, ma'am. Were you aware of the verdict prior to the judge telling you here today?
Yes.
That he was convicted?
Yes.
Do you know whether or not the state sought the death penalty in the first case?
I don't.
You don't? Okay. So you told Judge Marquez that you didn't really have an opinion on the death penalty one way or the other. Did I hear you say that correctly?
Yes.
All right. I feel like we just threw a bunch of law books at all of you sitting over there with all the information we just gave you. Did you hear the judge provide an explanation of sort of the process of how this will go through?
Yes.
Did you feel like you have an understanding of that?
Yes.
The reason I'm asking is I'm not going to go through it all again if you feel like you have your arms around it.
Yes.
Okay. So, but I do want to ask, have you ever heard of, as somebody who watches the news, a case or a set of circumstances where you thought to yourself, that the crime, that person deserves a death penalty? Like,
I have.
You have?
Mhm.
Okay. Can you tell me about that circumstance, please?
It was on court TV years ago where children were killed.
Children?
So, yes.
Okay. Was it more than one child?
Yes.
All right. And that's, as you can imagine, a very common response. People are sensitive about kids.
Yes.
Do you have any kids?
I don't.
You do not? Okay. And I saw that you said you didn't have any under 18, but I wanted to make sure.
No, I don't.
Okay. But nonetheless, somebody hurting a child, that personally offends you. Is that a fair statement?
Yes, because I have 13 nieces and nephews that I love with everything in me.
Say that again, please.
I have 13 nieces and nephews that I love with everything in me.
Okay, so no children of your own, but you're certainly no stranger to kids.
Right.
Understood. Okay. Well, this case doesn't involve children, right? And I want to make sure I understand what I heard you say is that even though you may have had an opinion on the defendant's guilt in the first case, you have no opinion in this case.
Right.
And so you understand there's a difference between this case where it's alleged that Lieutenant Clayton has been murdered versus the past case.
Yes.
Can you separate those two things, compartmentalize them in your mind, and make a decision based only on what you hear in this case?
Yes.
All right. Would you, on a scale of 1 to 10, how much would you want to be a juror in this case?
I don't want to be.
You don't want to be?
I don't.
So it's a 1 for you?
A 1.
Okay. Can you tell me why that is?
I just don't want to be. I just don't want to be here.
Because of the nature of the decision, or you have other things to do? Or?
I have other things to do, honestly.
All right. Do you think that you would be able, given that you don't want to be here, to give us your full attention over the course of 3 weeks?
I will.
You will. All right. So you don't want to be here, but if you have to, you'll be all in. Is that a fair
It's my
statement?
duty.
It's your duty. Okay. Thank you for telling us that. One of the things that the judge described is that if and only if Mr. Loyd is convicted of first-degree murder, then we'll present evidence of aggravating factors. And those are things just like they sound, things that about the way a crime was committed or the nature of the victim that make that crime eligible for the death penalty when other first-degree murders may not be. Did you hear her say that?
Yes.
All right. Other than the child, well, let me back up. Even if it's the murder of a child or multiple children, that crime is not automatically eligible.
Yes.
There are certain things that have to be proven and found and weighed before we get there. I think you understand.
Yes.
All right. So my question for you is, you've been told that this is the murder of a law enforcement officer. Does anything about the nature of the law enforcement officer aspect of this crime present a particular issue for you?
No.
You don't have any members of your family that are in law enforcement or friends or loved ones or anything like that?
No.
Okay. Well, I'm assuming you respect law enforcement?
I do.
You do. But that in and of itself wouldn't prevent you from being fair and impartial?
No.
Okay. Even in a case where, let's just say, hypothetically, children were killed, any criminal defendant, including Mr. Loyd, has the right for jurors to listen to those mitigating circumstances. And those are things about his character, background, or life, anything in his life, that the defense will present to you if they choose, and you'll need to give meaningful consideration to. You don't have to agree with it. You don't have to find that it's mitigating, but you do have to meaningfully consider it before you make a decision. Do you think you could do that?
Yes.
Right. Okay. Now, the other topic that was raised or broached was the issue of insanity. Without being too personal, if you can answer this, have either you or someone close to you had a mental health issue, a significant one, that affected their life in some way?
No.
No, so that's never been something you've encountered?
No.
All right. I'm assuming you mentioned Court TV earlier, that you've probably heard of the defense of insanity before. Right. So when you hear that somebody is claiming that they were insane at the time of the crime, and therefore that they should not be held responsible, you understand that that's what that means?
Yes.
Okay. What are your thoughts when you hear that?
Most of the time, I just think it's a defense.
Okay. And by just a defense, what do you mean?
I don't think they are insane.
Okay. So when you hear that somebody says that they're insane, am I accurately restating it that you're skeptical?
Yes.
Okay. And why is that?
Because they don't want to go to, I feel like they don't want to go to jail. And if it's a defense they can use.
Okay. And I'm picking that up from you. I just want to make sure that I understand what you're saying. Do you believe that there are legitimately people with mental illness issues in this world? Do you believe it's possible that a person could be so mentally ill that they didn't know what they were doing or that it was wrong? In other words, you do believe that some people are insane legally. Given that you are skeptical of that defense, could you assure us that you would still be able to listen to the evidence on that fact, on those factors, and fairly and meaningfully consider it before reaching a decision on that topic? Yes. Okay. Any concern about that at all? Last question, and you sort of alluded to it, like you told us that you had 13 nieces and nephews. That's not something I would ever know about you unless you told me, right? Is there anything in your life or background that you think we should know about, given that we as a group are trying to select the most fair and impartial jury for this person to get a fair shake in our system? Usually, if there's something out there, it pops in your mind, and I'll give you an example. Some people say, you know what, my best friend was murdered 20 years ago, or I had a loved one who was killed or the victim of a crime. Anything like that that you can think of?
Oh, yes.
Can you tell me about that?
I have two loved ones that was victims of murder from domestic violence, yes.
Okay, you had two loved ones that were murdered?
Yeah.
All right. And I'm sorry, but I'm going to have to ask you, okay? How long ago was that?
DG was years ago, probably in 1992 or 93. And Jasmine was not so long ago, maybe about 4 years ago.
So 4 years ago would have been not too much before, or right around the time this happened?
Yeah.
No,
it was, I can't even remember. I don't know, you might even remember Jasmine Samuels. I don't even think her murderer's been in trial yet.
You don't think the case has gone to trial yet?
No.
Okay, is that here in Orange County?
Yes.
Forgive me for not knowing. I apologize. Again, I'm sorry to have to ask you, but were you close to these two individuals?
They were family. We weren't super close, but they were family members.
Did you say DJ was the first one?
DG.
DG, okay, and that was about?
About 92, 93.
Who was that person to you?
She was a cousin.
The facts surrounding his death? In other words, do you know how he died? It was a female, I'm sorry. Do you know how she died? And how do you know that?
Boyfriend killed her.
Okay. Did you read police reports, or did you see it, or did someone tell you that?
Oh.
You were told. Okay. Given the nature of that, and that you know that Mr. Loyd has been convicted of killing his girlfriend in the past, do you think you could still be a fair and impartial juror for Mr. Loyd?
Yes.
So you could set us, go ahead.
Yes, because it wasn't the same circumstances.
Okay. I understand that, but you realize why I have to ask. The second circumstance, that was also a female? All right. Was that a boyfriend-girlfriend thing?
Yes.
Right. And so is it alleged that that male killed your, and who was she to you? DG. Oh, so I see. I think I know the individual that you're speaking about now. Yes, ma'am. Anything about that situation with DG's daughter prevent you from being fair?
No.
It's very important, and like the judge said, there's no wrong answer for you to look deep inside yourself, because you're the only one who can, that you can set aside those two set of circumstances. Can you do that for us?
Yes.
All right. And I know you're being honest because you don't want to be here, right? So,
I don't. I really don't.
Okay. Last question, okay? Or it's two questions, I'll be fair. Let's say you go through this whole process and you find that we haven't proven the aggravators beyond a reasonable doubt, or that the mitigation you hear about Mr. Loyd's life is really meaningful and important, and that you think life is the appropriate sentence for him. Could you go back to the jury room and raise your hand and vote for a verdict of life without possibility of parole?
Yes.
Conversely, if you believe that you've proven at least one aggravating factor and that a sentence of death is appropriate in your mind, could you raise your hand, not in a hypothetical sense, but in a very real sense, to vote to impose a sentence of death on another human being?
Yes.
Okay. Did I miss anything? Okay. Thank you very much, ma'am. Thank you.
Mr. Williams. Mr. Lenneman, you may inquire.
Good afternoon, ma'am. How are you? Now, I heard your response.
Yeah.
In terms of the law, is very clear that you are
okay.
The way that happens is you would listen to all the evidence in the first part of the case, assuming that Mr. Loyd is found guilty. You go to the second part of the case, and at the end of the presentation, you begin to set instruction of the law. And what that requires is all the jurors first. First thing all the jurors have to do is find that there was at least one aggravating factor that was proven beyond a reasonable doubt. Okay? That's the only thing that the jury complete. Everything else is independent decision. So, in other words, the next step is you have to decide what aggravators is proven beyond a reasonable doubt. And then you give them the way to the jury. And then the mitigators that will present the proven to a lesser standard, you have to decide if it's proven, and once you do, that you give the weight to each and every one of those, the way you decide. You can give one very big weight, another a small, you can add them all up. And at the end, you weigh the aggravators against the mitigators. Understand? So, once you weigh the aggravators and mitigators, you make the mitigation over their decision-making process if they're independent. Okay? You can do that? I have nothing further.
Either side need to approach?
No.
No, Your Honor.
All right, ma'am. We're going to bring you back for the last day of questioning, okay? And that means we're going to give you a packet, and you're now a purple dot. So if you'll take your badge and hand it to Ms. Teresa here, she's going to give you a purple dot. We're giving you a sequestration package because if you're picked for the jury, you would be sequestered. We need you to pack, when you show up the next time, we need you to have packed the night before. Leave your suitcase in your car. You won't need it unless you get picked as a juror. We don't know when that's going to be, but I can tell you it won't be before next week. So what you're going to do is we're also giving you in the packet a slip of paper that's got a phone number that you can call. Don't even bother calling until Thursday. Then just call every day. When you hear a purple dots report on such and such a date, that's you, okay? And the packet explains to you what to expect as a sequestered jury. Again, this is all in case you get picked for the jury. Do you have any questions? All right, thank you, ma'am. You are free to go. Juror in seat 38, juror number 30, panel 1. Good afternoon, sir.
Good afternoon.
Sir, are there any issues with your job?
No, not with my job. I did have a chance to take a look at my calendar. I'm officiating a wedding on the 23rd. It's a Saturday,
Okay,
6 p.m. And I've got my second COVID shot on the 28th of this month,
okay,
and that's it.
that's it. Those are the two things that you have. If you weren't there at the wedding, is there someone else who can officiate?
Could ask around, I guess.
Are these friends of yours, family,
Yes, friends.
friends? Okay. And how long have they been planning their wedding?
I'm not sure.
Okay. Have you heard anything about this case?
When I got home on Friday, I saw some of the news stories on my news feed, and it jogged some memories of a case maybe 4 or 5 years ago. I'm not sure how far back it was.
Did you read the stories on your news feed? Because you weren't supposed to read anything.
No, it was just on my news feed.
So what did it jog?
Just a memory of a young woman who was pregnant that was shot and killed.
Yep. So based on that, have you formed any opinions about Mr. Loyd being guilty?
No, ma'am.
I'm sorry?
No, ma'am.
Do you think you could, as I told you, he was convicted of the murder of Sade Dixon and her unborn child, and he was sentenced to life, but you can't use that to determine whether or not he's guilty of these charges. That information is being provided for a different reason, that if you're on the jury, we would tell you what it is. Do you think you could put that aside? Because you cannot use it to determine if he's guilty.
Yes, I can put it aside. It's understood.
All right. Tell me what your feelings or thoughts are about the death penalty, please.
Personally,
Yes, sir.
yeah, personally, I'm not an advocate of it.
Okay.
I've never been in a situation where I've had to exercise my personal beliefs.
All right. So do you have a religious or moral objection to the death penalty?
No.
No. In a case like this, if Mr. Loyd was convicted of first-degree murder, then you would have to make a decision between life without the possibility of parole or death. And that's the penalty phase. You know, the state's going to present aggravators. They're going to present evidence of aggravators, reasons they believe death is appropriate. Defense is going to present evidence of mitigation, reasons they believe life without parole is appropriate. I give you the jury instructions, and you and your fellow jurors retire to that jury room to talk about it. You're going to weigh the aggravators and the mitigators, and then you have to make a personal decision as to whether you believe the appropriate sentence is life or death. If at the end of this whole process, you had all the evidence, all the facts, everything has been given to you, and you believe that all of that led you to a life sentence without the possibility of parole, would you have any problems voting for that?
I would have no problems voting for that.
All right. If it led you to believe that the appropriate sentence was death, would you be able to vote for that?
I would be able to vote for that.
Okay. Do you have any concerns about your ability to vote for that?
No, ma'am.
The defense of insanity, as I told you, has been raised. I read you a little bit of the instruction on that. Can you listen to any evidence that's presented on that issue with an open mind?
Yes, ma'am.
And if you felt that the evidence established, by clear and convincing evidence that Mr. Loyd was insane at the time of the offense, would you be able to find him not guilty by reason of insanity?
Yes, ma'am.
I think I probably already asked you this, but forgive me, I've been doing this all day long. So remember I told you can't use the murder of Miss Dixon and her unborn child to determine guilt, and you're fine with that. You can put that aside? You told me that, right, didn't you? Yeah.
Yes, ma'am, I answered that.
Okay. Is there anything right now that would cause you to believe that you would not be able to sit as a juror in this case and be fair and impartial to both sides?
No, ma'am.
All right, thank you, sir. I'm going to turn this over to the state. Mr. Williams, you may inquire.
But I do not personally support the death penalty.
Okay. So can you tell me why it is that you don't personally support it? I'm not assuming that you should. I just want to know what your opinion is. As to why.
It's hard for me as a single individual to feel like I could cast judgment on someone whether they live or die.
Okay. As a single individual, meaning one person having that sort of authority over someone else's life?
Correct.
Have you ever heard of a situation, whether it be in the media or from a friend or from any source whatsoever, where a person committed a crime or an act that when you heard about it in your mind, you thought that that person should die, legally or otherwise? Have you ever heard of a situation like that? And it's okay if you have.
Yeah, sure. I've watched plenty of World War I and World War II documentaries. We've heard about all kinds of rotten stuff going on in this world. Okay.
So you brought up World War II. You're talking about things maybe like genocide.
Sure.
Right? So you can, if I'm wrong, correct me, okay? But what I hear you saying is you can imagine if a person murdered hundreds, thousands of people, that it might be appropriate for that person to be sentenced to death.
Yes.
All right. Short of genocide, and I'll be more specific, like the killing of one person, can you imagine a scenario in your mind where you think that the way that the murder was committed or maybe the nature of the victim might warrant a sentence of death?
Yes, I can imagine that.
Okay, can you tell me which situation you're thinking about? Or a specific one that you can...
I'm not thinking of any specific situation. You asked if I could imagine one.
I did, to be fair. Okay. Is there any, slightly different question, is there any situation where you think the nature of the crime would, in your mind, almost automatically lead you to want to impose or vote to impose a sentence of death? Let me give you an example. Some people, particularly those who have children, say to themselves, if you murder a small